expired on 23rd of December.
Hmm.
My lord, I am asking for 1 week extension. My lord, I am mentioning upon notice.
I am for the defendant number 1.
My lord, subject to your
The
lordship.
commercial or non-commercial?
Subject to your lordship's pleasure, my lord, we have agreed that opposition by 15th of January, reply by 22nd of January, and let the matter appear on 29th of January. My lord, this is the last order of your lordship, my lord. Matter is due on 13th.
Okay, let it come on 13.
Lordship.
In the meantime, you prepare it. We'll see to that.
My lord, three non-contentious probate matter, my lord, may I mention for enlistment?
My lord, may I be permitted to mention, my lord, one commercial matter, my lord, wherein I am representing the defendant, my lord, the initial 30 days period has over. My lord, I am seeking leave to file my written statement within 120 days time. I have also taken out an application
What is
for
the date? When?
Lord, I am
9.
giving for the plaintiff, my lord. Tomorrow is the 120 days is expiring tomorrow.
So today the 119th day. Affirmed.
affirmed on 6th January, my lord. I have also taken out an extension application.
Well, affirmed it is.
Affirmed.
Yeah. The defendant is allowed to file the written statement in the department subject to acceptance by this court, not scrutiny.
Much
Lordship.
May I have a lordship, sir?
Today.
Kind leave to mention a matter.
and also
Subject to
Sure.
acceptance and
Lordship kindly allows me.
subject to acceptance in course of the day.
in course of-
File in course of the day subject to acceptance.
Lordship, I am
Much
mentioning a non-contentious probate matter, Lordship.
My lord, may I be
May I have your lordship's kind leave to mention a matter. Your lordship, I am appearing virtual if your lordship kindly allows me. Item number 40 is a non-commercial matter application to file written statement. Your lordship, that has been filed with the department subject to your leave granted by your lordship. But the department is not keeping the written statement on record. In view of no order being passed, your lordship, they are only requesting for an order. GA6 is the application item number 40. If your lordship takes it up any day or
Is it-
tomorrow,
This is a non-commercial.
Your lordship, monthly list.
only formal order has to be passed.
No, what formal order?
Your
Formal order with regard to the allowing of the filing of the written statement. Your lordship has already granted me leave. I have filed it with the department. Department is only asking for it. There's a formal order. Kindly obtain a formal order from the court so that we can keep it with the file.
You have not taken the leave.
We had obtained
Where is
the
the written
leave.
statement?
Yes, we have obtained the leave. But it
Obtaining the
is the
leave, we had
department who is
filed
creating the
with the
problem.
department.
That in the written statement it was recorded by my court officer.
Yes, your lordship. Yes, your
You're
lordship.
not
Yes,
They have. It
yes,
has
the department
filed,
is creating the problem.
it is not taken on record since there is no
It will
formal
not
order.
be taken on record. Only it will be in the department unless it is accepted.
Yes, your
I
lordship.
have ordered, I have directed the department, unless it has been accepted, it will not be taken on record. Only it will be in the department so that you can say it has been filed.
Yes, your lordship.
If
Which
your
is
lordship only hears out the application GS6
mentioning this application
Let it be
only be to be taken up any day convenient to your lordship.
any day, your lordship.
Any day convenient to. That's the only reason we are
Item
mentioning.
number 40, your lordship.
Because it's
Item number 40.
it's a written state.
Monthly.
It's a written statement in a partition suit, your
Daily-
lordship.
Come on the daily list.
Grateful, your lordship.
Great.
listed matter running in the monthly list, my lord, probate matter, my lord, one for final hearing, one for citation. my
It is online listed, na?
lord. My
So
lord,
why you wanted to mention?
monthly list, my lord,
Ah.
is one for final hearing, my lord, all every
Take.
non-contest.
My lord, let it be permitted to mention for inclusion of non-contentious probate.
You give whatever the PLA matter,
Lordship,
give the numbers to my court officer.
Grateful, Lordship.
Give to my court officer.
Lordship, PLA matter.
Lordship, as per your Lordship's order dated 10 December, Lordship, there was a direction upon the defendant number 1 to file a demand draft of rupees 22 lakhs within 6th of January, Lordship. But the defendant number 1 stays in Delhi. We have only received it yesterday. I'm only praying for leave to file the same within the course of the day. I'm carrying the order and I'm also mentioning upon notice.
Appearing for the petitioner, my lord. Penultimate paragraph.
22, 47, 38 with the register ordinance of this court on or before 6th of January. Received by the register. Then what is happened? You are not deposited.
No, Lordship.
Why?
We have only received it yesterday, Lordship. Today we are standing on 8th, Lordship. The defendant stays in Delhi.
Leave granted, though. Leave is granted to accept the Demand of in course of the date.
Lordship, with regard to the same matter, Lordship, there is we have already filed our application for acceptance of written statement, and on that day we were standing on a 78 delay, 78 days delay.
The
Today,
commercial matter.
yes, Lordship.
Then
Today we are standing on 90 days delay, Lordship. The application is due to come on.
whether your return statement is ready.
Yes, it is ready and it is affirmed, Lordship. I'm only praying for
When you
has
receive the
been
return writ of summons.
23rd September, my lord.
So today is
20. I'm not sure. Please, Tara, help me.
No, for application election. You've written any application for extension.
is within 120 days.
Yes, Lordship. It is within 120 days.
Give.
Let a copy be served up.
Yes, Lordship. We shall.
No, that is acceptance after acceptance. The defendant is liberty to file the return statement in course of the day in the department, subject to acceptance by this court.
Grateful, Lordship.
Yes, next.
Here's a non-commercial list, to be mentioned item number 1.
My lord, this matter appeared in the list at my lord's order, my lord, by order dated 5th of December 2024. My lord, this is with regard to my lord sale of an endowment property. My lord, your lordship is directed for paper publication, my lord. My lord, only one thing, my lord, my prayer for extension of time for paper publication, my lord. This could not be done, my lord, due to some problem of my client, my lord. 4 weeks extension I am praying for. But this is the order passed by your lordship.
So and so appearing for the petitioner. The plaintiff counsel for the plaintiff submitted by an order dated 5th of December 2024. This court allowed the petitioner to publish the notice for sale of the property in question in the English, Hindi, and Bengali newspaper within a week. Within what is the time period?
My lord, there is no time mentioned in the.
Then why you wanted to
Because my lord, the returnable date is today, my lord.
Okay, publish the notice in the English Bengali for sale of the Bengali newspaper. No, within a criterion. Full stop. Counsel for the plaintiff submitted the publication could not, due to some unavoidable circumstances, the publication could not be made, and prayed for extension of time. Extension of time to publish the notice in terms of the order dated 5th of December 2024. Concerning submission made by the counsel for the plaintiff, time to publish the notice for sale as directed in the as directed by an order dated 5th December 2020 is extended for a further period of 2 weeks from date.
My lord, 4 weeks, your lordship,
6 weeks from date. 6 weeks, let the matter appear in combined monthly list of June 2025.
My lord, your lordship, my lord,
Go.
My lord,
Next
three
call.
newspaper. Grateful, my lord.
Item number 2, my lord, I beg to appeal for the plaintiff.
For the defendant lordship led by Mr. Swarup Banerjee.
My lord, what has happened, my lord, in this suit, my lord, after the written statement has been filed, my lord, we have filed we served a letter upon the defendant asking them to disclose what documents they are relying upon. And in that regard, when they reply, they also sought for documents on which we are relying. We have handed them a copy of the documents along with we have given an inspection because there was a letter to that effect. We have given the inspection, they have also given us an inspection. We have exchanged letters stating we have taken the inspection. Now we are only intending to file. These are the copies of the. These are the copy of the letters and the acknowledgements. We are seeking to file an affidavit of documents. But in that regard, on which we are relying.
Where is the written statement?
The statement should be on record, my lord.
My lord, I'm praying for extension of time to file our affidavit of documents, my lord.
You are appearing for?
For defendants.
You have filed the written statement?
Yes.
Yes, my lord. They have filed. It has been served within time.
Within
then,
time.
Discovery completed?
The discovery is complete.
Yes.
Discovery inspection completed.
Yes.
So what do you want?
Lord, I only filing the
My lord,
documents.
I am praying for extension of time for filing our affidavit of documents, my lord. 1 week's time may be granted, lordship. They have served us.
What has happened, the documents which we are relying on, they are also relying on the same documents.
Hmm.
There is no dispute in regard to the facts.
Hmm.
There is only dispute in regard to the understanding of the law. What's happening? This is a partition suit.
Hmm.
As I said, the partition suit on the basis of a document, there was a plan, there was a will which was probated by this honorable court.
Hmm.
In the will, there was a plan.
Hmm.
On the basis of that plan, there was a demarcation. This property will go to A, this property will go to B in lots, my lord.
Hmm.
We are enjoying an order of injunction
Hmm.
on that. Will pass by this honorable court.
Hmm.
My lord,
So what you want now?
nothing will only the every document.
My lord, I am praying for extension of time for filing affidavit of documents by the defendants.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Counsel for the plaintiff has filed affidavit of document. Counsel for the respective parties submit that discovery and inspection of the documents have been completed. Full stop. Counsel for the plaintiff has filed affidavit of document. Let the same be kept with the record. Counsel for the defendant prays for a week time to file affidavit of document. Let affidavit of document be filed by the defendant within a week from date. In the meantime, the parties are also directed to exchange their suggested issues.
Suggestion is already served upon him.
I will also
I can file it in the court today.
Let the matter appear on. Let the matter appear on 22nd of January 2025 for framing of issues.
framing of issue. My lord, much obliged.
Yes, next.
Grateful, my lord.
My lord, in this matter, appear for the plaintiff, my lord.
Hmm.
Defendant had preferred appeal from a lordship order, my lord.
Hmm.
In the appeal, my lord, they have been granted 3 weeks time to secure the entire amount before the registrar original side, my lord.
Hmm.
3 weeks is ending on 23rd of this month, my lord.
Hmm.
I am praying lordship may kindly keep it up any day after that, so that if they do not deposit,
Hmm.
then your lordship may proceed for passing an order, my lord.
Hmm.
May I hand over the copy of the order, my lord?
There were two applications filed by my clients. Milord, one was Order 7, Rule 11, and another was Milord Leave to Defend. Now, my lord was pleased to dismiss both the applications, Milord. Now, Milord, we have filed an appeal, Milord, where Milord, the Honorable Division Bench was pleased to give us an opportunity to leave to defend. Upon payment of Milord, payment not Milord, I'm wrong on that. I'm securing Milord that amount of rupees 30 lakhs with the registrar. Now, Milord, the 3 weeks, Milord, is yet to expire. Milord keeps it in the monthly list of February.
My lord, may kindly keep it on 29. 23rd is the 3 weeks which is getting expired, my lord.
At 29th, I have some difficulty, keeps it in the monthly list.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that the defendant being agreed and dissatisfied with the order passed by this court dated 11 September 2024 had prepared an appeal before the appellate court being APOT number 346 of 2024. Accordingly, the Honorable Division Bench, Honorable Appellate Court, by an order dated 2nd January 2024, directed the defendant to secure an amount of rupees 30 lakhs with the registrar original side within 3 weeks from date. It is submitted that 3 weeks time will be completed on 23rd of
January, my lord.
January 2025. In view of the above, let the matter appear. Let the matter appear on non-commercial, na?
Non-commercial.
Let the matter appear on 6th of February 2020.
My lord, under the same heading, my lord.
But for orders.
For orders. I'm grateful, my lord.
Same heading. Good. Yes, next.
Milord, we
Yes.
moved, Milord. We were refused ad interim relief. Milord, then Milord, affidavit direction. Now respondents have given us 20 affidavits. And Milord,
20 affidavits.
23 defendants. 23 defendants. So
I appear
20
for-
affidavits.
I appear for the defendant number 1, my lord. I have already filed my affidavit in opposition on 14th of November.
So now what you want?
Milord,
All banks who have made a party.
very long extension, Milord.
Any bank left?
Maybe some non-nationalized banks.
My lord, I appear for the banks. My lord, all the affidavits are similar. My lord, we have filed, we have served advance copy.
Milord, my stenographer used to compare and then see. We should have a similar stenographer.
You made me mad. The 6 continuous GA, that Vedic land and
Oh.
My lord, they have filed the
Impossible.
Yes.
My lord, I filed the affidavit of service.
Okay. So you want to extension of
Correct,
time to
exactly,
reply.
At 3 weeks, my lord. 4 weeks, my lord, they are saying, my lord.
So all defendants file no. All defendants.
My lord,
all back.
defendant 2 to 20, 22 and 23, except for 21, my lord.
Except for one.
One,
My
my
lord,
lord,
one I have
You have filed.
already filed my affidavit now.
One is filed. Only except 21.
except
Yes.
21, my lord.
21 and 23 have not filed.
Who is appearing for the 21, 23? Nobody. National Agricultural
Nobody appears. Service.
NABARD and
My lord, for 23 has also been filed.
filed.
Sure.
Yes, yes.
Okay.
Except for 21.
Sorry,
my
my
lord.
lord.
So you are also appearing for the NABARD also.
Yes, my
So IFCI Limited, nobody is appearing. So and so is appearing for the plaintiff. So and so is appearing for the defendant number 1. And so is appearing for the defendant number 2 to 23, except 20.
My lord, may I make one? I'm sorry, my lord. I am not appearing for NABARD, not 23. For 2 to 20 and 22, my lord.
2 to 20, 2 to 20 and 22. None appears on behalf of the defendant number 21 and 23. Counsel for the plaintiff submitted. Defendants. The appearing defendants have filed their affidavit in opposition.
You're used to doing
Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed within 3 weeks.
4 weeks, my lord.
4 weeks. Within 4 weeks. Police staff, list the matter on. What about the suit? List the matter on 13th February 2025.
My lord, we have served. my lord.
13th February 2025. Great.
My lord,
ये कल के वो rejection order कौन आया नहीं आए नहीं
Lord, item 10, I
Yeah.
appear for the defendants, but
Hmm.
I seek an extension of time to file the affidavit in opposition. But the defendant number 1, there is a bereavement in his family. His 27-year-old cousin had suddenly passed away. So, my lord, the family is, my lord, he had to travel outside of Calcutta, my lord. So, my lord, this is that matter where your lordship would recollect, my lord, on the prayer of my learned senior friend, my lord. A special officer was appointed to take possession of all the documents of the society. That has been taken possession of and has been given. My lord, I and my junior had previously sat with my client to prepare the affidavit. We are almost through, but then because of this incident, he had to
So
leave
you are appearing for both defendants.
for the defendants. He had to leave Calcutta. My
Extension
lord,
of time to
10
affidavit.
days, my lord, kindly grant.
Yes.
may I, my lord, please. My lord, if your lordship recalls, my lord, this is in respect of a building in, my lord, Ho Chi Minh Sharoni. Our allegations were threefold. A, my lord, no elections. No, my lord, audit. Number B, my lord, is arbitrary demands made on me for 6 lakhs, 10 lakhs, and unless I pay my water, electricity, everything being cut off. Water, not electricity, my lord, my mistake. Number 3 is, my lord, complete autocracy in the building. And my lord, on the first day we said, my lord, that they said we've given notices for everything. And your lordship was pleased to say that make over the documents, all documents to the special officer so that you can't manufacture now. Now the documents have, my lord, come. This is, my lord, in September. From September, my lord, there is nothing filed. The documents are given after 3 weeks. Now, or 2 weeks.
No. Same day. যেদিনকে কোর্টে ডিরেক্ট
Oh, I'm sorry, my lord. I was given a wrong impression. there, my lord.
Not September, October.
October.
Fifth
Now on 21st December, 13th November was the order. Now on 21st December, we write to them and say that if you have you filed an affidavit, give me a copy. Nothing done. Today, my lord, we are in January. May I only request for this? The special officer has filed a report giving, my lord, particulars of a lot of documents which are in his possession. May I simply obtain a copy from the special officer?
But
Kindly see the
we are
report.
annexing that in the affidavit.
Maybe you
The
are.
entire thing, we are annexing that.
Maybe.
The report
my
which has
lord,
been filed,
Kindly see,
we
my
are
lord,
annexing everything.
page 2 to page 11 are documents which he has taken. Now the
But
most
I do not
important.
join issues.
Huh.
I do not join issues with them getting, because we are anyways annexing that.
Now, my lord,
So I do not join issues.
this is, my lord, all his documents. from the nomenclature of the document, it appears that whatever I had said, my lord, would at least 50% be found to be correct, because we were looking at the documents. We find, my lord, maybe AGM, there has been one allegation of one. They say that there are 600 pages of WhatsApp chats. I was added in the group in January, in 21, November 21. Now we haven't, we can't say that whatever, if everything would have been there on the group, then, my lord, I think we would have been silenced. But we, subject to correction, we find nothing is on the group. May I only request for this? May I take a copy of the documents from the special officer?
I think the special officer has already submitted here.
Yes, so may I take a copy, my lord, from how do I make a copy? My lord,
That is bunch of documents, that is not. Volumes, 4 volumes.
yes, my lord, if under supervision of my lord's officer, if I can make a photocopy for myself and one for my learned friend, and kindly keep it, my lord, on Friday.
No,
I will analyze and come back.
kindly do not keep it on Friday because he is out of station. He had
I'm
to
going
go
to
to his
play for
native
first.
How soon you will file the affidavit?
10 days time.
My lord, my lord, I'm
10 days time because I also need to sit with him personally and because he is
my lord,
the
see, no further documents can come.
no
my
no
lord.
no further documents on these documents because
So very
this
well,
much
so
bunch
let
of
me-
documents have been
You
discussed. So I
haven't
have to sit-
filed. I'll see the documents and make a prayer before your lordship for appointment of a receiver to take over, my lord, maintenance of the society.
Yes, he kindly permits my learned senior
He's
friend to
2
renew that
months
prayer.
out of time.
No,
November to January, if you can't file and you've given your documents, you can argue on
it's
those
extremely
documents.
voluminous. We have
So I
sat and
will
we have
also argue on those
started with
documents.
each and every document in the affidavit. We are almost through, but since he had to leave, my lord, so
So this is
this
just
entire
another
thing had
way of
got stalled.
pushing it back by 2 months. my lord.
Okay.
Yes, my lord.
Let you, this will be Xerox and you take, how, कैसा Xerox होगा? दोबारा कराना
But
पड़ेगा.
we will be anyways disclosing this in our affidavit.
Then they will
The entire bunch with the pagination followed
Or
by
my lord, if that means they have the document,
yes.
I'll take it from Mr. Upadhyay. Kindly give him 48 hours to photocopy and give me the documents. Then, my lord, I'll
Again, it will be difficult. You do one thing. कोई हमारा Xerox करवा देगा. My officer will get it Xerox, whatever the cost.
expenses we will, my lord, bear.
Pay that.
And kindly keep it after, my lord.
And let him under 10 days.
Yes.
I am fixing after 1 week. I am giving to him. How soon you will file?
My lord, I'll come. We won't even, my lord,
Today we
wait
are
for a reply. We'll argue on the document.
So today we are on 8. Okay, so 1 week 15.
And kindly gives us 10 days time, my lord.
Okay, by 17 you file.
10, yes.
In 17, then I am fixing on 22nd. 22nd.
And reply by 21st.
21st. So appearing for the plaintiff, so appearing for the defendant. Counsel for the defendant prays for action. Time to file affidavit in opposition. Let affidavit in opposition be filed by 17 January 2025, reply if any there to be filed by 21st of January 2025. List the matter on 22nd of January 2025 for hearing of GA1 of 2024.
Great.
Full stop. The counsel for the plaintiff submit that in terms of the order passed by this court, the special officer has collected the document and submitted before this court, and he prays for supply the copy of the said document.
Referring to page number.
We have the submission made by the counsel for the plaintiff. Full stop. This court find that the document submitted by the special officer contains how many volumes? 8 volumes. Accordingly, the said documents will be get it Xerox by the office, and the cost shall be bear by the plaintiff. Full stop. The office is directed to get the said document Xerox and to supply the same to the learned counsel for the plaintiff after acknowledgement, and the plaintiff shall pay the cost incurred for the Xerox of the same. How much time it will take? 2 days?
Only, my lord, on that day, my lord, it will
Well,
come as
only-
an adjourned motion.
Only one humble submission. In our copy, we have marked everything. So once we Xerox, that will also go. So kindly permits us leave to on the payment of cost to take a photocopy because in ours we have marked
So once
while preparing the.
So what you want?
So,
One copy to
so
us.
one copy to the defendant on defendant paying cost.
The office, let the Xerox copy of the document is supplied to both the parties or payment of cost by both the parties
Great.
in equal share.
Milord, it will come as an adjourned motion, Milord, if it could have some precedence in any form your lordship feels proper.
Fix on 22nd, na? Second at the top under the heading adjourn motion.
Great. Item number 11, I appeal for the defendant. I'm praying for a adjournment for this week, but I'm led by Mr. Shuddha Sattva Banerjee. My lord, he is unwell and he has almost lost his voice. My lord, suffering from cold. So, my lord, he had indicated to my learned senior friend also. My lord, if your lordship
Affidavit in
kindly takes it up
opposition?
Wednesday, my lord. We have
Affidavit
filed. We have filed.
Filed,
Reply?
filed, yes. No, today is Mr. Gupta's days to seek adjournment.
My lord. Otherwise, I do not. But normally, my lord, if I am. But the affidavit in
Only,
reply
only one,
was served beyond time, which we had accepted. It was served yesterday, my lord. So, my lord,
20th November, your lordship was pleased to pass an interim order, which is scheduled to expire on the 9th of this month. So kindly extend the interim order. And kindly record that, my lord, the parties have exchanged. Oh, Jesus, sorry, my lord.
Readings completed.
Completed.
it is
The boss has forgotten all the things of the Indian culture. Census and suffering for the plaintiff, census and suffering for the defendant. Full stop. The counsel for the respective parties submit that pleadings have been completed. The matter is ready for hearing in connection with GA1 of 2024. In view of the submission made by the counsel for the parties, let the matter appear on 29th or 29th January under the heading adjourn motion. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired on 9th of January 2025 and plead for extension of the interim order. In view of the circumstances above, the interim order granted earlier is extended till 5th of February 2025 or until further order whichever is available.
Grateful. Well, the reply affidavit to GA1 be kept on record.
Filed by the plaintiff be kept with the record. Next.
May it please your lordship, my lord, I appear for the plaintiff petitioner.
I appear for the
But
respondent.
I appear for some of the respondents.
My lord, they have served us.
Affidavit was not one day out of time opposition. I don't know whether my learned friend.
They have served us their affidavits in opposition, my lord, belatedly. My lord, we have accepted it. We have accepted it, my lord.
I appear for the mother, the respondent number 1.
But I was, my lord, only praying, my lord, for 2 weeks' time, my lord, to file my affidavit of reply, my lord. My lord, the interim order, my lord, continue. That is all.
I am for the FNO3, I filed my appeal. I have also served upon.
But I've also not handed over my affidavit at 2 minutes.
Census and suffering for the plaintiff. Census and suffering for the defendant number 1. Census and suffering for the defendant number 2 and census and suffering for the defendant number 3. Defendants have filed their affidavit in opposition after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit in reply.
My lord.
Let the affidavit in reply be filed by?
My lord, 2 weeks.
By 2 weeks. Full stop. Let the matter appear on 6th of February 2025. The counsel for the plaintiff submit that the interim order granted earlier is going to expire today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 12th of February 2025 or until further order, whichever is earlier.
Grateful to us.
Lord, if your lordship recalls, this is in respect of my lord, Bandhan Trust, where we had moved an originating summon suit saying that we are the trustees and there is immense pressure because some of the beneficiaries
Report submitted?
No, my lord. For that, this is the minutes of the 9th sitting held by Justice Chakraborty, my lord, there have been appointment of valuer, but his lordship, my lord, has requested for some more time. So kindly, my lord, extend the time.
My lord,
How
before
much
my
time? Yes.
passes the order, we as the beneficiaries, my lord, we humbly pray for leave of this honorable court to be added as a party to the list.
That's why, see, that's why I appointed the special officer, because all the beneficiary has been made a party, then it will be a lengthy list.
My
Impossible.
lord, the special officers has emailed upon 6 or 9 of the representatives of the beneficiaries.
Correct.
May my lord appoint the 5 to be to appear before my lord in a representative capacity.
You do
with
one thing,
representing
you do one thing. The paper publication is made by the special officer, I think.
Paper publication made? No, not yet. But my lord, he's informed the beneficiaries, and they have hundreds of them have made a representation
unanimously in one.
unanimously. And whenever we are, my lord, getting notices, we are informing them that you want you want everything to be sold off and you want your money. This is before the special officer appointed in this suit. So therefore, people have the liberty to approach the special officer. Also.
Correct. If you are having interest, you go to the special officer, made your prayer, the special officer can, if it not considered come this court, then court will pass a prepared order. Because now the special officer is in session. So it is not proper for this court to interfere in the matter.
And my learned friends have notice of this suit. Yes. They are always at liberty to come and appear and tell your lordship if they are aggrieved by
go and make a representation.
My lord, pursuant to my lord's observation, since the special officer is now in somewhat adjudicating the list, may we renew our prayer in a future date if it's so
That's why,
necessary.
if you are having interest, you go to the special officer. Special officer will consider with regard to your interest. With regard to your interest, if a special officer find you are having interest, it's okay. If not, then you have a further opportunity. What you steps you can take.
There's no difficulty, my lord. My lord, if your lord, what has happened here is, I'll tell your lordship, this was started, my lord, by Bandhan Bank as a welfare measure for employees, in the form of a trust. So some shares, etc., etc. Now, as my lord, the entities grew, the value of my lord, the investment of my lord, some shares were given my lord, really for free. Now, as the entity grew, the value reached 1,000 crores. Now everybody says that you liquidate and give me.
Give me, because value high.
Value high. So now I want my money. What is the point in having this for welfare legislation? So, my lord, the trustees said that you do whatever you want to do. If whatever we do, you'll complain. So let somebody else do it. Somebody on whom there is confidence. And whatever you have, you take.
So-and-so appearing for the plaintiff. So-and-so. Who for the respondent? Defendants, anybody? No.
No, my lord, all trustees, petitioner, respondents.
Alright, I'm appearing. Alright, I'm appearing. For the defendants, I'm appearing online.
For the defendants. Full stop. Counsel for the plaintiff submits that in terms of the order passed by this court, the special officer is in session of the matter and prays for extension of time to file report by the special officer. In view of the submission made by the counsel for the plaintiff, time to file report by the special officer is extended for a further period of 2 months from date. Full stop. Let the matter appear.
Just one. I'm sorry.
My lord would make one observation that we may come if it so happens in a
File your application. You will never oppose anything. It is your money. You decide on how you get it. Just one more.
19th March.
One more indulgence, my lord. Already some 9 or 10 sessions have been held. Sittings have been held. My lord, if your lordship is pleased, my lord, to my lord add to the remuneration. Otherwise, my lord, it's a lot of work.
It is fine from the minutes of the meeting dated 3rd January 2024. 3rd January 2025 होगा.
Yes.
2025. The special officer has conducted altogether nine sittings, but still the matter has not been solved. Accordingly, this court find that the remuneration which the court has fixed initially for the 3 lakhs, the special officer is required for the remuneration, and thus the plaintiff is directed to pay for the remuneration of rupees 2 lakh to the special officer.
Grateful. Much obliged, ma'am.
Great. Item number 14. None of in this matter. In this matter. What is the name? Kaushik Bhatta. 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 Mr. Kaushik Bhatta, BHATTA, learned advocate, though appeared in the virtual mode, but neither the video or audio is functionable. In view of the above, the case is adjourned. Let the matter appear tomorrow. Next.
I go for the respondent number 3, Your Lordship.
Yes.
One.
My lord, I am for respondent number 1.
Yes.
My lord, in this matter, this is
a
a
plaintiff.
plaintiff, my lord, is not there. Unless your lordship wants to dismiss the suit, my lord, I had something to submit in this matter. My lord, my client has been suffering from cancer. This is a defamation suit, my lord, and the client is not in good health, which is why I have not filed my written statement. I haven't even been able to file my affidavit, my lord, in opposition to their GA. Now, my lord, the difficulty is that the allegation against me pertains to me, my lord, asking for my money, which the bank owes me. But I must, my lord, tell your lordship that sometimes the client has gone overboard in the manner in which he's been asking for money, which has triggered this defamation suit. Now, simultaneously, my lord, there's litigation pending where I have a claim against, my lord, the bank to the extent of 30 crores. And the matters also, my lord, pending in DRT, where the bank had, my lord, bank was my tenant. My lord, bank hadn't been vacating my premises. Now, one fine day, they vacated my premises.
You are appearing for one.
I am for one.
Two already died.
Sorry?
2 already expired.
Yes, 2 has, my lord, expired.
Yes.
Now, my lord, this transaction was that, my lord, I own a property. That is my only source of income today. This property was occupied by the bank. I used to get under the lease agreement rent. Simultaneously, I had an account with the bank. So the rent which would be paid to me would also, my lord, be adjusted in respect of, my lord, the loan which I had to repay the bank. So on one hand, the bank would, my lord, give me rent, and I would also repay the loan. And there was a running account which would get adjusted. Now, my lord, there came a point in 2019 where the bank had not paid municipal taxes, the bank had not paid rent for a long time, and the bank, my lord, hadn't even vacated the premises. So my mean profit, my lord, also was increasing day by day. And they had stopped paying under the lease agreement after the expiry of the lease agreement. In these circumstances, I got into a settlement with the bank. In that settlement of 2019, it was stated that I will be given 28 lakhs and the bank will write off and withdraw all whatever DRT, whatever claim the bank had against me after a fair calculation where I had let go of 3 or 4 crores for peace of mind. That settlement was to be given effect to. My lord, when I went, it's a government bank. When I went, my lord, for, my lord, this settlement to be given effect to, my lord, I was asked for a bribe. I was asked for a bribe. I refused to pay any money. And, my lord, I reported this in the press. This has, my lord, triggered this defamation suit. This is, my lord, the essential cause of action.
How you prove with regard to the demand of bribe?
My lord, there is a settlement agreement Now, my lord, the bank, what they did after this happened, my lord, vindictive, the officer, my lord, then who's now who's retired, my lord, for him it was a job. He did his, my lord, whatever he had to against me. Now he's nothing to, my lord, lose in the matter. But my property is still held up. One fine day, months after the lease had expired, they surrendered my property as lessee. And even before that notice could reach me, the surrender letter could reach me, they took over physical possession under surfacing and completely disregarding the settlement and completely disregarding all my dues.
What has happened to your property now?
Now, my lord, we approached the DRT immediately. Day one, DRT was convinced, DRT granted status quo. No further steps to be taken by the bank because the DRT did the calculation and saw how much money the bank owes us and how much we owe the bank. But my lord, DRT, as your lordships know, my lord, the sluggish pace at which it runs, that matter, my lord, is still pending and the property remains stuck. Today, my brother has passed away. I am, my lord, on the verge of dying. I am suffering from cancer. My lord, women and children are, my lord, dependent, and the only source of income today I cannot utilize. Which is why on the last occasion, my lord, I had come. I had explained to my solicitor as well to have this settled. Because, my lord, the finance ministry, my lord, from the PMO's office also letters have been written, my lord, on humanitarian grounds to the bank to settle this matter. So lordship was of the view on the last occasion that we must write to the plaintiff and tell them that come, let's sit at the table and let's settle this. So we've done that. My lord, this letter, if I may give me a copy of the letter. My lord,
okay, now what you want? The plaintiff is not here.
my lord, I was hoping that the matter could be sent to mediation, my lord, because
the plaintiff is not here. How the mediation can work?
My lord, I must be frank, my lord, there's desperation in me to have this closed before my client dies. Because after, my lord, my lord, the wife and children, my lord, they won't be able to, my lord, do much with the bank. Things have to be, my lord, resolved.
See, the defamation suit, how the legal years will become in the picture? They will not.
No, my lord, but there's a larger.
Yeah, that is.
There's a larger picture.
The...
There's a larger picture. Anyway, in defamation, nobody can, my lord, close my mouth from claiming my dues. I have a right, of course. I will, of course, not use abusive language in writing my communication to the bank and the higher authorities. That, of course, is a given. But I can't be prevented, my lord, from claiming my dues. They want to shut me up completely because, my lord, they don't want me to write to higher authorities. They don't want me to write or complain to the RBI. Well, that can't be done. I have a right to claim my dues.
The plaintiff is not here. I am adjourning. Let if next day they will not come, appropriate order will be passed. What can be done?
My lord, 15 and 35. Item 15 and 35. There are two connected matters.
35 also.
Is there substitution application?
35 substitution application, the defendant number 2.
Yes.
How the substitution in the defamation?
What?
Only recording the death.
Recording the death.
Hey, 32, 35 दो नीचे है ठीक है कहीं रहने दो so none appears on behalf of the plaintiff so appearing for the defendant number 1 and so appearing for the defendant number 3 full stop. Counsel for the defendant submitted. The plaintiff has also filed an application being GA4 of 2024, which is listed as item number 35 in today's list, wherein the plaintiff has prayed for recording the death of the defendant number 2. Full stop. As none appears on behalf of the plaintiff, for the interest of justice, the case is adjourned. Let the matter appear on 22nd of January 2025 under the same heading along with GA4 of 2024. It is made clear that on the date fixed, if the plaintiff will not appear, appropriate order will be passed.
My lord, GA3, your lordship may extend my time to file my opposition.
GA3?
Before the next date, my lord.
The counsel for the defendant number 1 prays for extension of time to file affidavit in opposition in connection with GA3 of 2024. Let affidavit in opposition be filed within a week. Reply, if any, there to be filed within a week thereafter. Yes, next.
Great. My lord, is the lordship keeping the letter on record?
No, take me the water.
Grateful, my lord.
15. Yes.
But there is one application which is GA1, which is our application as a respondent, but seeking to stay the originating summons suit till the disposal of a civil suit which has been filed by the plaintiff. Plaintiff in both proceedings, that is the originating summons suit and the civil suit, are the same. I am the respondent in the originating summons suit. I am the defendant in the civil suit. I have taken out an application being GA number 1 in the originating summons suit, saying that the originating summons suit should be stayed till the original suit is not disposed of. But why do I say that?
Who is for the other side?
But,
Mr.
Lordship, I'm led by Mr. Shakushen.
Hmm.
He's on legs elsewhere. Could you kindly grant me a short passover?
in that event, kindly passes it over for the day when it's some difficulty.
Come tomorrow? Not today. Next.
My lord, this is my application, my lord, for a limited purpose, my lord, to file the wakalatnama without obtaining no objection from the erstwhile.
For that you filed the wakalat.
My lord, that has been, my lord,
For that
by
you filed the
order of
wakalat.
27.
You filed an application.
Application was filed, my lord. Leave was granted by my lord. My lord, on 27th of September 2024.
Subject to scrutiny without obtaining objection. Leave is granted to file application. Subject. Yes.
My lord, this leave has been granted by your lordship. My lord, this application may be disposed of on such terms. My lord, if your lordship kindly comes to my prayer, is at, my lord, page 4 of the application. My lord, the sole prayer that I have is grant leave to the petitioner to file a wakalatnama without obtaining.
Why?
My lord, your lordship would kindly consider, my lord, annexure D. My lord, the erstwhile advocate on record, my lord, was not, my lord, taking steps in the suit. As, my lord, according to the erstwhile advocate, my lord, the certain sums were due and payable towards his remuneration. Your lordship, my lord, would kindly come to the series of orders, my lord, at page 44.
Why your client has not paid the fee to the...
My lord, your lordship would kindly consider, my lord, certain sums were paid, my lord, but, my lord, the differential amount, my lord, was not paid.
So appearing for the plaintiff, full stop. The plaintiff has filed the present application being GA2 of 2024, praying for leave to file wakalatnama on behalf of the plaintiff without obtaining no objection from the erstwhile advocate. Full stop. Counsel for the plaintiff submit that, and non-advocate appearing for the plaintiff submit that the plaintiff has engaged erstwhile advocate, but the non-advocate was not taking steps in the matter. And as such, the plaintiff the plaintiff has taken decision for engage some other lawyer and has engaged some other lawyer. But the non-advocate, the erstwhile advocate is not providing no objection for filing wakalatnama by the present advocate. Considering the above, prayer A of the master summon is allowed. Master summon? No. Prayer A of the application is allowed. The advocate is given liberty, the present advocate is given liberty to file wakalatnama without any objection within a week from date on behalf of the plaintiff. Next.
Deeply obliged.
GS disposed of.
My lord, sorry, my lord. I was rushing, my lord. I was in item number 15, my lord. My lord, it's a change brief, my lord. I haven't filed wakalatnama yet.
Item number?
15, my lord.
You are appearing for?
Central Bank of India.
I have passed. I have. 22nd. It will come on 22nd.
Much obliged. And similar matter, my lord, in item number 30.
Same, both will come together.
35. Master.
My application, ma'am. There are two applications, GA1 and GA3, my lord. GA1 is the injunction application where pleadings have been completed, and GA3 is the application for addition of party.
What is the GA1?
GA1 is for injunction, my lord.
Interim order.
Interim order was there. Mr. Krishnaraj Thakur is online.
Please, your lordship.
Being led by Mr. Bagi.
My lord, today was the day, my lord, which your lordship was pleased to fix for, my lord, the hearing of the injunction petition to be started. My lord, I'm appearing for the defendants.
GA3 is also there in the board, my lord. It's
What is the GA3?
GA3 is for the addition of party, my lord. After the
Who has filed?
It's my application. The plaintiff has filed for addition of parties. The board has changed. My lord, the election took place. Some new incumbents have been taken in.
Have you served the copy?
Yes, yes, it has been served upon them.
Yes.
GA3 has to be disposed of.
Yes. What about the GA3?
I'm sorry, Mr. Bagh. I appear. I'm
led by Mr. Thakkar.
Mr. Boral.
Milord, it's a petition filed by Mr. Thakkar, Milord. So
yes. What? What is the, any objection? GA3 for addition of party.
Milord, GA3, Milord, it's a formal petition which has been filed because the board has again changed. Milord, I'm told if it's the latest board, Milord, which has again changed, this is a petition, Milord, where they want to array them as a party.
So any objection?
Milord, board being changed. Milord, I do not, Milord, stand in the way if the board has changed, Milord, because otherwise, Milord, this petition as it is cannot be moved forward.
The Lordship will kindly allow GA3, Mr. Bagh cannot possibly. And GA3, then we will serve GA1 then on the added parties, and then your Lordship takes up GA1 on a convenient date.
Well, that I oppose to because Milord, today was the day when they were supposed to start with the injunction petition. And the only reason, Milord, is because we are suffering an injunction, which, Milord, I had pointed out on the last occasion.
I have no difficulty in starting with my injunction application.
But today I don't think this court can take the injunction application because in 11:30 other matter is fixed.
I understand that there's a fixed matter at 11:30, Milord.
So I am allowing this GA3 for amendment for added parties, and you take appropriate step for serve the notice upon the added parties.
Yes, my lord.
And I am fixing another date for injunction application.
Please, my lord.
May I only pray for a short date, Milord, so that, Milord, we can make our submissions.
Yes. So appearing for the plaintiff, so appearing for the defendant. The plaintiff has filed the present application being GA3 of 2024. Praying for
Prayers are at page 4 of the master summons.
Praying for addition of parties on the ground that after the election of the defendant number 1, altogether 6 persons have been elected as the office bearers of the defendant number 1, and as such the plaintiff intends to bring the said new elected office bearers of the defendant number 1 on record. Concerning the submission made by the counsel for the plaintiff for use the application, this court find that the parties whom concerning the submission made by the counsel for the plaintiff, prayer A. Prayer A, B, C and D.
E also.
A to E.
A to E.
A to E is allowed. GA number so disposed of.
I'm grateful.
Let and full stop. Counsel for the plaintiff submit that the plaintiff has filed an application being GA1 of 2023 for grant of interim order.
Interim order is there. It's for final dispute. Interim order is still subsisting, my lord.
Full stop.
Interim order is subsisting.
That the GA1 till which date?
22nd of
January,
my lord. Last order, my lord. My lord's order is at page. My lord's order.
Let the matter appear on 22nd of January 2025.
My lord takes up the order dated 19th December 2024.
22nd of January 2025. Under
Milord,
the
may only seek an indulgence, Milord, instead of 22nd, maybe 23rd, Milord. One day, Milord, may I seek.
23rd is the holiday.
23rd is holiday.
One, sorry. Milord, any day thereafter, Milord. One day, Milord. Because 22nd, Milord,
let the matter appear on 29th of January 2020.
I'm very deeply obliged. Very deeply obliged, Milord.
Next.
It's at 11:30. Item number 4 of the non-condition.
Extend the matter on 29th. So if the interim order is extended till 29th, it's 22nd.
The interim order is extended till 29.
I'm good.
Yes.
But I'll keep it very short. Not your lordship will remember. Not 4 points had been raised by my learned friend. Not I'd started not dealing with that on the last day. But just so that I can not keep it shorter. Not the first point raised by my learned friend was not the power to amend, whether the court at all has the power to amend. But I'll keep that as the last point. That's what I was addressing your lordship on. But if I have the time, I'll deal with it. Otherwise, I'll hand up my notes and finish it there. For the time being, let me just keep that away. Let me deal with the remaining 3 points. The remaining 3 points, which my learned friend had raised. One had occurred after my submissions had been concluded. Some party went up to Supreme Court and got some order. So that I have to deal with. Number 2, my learned friend made submissions based on minority character of the school. And the last thing was he placed this new judgment, Aligarh Muslim University. So those 3 things I'll deal with first and very quickly. Now, the first point here, that that I intend to therefore deal with is my learned friend's submission based on that Supreme Court order is that the findings of the division bench have evaporated. Now, that perhaps is a fallacy. I'll just give your lordship the chronological background. And as far as this is concerned, my noting on this is already there in the notes. But before I get into that, may I just indicate. I had earlier argued that Justice Boshak has decided all the points that my learned friend has made, including minority character of the school that is dealt with in para 62 of the judgment. Now, my learned friend, against that order, they first preferred one SLP. That SLP was that SLP, your lordship will find the order at page 94 of GA 10. Right.
Yes.
The lordship takes page 94.
Yes.
The lordship will find item number 36 about somewhere 7-8 lines from the top. Your lordship will find item number 36, petition for SLP number 16463 of 2023. Now, let's just mark that and please turns the page. The order is learned senior counsel for the petitioner submits that the real issue is only that the expression except those pertaining to day-to-day administration and functioning of 2 schools must take care of certain acts to be done by the secretary. Moving forward, after some arguments, learned senior counsel submits that he seeks to withdraw these petitions to move the High Court for any clarification. And the SLPs stand dismissed as withdrawn in terms of the aforesaid. So first SLP filed, dismissed as withdrawn. Justice Boshak's order remains untouched. There was also a second SLP filed at that time, which was, your lordship will find, again, on that same page, page 94. There were 2 items, item number 24 and item number 36.
Yeah.
So there were 2 SLPs, both withdrawn.
Item 36.
Not right on top, right on top.
34, yes.
So 2 SLPs withdrawn, no success there.
Correct.
Findings remained. My submissions concluded.
Yes.
Then, belatedly, after almost. Now, the petitioners in those SLPs, please see who they were. This is the case status, from the website of Supreme Court. Reverend Paritosh Canning and Swarup Bor, who are the ones who are the 1 and 2, not the ex officio. So, the SLP filed by the governors dismissed. And
Reverend Paritosh and Reverend
yes,
Swaroop, yes.
defendant numbers 1 and 2, so their SLP got dismissed.
Yes.
Now, your lordship has also seen the date of the order, 14th of August 2023. 14th of August 2023.
Yes.
Now, my lord, thereafter, hearing taken up by your lordship, numerous adjournments taken, my submissions finished. Now comes, my lord, this new SLP. But please turn the page to page 96. So after 1 year,
Yes.
one more SLP. Now, my lord, please now see this carefully. But first thing, please see, my lord, who the petitioner there is. Page 96.
Yes.
Abir Adhikari. So now, my lord, a second attempt against the same order, or rather third attempt against the same order.
Yes.
Now, who is Abir Adhikari? He was appointed by them
Yes.
thereafter. Now, his term had ceased to finish, had finished by them. He had no right to file anything. He was not on the board of governors. His term had finished.
Yes. So Abir Adhikari was not in the board.
He was on the board. His term had finished. 1 year is the term under the constitution. That your lordship will find from the constitution at page 163 of the plaint. He had been appointed on. He had been appointed just before 22nd of June 2018.
Page?
Page 188. Volume 2. ये बोल चुके
Yes. 188 paper publication.
Yes.
New governors, yes.
Blood us. Blood, your lordship will give me blood. The name is not coming from there. I'll just pull out from where we are getting it. Blood. But his 1 year
Now,
term.
even though if the name is not apparent, but there is an order of Supreme Court.
No, I'm coming to that. What I'm saying is, blood, the Board of Governors prefer an appeal. It's not touched. 1 year later, someone files. He is not even on the Board of Governors. He files, and now, blood, let's see the order which is passed. Now, has it set aside the observations or the findings in the DB order? This is all we need to see, blood. Now, blood, please come to the ordering portion, page 97. Delay condoned. We are not inclined to entertain the present special leave petition. The special leave petition is dismissed accordingly. Then, however, we clarify, now, Lord, please mark this, that while deciding, Lord, what? The preliminary issue, not the interlocutory application. Please mark it. While deciding the preliminary issue, the learned single judge would not be influenced by the observation made by the division bench. Yes, yes. So now, my lord, it is only preliminary issue, your lordship will not be influenced. All other findings remain. Everything else. And what was the preliminary issue? Preliminary issue was only with regard to section 92 leave, that your lordship will find at page 31. And that was to be finally decided at the trial. Page 31, Lord, Division Bench Order of 25th July 2019.
Yes.
At page 32.
Correct.
Lord, the fourth para, last sentence, the question whether this leave under section 92 was properly granted or not shall be decided as a preliminary issue at the time of trial of the suit. that part of the impugned order revoking leave is set aside. So, my lord, Justice Devanshu Boshak's order not touched.
Yes.
All findings remain.
Yes.
So, my lord, 2 points here. I point out Malafide having failed twice in 2 SLPs, they set up someone else. And my lord, let me show your lordship, he had ceased to be a director. My lord, I had the wrong page. Please take page 188.
Yes.
Please take page 188. But first column, that newspaper article, first column, second para, moderator PC Singh, who's the chief of CNI. Now let's see how CNI has come in. And is based in Delhi and he's in jail, just by the way, will be one of the governors along with Alwan Masi, General Secretary of the Synod, highest decision-making body, Abir Adhikari, priest of St. Paul's. That's the gentleman who filed. And I've given your lordship page 163, 1-year term. So his term had expired by then. He had no right to file, nor could he have not got this order.
Yes.
But I only
Sure,
hope he
sure,
is
sure,
restricting
sure,
himself to his pleadings. Because these are nothing, because he is
Yes,
going
next.
now way out.
I am not, where is the pleading? His not, these newspaper articles are next.
Okay.
I'm showing that his term had expired. Now, so Mulad, 2 attempts made, failed, third one, Mulad set up, and Mulad, the order is completely misconstrued to say that Justice Devanshu Boshak's division bench order is evaporated. It's not been touched by the Supreme Court. SLP was dismissed.
Correct.
So Mulad, those findings remain.
Yes.
Now, this aspect of the matter, Mulad, has been dealt with in my notes, Mulad, at 2 places. Mulad, I'm not placing it, I'm just indicating for your lordship's convenience.
Manatosh. Notes done.
Mulad, that is at page 10. Page 10.
Yes.
Or, Mulad, your lordship could see it from page 9, para 7, A and B. Or rather, Mulad, 7B. 7B at page 10. And it is also dealt with, Mulad, in another portion. Yes. Mulad, page 12. Page 12 at page 13.
Yes.
Lord, your lordship will see first, Lord, subpara D on top, as observed in para 52 of the division bench judgment dated so and so, such objection of 92 is not in the realm of a order 7 rule 11 scenario, and then Lord, para 2. Para 2
There is a minority.
no, Lord, right at the bottom. Dealing with the minority, but saying that part has not been touched. The judgment and order of July 13th has not been set aside. The Supreme Court and trial court should not be influenced is with regard to only the preliminary issue. Right at the bottom of the page,
Yes.
the last.
Observation was not made on.
In this connection, it may be noted that the SLP against the order was dismissed and long thereafter SLP was filed. Observation was made only in aspect of the preliminary issue to be decided at the final hearing of the suit. Accordingly, same does not come in the way of grant of relief. Then, page 13. This may be my own printout.
Written notes of argument.
We've given them a copy.
Pages are not telling, that's the reason.
No,
No,
page,
this is my
page
own
is
printout from my.
down.
Bring it. Oh.
Achha.
So, Lord, that takes care of this first point that my learned friend Lord raised, or rather, this was the second point raised by them. Now, Lord, dealing with this Aligarh Muslim University and minority. Now, on minority, Lord, 2 things. Lord, if your lordship takes, Lord, page 13. Page 13 of my note.
Yes.
But this is dealt with in para 2. point is a bogey. Whether the school is a minority educational institution or not is irrelevant, does not arise for decision in the matter has been observed by the division bench in para 62. Para 62, division bench has held on this. Then, as further noted in the para, when the composition of the board was framed by this honorable court itself, the defendants cannot be permitted to now contend that the honorable court which passed the decree directing the composition of the board no longer retains the jurisdiction to recompose the same. Lord, that is also. Then, Lord, I have given your lordship why, Lord, the Supreme Court has not interfered. Now, Lord, please turn the page. In any event, the findings of the division bench may be viewed as my arguments. Lord, that's one part. Now, Lord, the other part. Now, Lord, this Aligarh Muslim University's case. Now, Lord, what this says is, Lord, I'll tell your lordship the basic distinction between what my learned friend said, and he said, I'll show your lordship the paras, they support my case. Lord, the minority character, oh, before that, one factual thing. Now, please remember, Lord, under the will, it's not minority. I've made my submission on that. Under no order of court was it minority except for two things. One is 1944, they had to be Christians, the Board of Governors, that came in. I've showed your lordship how it's against the spirit of the will. And then a division bench order in appeal against Justice Barin Ghosh's order, Lord, made the stray observation saying Christian character of the school. Now there I told your lordship the suit was restricted to question of grant of a lease to ICICI Bank. So this supersession of the board, etc., none of it was subject matter of the suit. So the division bench set aside the order saying, look, this supersession of the board is completely beyond jurisdiction. So, when the court says that things are beyond jurisdiction, my learned friend tried to say that the court was making an observation that because it's a minority, therefore it is beyond jurisdiction. No. Beyond jurisdiction, I've showed your lordship the para is in the context that the subject matter of the suit was restricted to a lease. The court could not have superseded the board or changed the composition in any way. That is the context. So, these are the only.
How that board, that
Correct.
chapter was
So
over by the division
yes,
bench.
so it's a
setting
stray.
aside the order.
Right. Now, came the third thing, which they point out. The school got a minority certificate sometime in 2010. So this much is clear. Till 2010, at least it was not minority, right from the inception till now. This is the position. So, this could have had no bearing on any observation made by the court at that point of time. Now, this is the factual backdrop. So, my learned friends say minority certificate, court can't pass an order because you will be tampering with the minority character of the school, which is prohibited by this Aligarh Muslim University, judgment, not running into a few hundred pages. Now, them simple thing. What it says is a school may have a minority character. It does not mean that the management of the school cannot be non-minority. Management of the school can be non-minority, it says so clearly. So simply by saying that members of the board can be non-Christians, your lordship will not be touching the minority character of the school. This is the point. I'll show your lordship those portions. Because there's a reason behind it. There's always common sense behind it. The school will need competent people to run it. Now, it may be possible that you cannot find someone from the minority community to do it. Therefore, the school is entitled to have persons who do not belong to the minority community manage it. This is what that judgment says, and I'll show your lordship those paras. Okay. But this is the principle.
Can't be run by a person who's sitting in jail.
As my junior comments, the school can't be run by a person sitting in jail with 1,000 crore ED claim against him.
Please side comments on the pleadings before you make this.
Sorry?
Yes, sir. You ask your junior to make a side comment which he is making on pleadings.
I'll show you where it is. That the charges against the ED. Bring it out. No, I'll show it. I'll show it. My learned friend puts me to the challenge. We'll see credentials. We will see.
My lord, Mr. Bachawat is appearing for the secretary. He's appearing for the respondent number 8. He's not, the GA8 is not his application. It's an application filed by the plaintiffs. Plus, these are all off the record arguments.
The plaintiff is here supporting Mr. Bachawat in full.
He's my learned.
He's a co-respondent in the suit. The plaintiff is not making all these arguments. It's the plaintiff's application.
Why?
Now where it pinches, why are they getting agitated? Not let him deny that he is arrested and behind bars. Let him deny it. My learned friend is not denying it. He's not. He's getting agitated instead and trying to interrupt the proceedings.
You are taking the cause of somebody else. You stick to your own case.
Oh, what happened? What happened when the second SLP was filed? Whose cause was he taking up?
Well, that SLP was entertained and there was an order by the Supreme Court in that
Yes,
SLP.
but who was he?
Okay. Let
Who was-
Mr.
yes.
Bachao.
So now, let's see the Aligarh Muslim University. Your Lordship has the judgment, perhaps not. If your Lordship would take page 100 of page 118, if not, I had a physical copy. They had given us. Oh, they took it back. Oh, I had marked on that. Anyway, can't be helped. Hey, do you all have a copy? Yes. Oh, I'm sorry. Page 100 of 118. 118 should perhaps be the last page. Page 100, para 138. Now, does it tally?
That is 138 paragraph.
Para 138.
Because this is the print copy of the.
Yes, we also have that. Para 138, perhaps not. But the page is at the bottom. Page 100 of 118, it says.
Yes.
But is it a paragraph beginning with the next question?
No. In the backdrop, para 130.
It's not telling.
And it starts from page 82.
How is it not telling? Para 1. But could I just borrow your Lordship's copy and pull out the relevant para, if your Lordship doesn't mind? Oh, acha. Now, yes. A different one. Yeah. But there was different judgments by different judges. No? No, some part of one. Wait. Because there are multiple judgments, your Lordship will give me one minute to bring it out. No. Baba. Yeah, this should be it. Yeah. Yes. But there are different judges by different judgments by the different judges. That's why I'm not. So. I saw the look on your Lordship's face. But more suited for.
I indicated the three judgments because the page editions are.
But more suitable for morning exercises. But this is the lead judgment with which two other judges have concurred. Now, 138, if I may play.
Yes.
The next question is whether the administrative structure of the educational institution is an indica for establishment of a minority educational institution. We have already held above that an educational institution, a minority educational institution, if it is established by a religious or linguistic minority. Now, please mark this, it is not established in any case, in our case, by a minority because the will says it's for everyone, for the public of Calcutta. Now, we have clarified that it's not necessary to prove that the administration vests with the minority to prove it is a minority educational institution, because the very purpose of Article 31 is to grant special rights on administration as a consequence of establishment. So, management need not be minority. Then, to do otherwise would be amount to converting the consequence of to a precondition. Right to administer is guaranteed to minority educational institutions to enable them to possess sufficient autonomy to model the educational institution according to the educational values that the community wishes to emphasize. It is not necessary that for the the purpose can only be implemented if the persons belong to the community helm the affairs of the administrative affairs. So it's not necessary at all.
Can only be implemented. Okay. Yes.
This is so particularly because a minority institution may wish to emphasize secular education. Now, my lord, please remember this school, not over here, 95% or 98% are not non-Christians in any case.
Everywhere, yes.
The founders of the minority committee may choose to populate the managing board or a comparable authority responsible for the day-to-day administration of the institution with persons belonging to the same committee. However, they are not compelled to do so. So, governing institution may or may not belong to the minority community.
Yes.
They may wish to appoint persons who do not belong to their community, but who they feel deem fit for proper administration. So they can appoint anyone.
Yes.
Now, my lord, in this case, please remember, my lord, the High Court is the person who has framed the scheme. If your lordships feel fit that it should be run by other competent people, your lordships can certainly do so. Absolutely clear from this judgment.
Yes.
Which is why your lordship will find, Lord Justice Devanshu Boshak also said that the minority of nature of the institution is not going to be affected by who the management is. If it is minority, it will remain a minority. If it is not, it is not.
Yes.
So, my lord, this is a complete bogey.
Yes.
Now, my lord, if your lordship would come back to page 14 of my notes.
Yes.
Not subpara B, I've said that they are relying on a minority certificate, and then I deal with it in the 1, 2, 3, 4. Reliance on the certificate is irrelevant as the school has admittedly functioned for 200 years without having sought or been granted such status not till 2010. Now, who got it? These people, because there was admittedly a vacuum from the 1970s, according to them. There have been only 2 people. So these people went and got it. No. Subpara 2, such status was applied for and granted at a point of time when there was no functional board of governors, with only ex officio who were on the board being members of the Christian church, who have obtained the same with vested motives and self-serving reasons. There was no one to oppose the same, as even according to the submissions made on behalf of defend numbers 1 and 2, there have only been 2 ex officio members for decades. The contention of the defendants that La Martiniere schools are Christian minority institution and such character will be changed by the change of the board is misconceived. It's clear from the defendant's own case that the school will continue to retain its Christian minority character even if reliefs prayed for are granted, since the factum of schools having been set up under the will of Claude Martin will not change. And Lord, your lordship will remember, even the first decree by which the scheme was framed says that the school will be set up and run in accordance with clause 24 of the will. And clause 24 of the will does not say anything about Christian. Then, Lord, subpara 4, moreover, Aligarh Muslim University sought to be relied upon, itself clarifies at para 138, but there's another para also, that it's not necessary. Administration must vest with the minority for university to be minority educational institution, and the persons who do not belong to the minority committee can also be appointed if they are deemed fit and proper. And their observation saying, Lord, that there must be a good management. So, therefore, they are free to choose their management. And Lord, please also remember the context of the judgment. There, Lord, the question was whether the state can frame a law to control it. It's nothing to do with this. Then, Lord, Aligarh judgment does not grant absolute and complete autonomy as contended. On the contrary, it permits interference for the purpose of proper functioning of the institution and broader objective of serving public good. That also your lordship will find in the judgment. It's to be noted that the Aligarh judgment was delivered in the context of state interference affecting rights of minorities, does not come in the way of reasonable restrictions being imposed for proper administration. In the present case, appointment of non-Christians on the board of governors is not only necessary but also permissible in light of the Aligarh judgment. Appointment of non-Christians on the board of governors will not affect the alleged minority status or character of the schools, as the judgment makes it clear. Even a non-minority can be academic or institutional head of a minority institution. Now, that's para 62. And they had relied on para 62. It is not understood how the change proposed in the composition of the board of governors will affect the rights of any minority. Vast majority of schools are not Christians. Schools will continue to provide for the needs of foundations, etc. So, my lord, this takes care of minority and, my lord, Aligarh Muslim University, which leaves me with one, my lord, very small topic, but, my lord, that is dealt with in my note. My lord, why is it now become imperative that your, my lord, one part is whether your lordship has the power to do so. Now, the one objection which my learned friend raised, my lord, I've dealt with that in detail and I placed most of that on the last day. One, my lord, thing which my learned friend, my lord, kept jumping up to say, look, all those things that you show, those are not cases where the court has interfered in a different suit. Court has said scheme modified in some other proceeding. So now, my lord, I'm dealing with that. Only that limited aspect. The rest is all dealt with, my lord, in the note. So, my lord, let me give your lordship, my lord, 3-4 instances. Number one.
Yes.
Lord, your lordship will remember the original one was in the old equity suit. The 1944 where the Christian was brought in was in the old equity suit.
Yeah.
Now, also, Lord, please remember there is no restriction on in the will with regard to composition
Of the
or the right to change. The decree which came in says that your lordship has the right to change. So, Lord, power to change, therefore, cannot be disputed. The only limited point that they can now, Lord, say is, look, it must be in the old equity suit and nowhere else. So, Lord, that is what I'm trying to
That
now.
is the main argument.
No, their argument was court has no power at all. At all.
First thing, second
Yes,
thing, you
yes.
filed in this
Right. So,
a separate suit.
Correct.
It is not the old.
Correct. So now, my lord, power to alter is there in the decree. Also in my note, your lordship will find Lucknow Lamartnia, which arises out of the same will. Clause 22 of the same will does not have this restriction at all by virtue of our court order. Now, my lord, coming to the last thing. Now, my lord, your lordship will find the page take to follow. Just give me that page, please. But the suit which you but first, not please take the decree. First decree. Not at page 74.
Yes.
Just the last 4 lines of the decree.
Mantosh, usko pin kar. Page 74.
Yes.
Yes.
Just the last 4 lines of the decree.
Yes.
Or 5 lines. And this court doth further decree and declare that the Supreme Court shall at all times have the power of authority either on motion by the Advocate General for the time being or otherwise, time to time to make all alterations. So power can't be disputed. And it does not say in this suit. It cannot be contemplated that suit will remain pending for not 300 years or 400 years. So not to say that it can only be in that suit, although the decree itself doesn't say so, but is stretching it. Now, I am giving your lordship examples now of where the court has said it will. Now, my lord, that judgment of Lord 1968, which I've showed your lordship, plaint page 79, and my lord, if your lordship turns to the operative portion at page 94. Now, please, my lord, at 79, please see the suit number. It's a different suit, 2602 of 1967. It's not in the same suit.
Page 79.
Yes, my lord. See the suit number. But page 79.
Yes. That is the suit number 2602.
Yes, it's not in the old equity suit. Now, if your lordship turns to page 12 of this judgment, which should be page 94 of the plaint.
'92.
94.
Yes.
Your lordship will remember this was in the context of appointment of principal and other such things. And not there the question arose with regard to the clauses of the will, whether they should be changed or not. Now see the second para. Although most of the offices the holders whereof were appointed by the decree of 1832 to be ex officio governors have ceased to exist. Please mark it. Have ceased to exist. The first three respondents are holder of three such offices. So in 68, there were three, not 12, but there were three. The scheme as framed by the decree of 22nd October 1832 as amended by the decree of 1980 and orders of so-and-so may be changed by this court at the final hearing of the suit. So court says it has the power to do so in a different suit.
May be changed by this court at the final hearing
Correct.
of which
the
suit?
scheme as framed.
Which
the
suit?
Of this suit, no, this is that suit of 1967.
Correct.
This suit means in 19.
Correct.
So not in old equity suit. So the court has the power to do it in a different suit. That's all.
So you mean to say this suit means in this suit
Yes, the court had the power.
of the 1967 suit?
But I'm only relying on it to say that when my learned friend says
It
it
is
can
not
only be
necessary
done
to
in
go to the old
old
equity suit. Any suit can be filed
Correct.
for.
Correct.
This is your submission.
This is the finding. This is the finding by the court that the court will do it at the final hearing, may do it at the final hearing of that suit. So possible in a independent suit.
One.
The division bench has taken note of this judgment and said ultimately this suit came to be dismissed.
Correct.
So therefore it was not done, dismissed for default or some such thing. So Milord, this is the first instance. Then, yes. Then Milord, please take Milord, GA 8, page 64.
What has happened to this suit?
Milord, it's recorded in the division bench judgment. Milord, it was struck off.
Struck off.
It was struck off from the rolls of the.
Yes, Justice Bashar.
Yes.
Next.
Milord, if your lordship takes GA 8, page 64. So, not first instance where a court says it can be done in an independent suit, power and jurisdiction there. Second instance, in this suit, division bench, page 64.
Yes.
8th October 2020. SLP is not filed against this, also dismissed. Please make a note.
Yes.
Now, your lordship will find that I'll read this order. It's not very helpful in our case also. There'll be an order in terms of prayer A. I'm sorry, not at page 65. GA8, page 64 is not the beginning of that division bench order. If your lordship turns to 65. There'll be an order in terms of prayer A, matters of some importance, and the slippery technical arguments made on behalf of some of the respondents would have the court miss the wood for the trees. Please see the language. Slippery arguments. Appeal arises out of an interlocutory order, etc. Then there's a bit of history which cannot be overlooked. Before addressing the present list, there is an old equity suit. Now he notes the old equity suit. Pending for nearly 200 years pertaining to the will of Claude Martin and the school set up as a consequence thereof. There is no dispute that a decree was passed in 1944 by this court, framing a constitution for the school. 12 ex officio governors were constituted to the board. Posts were indicated as follows, and all eminent persons, not all eminent posts. And your lordship turns the page. Lord, includes army, judiciary, advocate general. Then, Lord, however, the immediate succeeding clause in the decree dealing with the constitutional board of governors provided that no person officiating the aforesaid officers who did not profess the Christian religion would be eligible to exercise or perform any of the duties. It must be noticed that the 12 ex-officio governors were empowered by the decree of 44 to co-opt for additional governors every year for the 16-member board. It appears the constitution as framed in 1944 decree has not been amended, nor does it appear that any meaningful attempt for the purpose of amending the same has been made. The decree and the constitution indicated therein are quite anachronistic. The country has gained independence. The state is now West Bengal, and even Calcutta old is spelled differently. It appears that upon the first two named in the board of ex-officio governors for long, not being persons professing Christian religion, the third name in the list has taken it upon himself to assume the post of chairman of the board of governors and wield powers that the constitution may not have provided for the occupant of the relevant post. So finding first that he is going beyond his powers. Further, since several other positions are no longer manned by persons professing Christian religion, the board of governors has effectively shrunk to 2 or 3, with the successor in office to the Lord Bishop of Calcutta and the nominee of St. Andrews being principal persons in control. Prima facie, it appears that the 1944 decree intended only it does not appear that the 1944 decree intended only 2 persons to control the Board of Governors. So, my lord, second observation. If it is necessary to respect the will of the founder of Claude Martin, the permanent Board of Governors should not have non-Christian members. The decree could have been modified as the old equity suit remains pending and the perpetual overall mandate of this court continues. So, mandate of the court continues. As far as the present suit, now I'm not turning to present suit. It is instituted by 4 persons who've been co-opted on the Board of Governors for 1-year term. Similar to that 1-year term I gave you, Lordship, and whose nomination was subsequently sought to be revoked. So, my lord, 2 of them tried to remove 4 without giving them notice. While it's true, as some of the respondents suggest, that the personal relief squad, the individual plaintiffs figure most prominently in suit, there's a prayer for a scheme of administration or management to be framed, and it cannot be missed that the Board of Governors, as functioning in the recent past, may not be in consonance with the decree of 44. So, my lord, Board of Governors is not in consonance. Respondents suggest that the scope of the appeal is limited and the interim order was merely vacated by the impugned order of 18th upon the court noticing that the 1-year tenure of the 4 plaintiffs would have run the usual course. So, argument made by them is, look, the 4 plaintiffs, they've lost their office. End of the story, there's nothing left. But the court says, no, there's a scheme prayer. And that scheme modification has to be considered. However, it cannot be missed that the Board of Governors is not the board in accordance with the decree of 1944. Not clear finding. Division bench, Supreme Court challenge, dismissed. The appellants complain that the major policy decisions have been taken by the Board of Governors headed by the present Bishop of Calcutta for establishing branches or new schools in the name of Lamartine in conjunction with other schools. It would be in the best interest of all concerned that all decisions taken by the board after institution of the suit or after passing of the initial order be not immediately given effect to except those pertaining to day-to-day administration. So, not the school that they were trying to set up stopped. No decision pertaining to any new school should be given effect to or any steps taken in pursuance thereof till the matter is decided. So, my lord, even the 2 people there, their powers have been curtailed. It may be necessary to make the constitutional document more contemporary. Now, my lord, see this. This is of extreme relevance over here. Utmost relevance, rather. It may be necessary to make the constitutional document more contemporary and to revisit the manner of composition of the Board of Governors. Since such part of the exercise may be purely for the interest of the school and not adverse to any person, the exercise may be taken up in the course of hearing in the present appeal, not in this suit itself, to preserve and protect the interest of the school, which ought to be paramount concern of the court. Appeal and applications will appear a week, and my lord, they were asked for their suggestions. My lord, COVID was on, repeated adjournments taken by them. Learned judge got transferred to Chennai, and he drove off. And thereafter, ultimately, after a lot of attempts, we were able to have the matter heard before Justice Boshak. And your lordship has seen the observations there. I don't think I need to trouble your lordship. But again, he also felt that it should be done in this suit. And my lord, please see the relevant portion at page
112.
The relevant portion will be at page 114.
Start 112, then 114.
Yes.
72.
So, my lord, in this suit itself, your lordship has been asked to. So, my lord, and these, my lord, in my humble submission, my lord, these observations fully remain not touched by any of the 3 SLPs that they filed.
Yes.
This process is not adverse to any persons, but they are officers of post. No one has a right to be a receiver for life.
Now, my lord, please remember one more thing, my lord. It's my humble my lord, request, my lord, if your lordship consider. But framing of a scheme cannot affect them in any way at all, or reframing of the scheme.
For the management of the school.
It's for the management of the school. Admittedly, today there is a vacuum. There is no quorum. The powers of the board are also restricted by these orders. And there is no quorum. But that also I'll point out in just one more minute before I finish, my lord. So, my lord, now, my lord, why is it that my learned friends are objecting to reframing of the scheme? We are not saying remove them. No one is saying so. We are not saying let there be no Christian representatives. We are not saying so. We are simply saying, look, 10 posts remain unoccupied. And it has been so for a large number of years, not at least in excess of not 40 years or 35 years. So, my lord, there has to be some way, my lord, to fill these up. So, removing the Christian with regard to at least those posts which are no longer occupied by Christian or any other way in which the court deems fit. But after all, not under the will, your lordship is the guardian. Your lordships are the guardian. The school, not the court has been given the power to appoint the scheme. Your lordships have done so. Your lordships have modified it when it arose. But the fact of the matter is today, not it is anachronistic as that not judgment holds. Today, situation has changed. That not change was made in 1944 before not the English were leaving. They've done it to safeguard whatever interest was necessary. Today, not we are in a completely different India, a completely different place. And only one other thing which your lordship will not kindly consider: two schools, not one running in Lucknow, one running in Calcutta, no religious restriction there. But that school has grown not from not it's soaring. It's soaring. Today, not it's a museum worth visiting, actually. This school, not the reputation has been going downhill because of a admitted vacuum in the management. So, this and one para only, if your lordship will not make a note of, not why it is necessary to do so. If your lordship will not please take from not necessity for intervention, page 7 of my notes.
Yes. C.
Yes, not C, 1, 2, 3, 4, etc. Change circumstances. 10 out of 12 positions are vacant is the first bullet point. Not only 2 posts are filled up by post holders. Then, Lord, admittedly a vacuum in the board which lacks quorum. Now, Lord, there was a strange argument made by my learned friend. Lord, if your lordship comes to the 5th bullet point, quorum, clause in the constitution relating to meetings of the board at page 161, I've given it and quoted it, so your lordship doesn't have to go there. At all board meetings, 1/3 of the governors shall constitute a quorum. Now, my lord, your lordship has seen 12 posts, so quorum should be 4.
Minimum.
Now, what was the argument made by my learned friend? Lord, the next sentence. Accordingly, the quorum required for any valid board meeting would be at least 4 members. Thus, no valid meeting of board of governors can be held because there are only 2. Then, the argument made on behalf of the defendant numbers 1 and 2 that the same applies for a quorum of 1/3 of 2 members. That's what he argued. Now, if you take that, not 1/3 of 2 members is 0.67. So, if you go by this theory, one person can hold. He said 1/3. No,
He said 1/3.
1/3 of those.
Persons are there, then they can take.
He said 1/3 of those present and voting, which means what? There can't be more than 2. That can't be more than 2. So 1/3 of that is 0.67. So if you go by what he said, one person can hold a board meeting.
One person can take the decision, other will give this half opinion.
That the same situation arose previously.
So this is absurd.
And the court has held that the 4 additional governors, if they come into the board, then that constitutes that was the situation that was prevailing then also.
So, Mulad, if that was the situation,
said that
so
these
Mulad, take that argument to be correct.
Because of that fact, the fact that there is an
I accept his argument. I accept his argument. I accept his argument. So, Mulad, today there is no quorum. Then how did he not make the quorum by which he appointed these 4? How could he have appointed? Let me understand that. The appointment of additional directors can't be done at all in that case. Can't be done. He appointed. He removed without calling them to a meeting.
Next.
Those are my submissions. But just give me 1 second to not reconsider if there's anything I've missed out. Not. So, not to summarize, none of the court orders put a hurdle.
Yes.
On change. Second submission, change can be in any proceeding. 3, not your lordship is the guardian. The court is the High Court is the guardian. And it is solely in charge. 4, today, not change circumstances, complete vacuum, lack of quorum, and wrongdoing and arbitrary actions by not the existing members. Not those are my submissions.
Yes, thank you.
But I am sorry, I've taken up almost an hour today.
Thank you.
But Mr. Shah, he's going to deal with the section 92.
Well, I will be very brief because I do not intend to converge on any of the points that Mr. Bachawat has submitted on. It will be a repetition of arguments. Because although Mr. Bachawat technically appears for the secretary of the school, he is an ex-student of the school and equally invested in this matter, as all of us are. And my lord, apart from that, my lord, the interests are quite aligned because my lord, they have been supporting each other right from the beginning. So my lord, brushing aside the very technical objections that look, he's appearing for the secretary of the school. My lord, there is really no substance in these allegations. Now, my lord, the question is very simple before your lordship. Secretary, ex-secretary. Very well. We stand corrected. If that, my lord, makes my learned friend happy, but I'm equally happy for him. Now, my lord, the question is, my lord, why did
You are appearing, Mr. Shah, you are appearing.
I'm for the plaintiffs.
But one aside over here, since we are here, Lord, your lordship would have seen, Lord, the name of the Reverend Paritosh Canning, gentleman appearing there, Mr. Paritosh Sinha. Now it just happened. This is the joke. So Lord, there was a gathering where there were a lot of Martinians present. Someone from our batch was getting married, and a lot of Martinians. And in walked Mr. Sinha. I said, "What are you doing in the middle of this?" And someone then said, "Why? He's Paritosh."
I thought this
Reverend.
I was almost not being killed.
So I said, "You come here to get mobbed."
So you're safe in both the ways.
He's got more friends
Well,
in La Martina than I do.
I can only say that, my lord, he should not take his safety for granted.
My lord, I am also appearing, my lord, for the Association of, my lord, the alumni. My lord, is it my lord's pleasure after Mr. Shah, my lord, will hear me also, my lord, mine is GS6. So my lord has heard me. I don't know, my lord, whether, my lord, and I've also filed notes. So
Yes.
after Mr. Shah finishes, my lord, maybe if required, my
Well,
lord,
I will not take very long. But my lord,
Right.
if your lordship, my lord, kindly,
How much time will take, Mr. Shah?
well, I should not take more than, my lord, 15-20 minutes.
It is a kal bhi hai ye. Kal bhi hai. And Mr. Banerjee, you are already argued. I have taken note of it. You come with the written notes.
I have, my lord, also prepared written notes, my lord, which I think, my lord, has already been, my lord, is being filed. But if my lord thinks, my lord, I can, my lord, just make submission, my lord, for 5 minutes if anything, my lord, is left behind, if I think. Otherwise, my lord, I don't, my lord, not require.
So let come to
Notes are with us, my lord. May I
come tomorrow. Come tomorrow.
You come
So
tomorrow.
let it tomorrow because
Very well,
11,
very
12:30 other matters of
Very
things.
well, my lord. I will not take much time in
You
any
will take
case.
15 minutes. Mr. Banerjee
Right.
will take 15 minutes. Other
Yes, yes.
I will just reply to only factual aspects.
Well, yes. Well, it's just factual clarifications, not more than 5 to 10 minutes.
all
Not more than.
15 minutes, not more than that.
Yes, kindly.
Absolutely. Absolutely. Not more than 15 minutes on this side.
This all good things must come to an end. We'll confine ourselves to 15 minutes.
So फिर वो देख लेना सब कुछ. And the counsel for the defendant number 8 has concluded his argument. Counsel for the plaintiff has commenced his argument in reply, but due to paucity of time, hearing could not be concluded. It is found that the matter is already fixed tomorrow at 11:30 p.m. 11:13 a.m. Let the matter appear tomorrow at 11.
Great.
So it's grateful, your lordships.
Great.
Obliged, Lord.
कितना है ये पूरा? मेरा चैम्बर भर जाएगा. बहुत ज्यादा है. Yes, call the matter.
20 is my application, but under section 34 of the Indian Trust Act. Lordship on an earlier occasion in another matter, Miller had considered this provision of law where Miller, the trustees of a trust which Miller enjoys immovable properties can come to court, Miller, and seek Miller orders from court to deal with the property. This is one such matter. Miller, here the trust deed, Lordship would find at page 19. The trust deed, Miller, contemplates two properties. It considers two properties. One, Miller, is at 80 Bidhan Sharoni.
You are the trustee?
Yes, Miller. These other two persons now are the last trustees, Miller.
Geeta Maulik and Sanjay Maulik.
Yes, Miller. According to the trust deed, Miller, I would show that one clause. Miller, kindly come to Miller, page 31, Miller. Page 30 and 31. Page 30, this clause, Miller, the settler is now at the end, last clause, Miller.
30.
30.
Yes.
The settler is now desirous of settling the aforesaid properties, Lot B, premises 80, and premises now 53. These are two properties considered, which are considered here, for the purpose and for the benefit of the persons mentioned hereafter, and the manner and to the extent hereafter provided. Thereafter, the how the properties are to be maintained, provisions are there. Now, one of these properties, the trustees now want to sell off, and the out of the money that comes with the sale, would be utilized for the maintenance of the other property and the maintenance of the members of the trust who are now living beneficiaries. So this is my prayer.
Why you want to sell?
That both these properties are one is fully tenanted. It's a market running going on. Many market shops are there. The other is partly tenanted, partly residential. Residential part I am staying. The beneficiaries are staying. Now, the deed provides that you have to use that property where we are residing as partly residential. Remaining you can let out.
There is no deity.
There is no deity. In none of these there is no deity. It's a trust created by an individual. So we are the beneficiaries.
Only these two. Only these two persons.
No, beneficiary now there are 6 beneficiaries.
So what about the other?
The others are giving consent. All of them will now. The daughters, they stay outside. They don't stay in the property. They got married and they don't give the one. And there is a provision for giving maintenance to the daughters who go out from the family through wedlock. She is receiving maintenance and she is willing to because the mother and brother they are moving it. Son and mother and son is moving it. So there is no dispute in the family. It's a family trust. Only prayer is that we need the permission of the court, if Lordship sees my prayer, permission of the court, to sell off one of these properties.
Why you want to sell?
Because it's difficult to make. I have given the accounts. The money that is coming from the properties, from the tenants and occupiers, is not enough to maintain the properties.
How many tenants are there?
It's fully tenanted. It's a marketplace. There are about 150 tenants.
Having the details.
30 shop rooms. We have given the bills and the.
How much rent you are receiving?
Yes, I have given the particulars. Lordship would find that particular at page 109 of my application, the audit of both these properties, the page 1110 and 1111 are the income and expenditure account for both the properties separately. The 80 Vidhan Sharoni, kindly see the page 1110.
Salary, cashier, property tax. So your expenditure is?
So this is my expenditure. It is coming 5,99,807. There is a deficit of 70,000 every year.
Income and expenditure are the same.
Because the deficit on the.
It's 1,71,000.
Yes, 70,000. 70,000.
Where it is?
But the
70,031.
Yes. That's the problem. Now, every year I'm incurring this loss.
Taxes are not being paid.
I'm also not being able to pay the tax or clear the tax because of this loss in revenue. From the tenants, whatever I income, whatever I will earn from the property, I have to utilize the same and much more than that for the purpose of maintaining these two properties. One is partly residential, partly tenanted, other one is fully tenanted. The one which is fully tenanted, that is what I want to deal with.
Which property?
That is 80 Vidhan Sharoni.
Where it is?
80 Vidhan Sharoni,
Page 30 bottom.
Page 30, that clause I was showing, the two properties were in
80 Vidhan Sharoni.
That is the part that I want to sell off. Page 31, last clause permits it. Page 31, last clause, clause number 2.
There is 53A.
Yes, 53A for residence, and let out remaining portion of 53A, the next sentence, and let out Lot B of premise number 80 upon such term and condition as the trustees shall agree upon with intending tenants. So the one I had to use 53, I have to use it for some residential purpose, which I am residing in the property. I don't want to. Trust will be alive. So because that property remains in the corpus of the trust, so trust will be alive. The 80 Vidhan Sharoni property that is fully tenanted, that is anyway not in my possession because some occupiers are there. So now in this case, Lordship in the other matter, Lordship had asked me to first advertise and see if anybody is interested to in the residing in the whoever is continuing.
First you bring what is the market value of the property at present. Then only the
I will bring Miller market value of the property. Miller for
Present
intending
market value of the
purchaser. Yes, Miller. And Miller, the lordship will direct me to publish it in the newspapers.
That's correct. First you have to bring the market value. Publication will be made for the basic price only. First
Yes.
the
So
market
that publication is Miller regarding the persons who are occupying, if they have anything to say, because
that's correct.
Yes.
See, with regard to who are occupation,
Yes.
they are the tenants.
They are the tenants. They may have some lordship say on that.
There might be some, I agree. But if you wanted with the what the publication is to be made, publication is to be made for the claimings and objection and the person interested.
Yes.
So if the person interested to purchase, you have to fix the basic price.
But this is not going to be a tender, Miller, because I will enter into a private arrangement with a developer or Miller.
That's correct. But the court has to see what is the amount you have settled.
But there is no, without the leave of the court, I can't formally settle anything.
Now you're telling that party you are going to.
I have to look for an interested buyer who will
if you
purchase.
wanted to look for have any person who the proposed purchase.
I will take out the valuation from the government website.
Correct.
Yes, what I
bring the government website and you disclose if you are having any proposed purchase what he is giving.
Very well. Absolutely.
So that's why the basic price is to be given in the paper sale notice.
Yes, yes.
Then if any person is coming for that basic price, then it can be done.
That direction lordship kindly provides.
Otherwise,
the valuation of the government valuation and
present
the
market value.
present market value, and if I have anyone interested in my knowledge, then I will also
that I am not recording. You come with that.
Very.
So and so suffering for the plaintiff. The plaintiffs are the trustees. What is the name of the trust?
That is the problem. There is no formal name of the trust. It is the audit. Kindly come to the audit page, Miller. We are writing it as the person in his wisdom, Miller, had created a trust. He passed away, Miller, and the trust is continuing. Lordship can name it in this manner, Miller. Estate of late Tulsidas Malik. But we can also then, because that is how the audit part is doing. I am also not being able to obtain the PAN card because of this issue. There is no formal name.
That's why if I record this, tomorrow if the court will pass an order for sale, then you will be in difficulty for registration of the sale.
These persons in the individual capacity have to now.
The plaintiffs claiming themselves as the trustees of the property being premises number 53 prior to that which of the property being premises number 80 property being lot
lot B
premises number 80 comma Bidhan Sarani Kolkata and premises number 53 capital A Abhedananda Road Kolkata full stop. Counsel for the plaintiff submit that one of the property being premises number 80 Bidhan Sarani Kolkata is full of tenants, and in the other property being premises number 53A Abhedananda Road Kolkata is having the half portion of the residential premises of the plaintiffs,
remaining half is tenant
of the plaintiff, and half portion is vacant
tenant,
and half portion of the property is tenanted.
Portion only.
Counsel for the plaintiff submit that the plaintiffs being the trustees of the said property are not getting proper income to maintain the said properties. And as such they have taken a decision to sell one of the property being premises number 80 comma Bidhan Sarani Kolkata. Full stop. Consider this and as such the plaintiffs have filed the present suit praying for leave from this court to sell one of the property that is premises number 80. Full stop. Bidhan Sarani Kolkata. Consider the submission made by the counsel for the plaintiff. This court is of the view, without going into further into the matter, into the merit of the matter, comma, the plaintiff is directed to file and to file a supplementary affidavit by disclosing the present market value of the property present market value of the property as well as the value of the structure standing in the said property. Let the same be done within a period of 2 weeks.
Corporate website, 2 weeks, 2 weeks.
2 weeks from date. Let the matter appear on 22nd January 2025 for filing supplementary affidavit and further orders.
Grateful. Grateful. Well, I will disclose if there is any intending purchase, I will disclose the name.
Next.
My lord, I am appearing on behalf of the petitioner. I am seeking an adjournment for filing the amendment application.
Why?
Amendment of the cost title. My lord has
Last
already.
time also you have taken time, madam.
Yes, my lord. The executor is now in Gujarat. I have informed him. He will come within 2 to 3 days, my lord.
For what amendment?
For amendment of the cost title.
For what?
Address of the, for adding the address or another address of the testator, my lord.
Another address of the testator.
Yes, my lord.
What is the mention? What is mentioned? What is the address mentioned in the will?
In the will,
Okay.
one.
As per the prayer made by the counsel for the petitioner, the case is. Let the matter appear. How much time? 2 weeks.
1 week, my lord.
The matter is adjourned. Let the matter appear on 24th January.
Grateful, my lord.
47, my lord, we are for the applicant in
My
GA2.
lord, this is my application. My lord,
I'm opposed to this application.
my lord, this is an application for condonation of delay in support of filing of caveat in connection of the probate application. Madam, I am the sole surviving first-class legal heir. They have obtained for probate of my father's will.
What is your application number?
GA2 of 2024.
2 of 2024.
Yes.
My lord, there is a delay in filing the affidavit in support of the caveat.
Yes. When you receive the notice?
My lord, I have received the notice on in 2022, 12th of December 2022, and I have lost the caveat within time. But thereafter, my lord, there were certain changes of advocate. Twice, advocate has been changed. And lastly, Mr. Siddhant Chaudhuri has been entrusted with the brief, my lord, and the petitioner has been met with an accident for which he could not file the affidavit in support of the caveat within time. There is a delay of 212 days. My lord, I am not going into the technicalities of this delay. My lord, it has been explained in the application. I am only pointing out to your lordships, I am the only son of the testator. My lord, testator, my father died in 2020, 2nd January 2020. The will was in 2014. My lord, probate application has been filed sometimes in 22.
Correct.
My lord,
yes.
My lord, there was a subsequent discovery of a new will, last will of the testator. When testator executed the 2014 will, the executrix who has filed the probate application, who incidentally was my wife, my lord, was with me in that house. And my father bequeathed the property in favor of my son. But because of the strange relation between myself and my wife, divorce was passed by the decree obtained by a decree of divorce when a marriage was separated. Thereafter, she left the house in 2017. And my son also left the house. And the relationship was so strange That is why my father was constant to change the will in 2019. But I didn't know that will was existent. Well, the attesting witness of 2019 will informed me that there was a subsequent will in sometimes in 2023. That is why probate application of such will, the last will of the testator, has been filed in before the district delegate at Alipur. So, my lord, in any event, I have a caveatable interest.
You have filed another probate application
Yes, man.
of the 2023 will.
In the yes 2019 will
2019 will. When you have filed this said probate application?
And I have filed it sometimes in 2023.
Yes. What is the stage of that application? But and that
My lord, district delegate in that district delegates court, my lord, they have filed an objection for which it became contentious and it has been returned to the petitioner for filing before the district judge.
Why did return? It should be directly go to the district judge. So it is that contentious cause before the district judge now.
Yes, yes, yes.
Yes, Mr.
Grandfather's property. He is the son. I am the grandson.
You are
Now,
the grandson.
I'm the grandson. Now, first will executed on 26 November 2014. Lordship, dates are very important.
Where is the PLA?
PLA 124 of 2021.
Yes.
In any way, my lord is not entering into the merit of the application right now, only considering the delay.
I only point out, your lordship, the relevant facts, and then I'll say, your lordship.
Who is Samparita?
Yes, your lordship, Samprita is, your lordship, the daughter-in-law, my mother. My mother. Now, he is the father, the executrix is the mother. I am, your lordship, the beneficiary is the grandson.
No, the application is filed by Samparita.
By Samprita, that's your lordship, the daughter-in-law.
Correct.
Now, the person, your lordship, executed the first will on 26 November 2014, admittedly. He is saying, your lordship, the will has been executed, not disputed. Now, what he has done, after your lordship filing this probate application, he has not filed, your lordship, any caveat, and your lordship affidavit in support of caveat. What he has done, he has gone before the district delegate at Alipur and filed a probate application claiming that there is a subsequent will.
Correct.
He is not disputing that there is an earlier will.
Correct.
He is saying that there is a subsequent will dated 18th of December 2019.
Second will.
Second will. And his
18
contention,
September
18th of December 2019.
18 December 2019.
And his contention is that no, first will was executed, no problem. There is a subsequent will, so subsequent will prevails.
Last will prevail.
So that's the only contention he has taken. He, without filing any affidavit in support of caveat, what he has done, he has gone there and filed a probate application.
Correct.
Now, your lordship kindly sees my affidavit in opposition. I will not take too much time. Lordship, kindly take page. Affidavit in opposition.
Yes.
Page 37, your lordship kindly sees. And this order was passed on 29th of January 2024. Page 37.
Objector namely
Promit Kumar Mitra.
files W.
Prashomit Kumar Mitra files WO. Under these circumstances, where the matter appears to be contentious, I consider it to return the original probate application and affidavit of assess for filing the same before the proper forum. Till date, nothing has been filed by them. And moreover, in my affidavit in opposition,
That's why I'm asking whether if they have
3 years is the Supreme Court has recently said 3 years, within 3 years, I have to file.
I am not on that. Whether in terms of the order dated 29th of January 2024, have you filed any probate suit before the district judge of the Alipur court?
My lord, it has been ready, but the attesting witness mother had died. She has gone to Pune. My lord, attesting witness has to come and swear an affidavit.
Yes. Yes.
My lord,
Then-
so far, my lord,
situation. Now, in the affidavit in reply or in the application, your lordship, he has not disclosed the copy of the will dated 18 December 2019. So today, Your Lordship, the situation is the first will is in existence, properly executed. He is not disputing that. Now today, if the second will is not there, Your Lordship, he cannot restrict my, Your Lordship, grant of probate of the first will.
My lord, only I am asking, my lord, bank could did not be,
Just a minute, Mr.
my lord. My lord.
Unless and until he produces that particular will before the honorable court, Your Lordship, he cannot, Your Lordship, agitate anything.
That is correct, Mr. Dasgupta, Sengupta. Problem is that admittedly he is one of the son. Correct. He filed caveat, but rightly, wrongly has not filed the affidavit in support of caveat. He filed the application, has not. If it is there, then situation would have been different. You know better.
Logic.
Correct. But he, as of now, there is no case with regard to the second will.
Logic.
So that chapter is closed. If they will take a step, that is the different aspect. Now, as president, so he is the son. He should get an opportunity.
Exactly. I am not standing on the way. Your Lordship, in any event, if he does not produce this 18th December 2019, he has a right to oppose my will.
Correct.
Lordship, my attesting witnesses are, Your Lordship, advanced stage.
Correct.
Lordship, kindly expedite, Your Lordship, by probate application.
What I propose,
Yes.
let the affidavit of affidavit of caveat may be accepted.
May be accepted.
Correct. Maybe
Discovery inspection.
I will fix the short date.
Yes, Your
I
Lordship.
will let the testament
Contentious court number
call may be taken, number may be given, testamentary suit number may be given. I am fixing after a week. The discordant inspection, only the will is there. Discordant inspection can be completed within a week.
Lodge.
And I proceed with the matter.
Next date may be fixed for Your Lordship, the framing of the issues, Your Lordship.
Yes.
I want to proceed, Your Lordship, unless.
No problem.
Lodge.
Well,
So appearing for the petitioner. So appearing for the caveator. Caveator has filed an application being GA2 of 2024. GA2 of 2024. Praying for condoning the delay in filing the affidavit in support of caveat. Full stop. The counsel for the caveator submit that the caveator is the only son of the testator who died on second, only son of the testator. Full stop. Full stop. Counsel for the caveator submit that the copy of the citations were served upon the caveator, but due to caveator, and in the meantime, the caveator has filed a probate application before the learned court of
District Delegate Alipur.
District Delegate at Alipur with respect of the alleged second will. Full stop. After issuance of the citation in respect of the said case, one of the legal heirs has appeared in the said probate matter, and accordingly the district delegate had written the probate case as a contentious cause, had given liberty to the contentious cause and given a liberty to the caveator to file the same before the concerned district judge. Full stop. Counsel for the petitioner submit that though the learned district delegate Alipur has given liberty to file appropriate case before the learned district judge, but the caveator has not filed any case before the learned district judge as they have not received any notice till date. He further submit that the caveator is claiming with regard to the second will, but the second will has not been disclosed in the present application. Counsel for the petitioner submit that the attesting witnesses of the will of the present case are at this advanced stage, and only to delay the matter, the caveator has not filed the affidavit in support of caveat within the prescribed time. And as such, the application filed by the caveator is required to be dismissed. Heard the learned counsel for the respective parties. This court has not gone into with regard to the second will, as the second will is not on record. It is also admitted that in terms of the leave granted by the district delegate at Alipur, the caveator has not filed any probate case or suit before the learned district judge. Full stop. Admittedly, The caveator is the son of the testator. Thus, this court is of the view opportunity should be given to the testator, to the caveator, to object for grant of probate of the will. Accordingly, delay in filing the affidavit in support of caveat is condoned. Full stop. Affidavit in support of caveat is accepted. Have you received the copy?
Yes, yes, sir. We have received.
Accepted. Full stop. The let PLA number one full stop. GA number 2 of 2024 is disposed of. Full stop. The PLA, the department is directed as the full stop, as this court has accepted the affidavit in support of caveat of the caveator. Accordingly, the PLA 124 of 2021 be treated as a contentious cause. Full stop. The department is directed to assign the testamentary suit number within a week from date. Full stop. GA number so and so disposed of. List the matter on today we are on 8 on 21st of January 2024. 2025.
Affidavit in reply may be kindly taken.
Affidavit in reply filed by the caveator be kept with the record.
Well, it's only one thing, well, may Lordship can add, that it will help both the parties. When any observation in this order will not prejudice the learned district judge.
I have not, this court has not made any observation. That's why I made it clear that this court can
my lord.
Second will. That is not on record.
And on that day, Your Lordship, I'll pray for the Your Lordship inspection and process.
Yes, come on that day then,
Yes, sir.
because if the testamentary suit number will be given, then I pass appropriate.
Lordship. I'm grateful.
Item number 48 is my application for grant of letters of administration. On the last occasion, I had finished off with the attending witness because he was the eyewitness to the will, and thereafter the matter was directed to be posted for hearing today. So if your lordship kindly takes up the will, which is exhibited as Exhibit A.
Yes.
The deceased testator was one of the owners of a cooperative housing society flat, which he, by way of his will, had bequeathed in favor of Ramakrishna Mission, Belur Mott. Under this particular will, your lordship will find that he named the as executor the Ramakrishna Mission, Belur Mott, President Maharaj of Ramakrishna Mission, Belur Mott.
President of the Belur Mott
Yes,
as
the executor. Yes.
to obtain the
Now
probate.
he had renounced his executorship in terms of Section 230 of the Indian Succession Act, and thereafter this application was filed. Umpteen number of attempts were made.
This flat is in society.
Yes, it's a housing cooperative society flat.
Do you have any knowledge with regard to the society's regulation? Because there are some societies
Yes.
which do not accept the societies or the another persons be a member.
My lord, pursuant to the direction of this honorable court, there were publications made, paper publications were made, and nobody came forward.
Okay.
And this was marked as non-contentious cause. But because we could not get hold of the attesting witnesses, therefore we had volunteered that we would get the will proved in solemn form instead of common form. And that is why, my lord, I'm placing reliance on Section 69 of the Indian Evidence Act, which now stands as it stands is Section 68 of Bharatiya Saksha Adhiniyam,
We go by the
2020.
old because
But I'll go by the old act because it is the matter was
red
filed
color,
prior thereto.
that color.
So Section 69 is the relevant section here, not Section 68, which is the general law, otherwise would have been applicable. 69, if I may just place before your lordship, proof where no attesting witness found. If no such attesting witness can be found, or if the document purports to have been executed in the United Kingdom, we don't come under the second part of it. It must be proved that the attestation of one attesting witness at least is in his handwriting, and that the signature of the person executing the document is in the handwriting of that person. Now, in order to comply with this, I had called before this honorable court the eyewitness who was the attending witness. Now, in course of his examination, what had transpired was, if your lordship kindly looks into the deposition once, in answer to question number 2, in answer to question number 2, he had deposed that Shradesh Chandra Kaur, who is the testator, had executed the will on 1st of June 2010, and at that time he was a bachelor. One of his brothers was a monk at Ramakrishna Mission, Belur Math, and that is why he had asked someone to be present from the side of Belur Math at the time of execution of the will. By way of will, he wanted to give his property, that is the flat, to Belur Math, and that is why, to represent Belur Math, he was asked to go to the place where the will was being executed. So I had shown the document, and he said that he identified the will, and accordingly the will was also exhibited. Then I also asked in question number 8, my lord, if kindly looks at, please tell this honorable court what happened on that day when you visited the premises of the deceased testator. So when I visited his place, that is the place of the testator, 2 of his neighbors were present in his flat, and 1 advocate was also present. I was also present there. At first, Shradesh Chandra Kaur put his signature on the will. Thereafter, he asked 2 witnesses to put their signatures. The name of the witnesses are Shujit Kumar Kaur and Gopal Chandra Banerjee. These 2 persons are the residents of the same complex. Then I asked about the original. He identified the original will. Then I also asked that kindly go through the will and tell this honorable court whether you find any signature in this document that you can identify. I find the signature of Shradesh Chandra Kaur at page number 3 of the will. Then he encircled it, and that was also marked as exhibit. Thereafter, your lordship will find that at internal page number 3, the relevant question is 14. Can you identify the other signatures which are appearing apart from one that you have just identified? Yes. Question 15. Please name them. The first signature is of Shujit Kumar Kaur, and the second one is of Gopal Chandra Banerjee. Their signatures were also tendered and exhibited. Then, have you filed any affidavit in this proceeding? He said, yes. I'm showing you a document. The affidavit was shown, and this he identified his affidavit. Now, in this proceeding, my lord will find that pursuant to your lordship's last order of 19th of December 2024, the will was exhibited as Exhibit A. The signature of the testator, wherever appearing in the will, were tendered and exhibited as A by 1, A by 2, and A by 3. Signatures of the attesting witnesses were also identified, marked as A by 4 and A by 5. And the attending witness had filed his affidavit, which was also tendered in evidence and marked as Exhibit B, and his declaration was marked as Exhibit C. Now, so far as affidavit filed by the attending witness is concerned, if I may just quickly take your lordship through that once. The affidavit of attesting witness was affirmed on 16th of March 2021.
What is the name?
The person's name is Arnab Guho. The affidavit is of the eyewitness Arnab Guho, affirmed on 16th of March 2021. My lord, in my copy, it is stitched with the application, and it is appearing at page number, I don't know, annexure D.
Yes. Yes.
So, in the affidavit, the relevant paragraphs are 1 and 2. These are the 2 paragraphs which I need to place before lordship. I am the eyewitness to the last will and testament of Shradesh Chandra Kaur, deceased above named, which bears the date so and so, that on 1st June 2010 at the testator and in his presence, I, Arnab Guho, and attesting witnesses Shujit Kumar Kaur and Gopal Chandra Banerjee, at the venue were present and saw that the said testator Swadesh Chandra Kaur signed the said will on every page as the same now appears thereon. At the request of the said testator and in presence of the said testator, the said attesting witnesses Shujit Kumar Kaur and Gopal Chandra Banerjee attested and subscribed their respective signatures in the said will in the presence of the said testator and in the presence of each other. I further say that the signature of Swadesh Chandra Kaur, the above named deceased, appearing on every page in the said will is his true and original signature. The signatures of attesting witnesses Shujit Kumar Kaur and Gopal Chandra Banerjee appearing in the said will are the original signatures. Then paragraph number 2, I state that the testator was in sound mind and good health at the time of execution of the will. And then his documents are also annexed to his affidavit. So these are the two relevant paragraphs in his affidavit which I had to draw attention of before your lordship prior to taking your lordship through the process which was issued through this honorable court.
So that I got it. That is
Yes, so
affidavit.
those are all there before your lordship, and by abundant caution, I'm carrying this judgment, which is reported in 2008, volume 14, Supreme Court cases, page number 754. This is report. This is the case of Babu Singh and others versus Ram Sahai.
Yes.
I'm drawing reference to paragraph number 17 of this judgment. Because under normal circumstances, in terms of section 63(1)(c) of the Indian Succession Act, read with section 68 of the Indian Evidence Act, I had to bring the attesting witnesses, at least one of the two attesting witnesses before this honorable court to get the will proved. But in absence of both, section 69 of Evidence Act triggers in, and I'm relying on this provision and the case law. Those are my respectful submission before your lordship.
Okay. So appearing for the petitioner. The petitioner has filed the present case for grant of probate.
My lord, grant of letters of administration.
Sorry. For grant of letters of administration of the last will and testament dated 1st June 2010 of the testator Sujit Kumar Kaur.
Swadesh Chandra Kaur.
No, kindly.
Testator is Swadesh Chandra Kaur.
Swadesh.
Swadesh Chandra Kaur.
SWADSH. Swadesh Chandra Kaur. Okay. Consent for the petition submit that the testator has executed his last will and testament in presence of two attesting witnesses, namely
Shujit Kumar Kaur and Gopal Chandra Banerjee.
Shujit Kumar Kaur and
Gopal Chandra Banerjee.
GOPL Gopal Chandra Banerjee, while possessing good health and fit state of mind. Full stop. Counsel for the petition submitted. After filing of the present application, citations were issued, but none has come forward to file any objection for grant of probate, and accordingly, the department has submitted no caveat certificate on 6th September 2024. 6th September 2024, stating that as per record, no caveat has been entered against for grant of letters of administration. Counsel for the petition submit that though the testator has executed his last will and testament in presence of two attesting witnesses, but both the attesting witnesses were not available, were not traceable, and thus the petitioner failed to bring the said two attesting witnesses to prove the will. Accordingly, the petitioner has proved the said will in solemn form by examining one of the witness who is to be a attending witness in whose presence the testator has executed his last will and testament by appointing the petitioner as the sole executor of the
No, my lord, that would be wrong because the appointment was given.
And in which क्या बोला? Huh? To prove that the testator has executed his last will and testament in the presence of the attesting witnesses as well as in his presence. Full stop. And his presence. Full stop. Full stop. Counsel for the petitioner has drawn the attention of this court to the evidence of the PW1, namely Arnam Ghua, who is the attending witness of the will, in which he has categorically stated that the testator Swadesh Chandra Kaur had executed his last will and testament on 1st of June 2010 by possessing good health and fit state of mind in presence of two attesting witnesses. And the testator and both the attesting witnesses have signed the said will in his presence. And accordingly, the will was exhibited as Exhibit A, and signature of the testator were marked as Exhibit A by
1, A by 2, and A by 3.
A by 1, A by 2, and A by 3. As well as the signature of the attesting witnesses were marked as Exhibit A by 4 and A by 5. Full stop. During the evidence of the attending witness, the affidavit filed by the attending witness were also marked as Exhibit B, and signature of the said witness as marked as Exhibit BY1. Concern the submission made by the counsel for the petitioner, peruse the original will. Full stop. It is signed from the death counsel for the petitioner submit that the testator Swadesh Chandra Kaur died on 10th November 2010, and the death certificate is also enclosed with the probate application. Full stop. That was not marked.
No, that was not.
Full stop. Considering the submission made by the counsel for the petitioner, produce the original will, death certificate, the no caveat certificate, and the evidence of the PW1. This court find that the PW1 in his evidence has categorically stated that the testator has executed his last will and testament while possessing good health and fit state of mind in presence of two attesting witnesses. Though the two attesting witnesses have been not brought before this court, but it is the specific case of the petitioner that two attesting witnesses were not traceable. Accordingly, the petitioner has taken the recourse of Section 69 of the Evidence Act and has examined the witness being PW1. The counsel for the petitioner has relied upon the judgment in the case of Babu Singh and others versus Ram Sahai alias Ram Singh, reported in 2018, volume 14, 2008, volume 14, SCC 754, wherein the Honorable Supreme Court held that, set out paragraph 17. Set out, italic. Considering the above, this court find that the petitioner has proved the will through the attending witness, as the attending witness has categorically stated that the testator has executed his last will and testament in his presence and in presence of the attesting witnesses. Accordingly, the petitioner is entitled to get the probate, get the letters of administration. The letters of administration. The department is directed to issue letters of administration of the last will and testament dated
1st June
2010, subject to furnishing of surety of 5 lakhs with 2 sureties. 5 lakhs with 2 sureties. So and so dispute.
Grateful to Lordship.
Lord,
I appear for the propounder. My lord, probate was granted back in March 2023. So thereafter, my lord, more than 1 year have passed. Lord, they have filed recently an application for revocation. Lord, since revocation, Lord, hanky panky, but again they are not coming. Frivolous
appearing?
grounds for revocation application, nothing in the matter. I have filed opposition. They have again not used reply. He is not the daughter-in-law. She is the daughter-in-law.
The applicant.
The applicant
Who
is
has
the
filed this
daughter-in-law.
application for revocation?
Citation issued in her favor.
What is the ground for revocation?
That not because the name of the propounder, rather the beneficiary, and not the wife of the widow of the testator, and her name matches. That's why we have received the citation in her name. That's the case made out. Not affidavit service of the department, everything is on record.
But nobody, I am giving one chance. Let they come.
This is perhaps the fourth or fifth time, Lord.
No, but the last occasion they appeared.
Yes, last occasion.
So Aditya Mandal had
They
appeared.
appeared.
So today is the first date before this court now. Let it be. I am giving after fixing a one after a 1 week. If they will
Whenever
not come.
please. Lord,
So-
Lordship's pleasure to fix it as a last chance. Lord.
That's right. So and so appearing for the propounder. None appears on behalf of the applicant. Applicant has filed the present application being GA2 of 2024, praying for revocation of the probate granted by this court. As none appears on behalf of the applicant, for the interest of justice, the case is adjourned for a week. Let the matter appear on 17th of January 2025. It is made
Lord,
clear.
not 17 plus 17. I am in difficulty. Lord,
22nd.
22nd
January 2025. It is made clear that on the date fixed, if the applicant will not appear, necessary order will.
Read.
Next. Yes.
Lord, item number 50, my lord.
Yes.
I am for the petitioner, my lord. I filed the application for grant of probate, my lord. My lord, last occasion, the learned advocate for the defendant, caveator, my lord, appeared and my lord submitted before your lordships that his client is not willing to proceed with the case and handed over my letter written in Bengali. My lord, your lordships directed to hand over to file a submit a translated copy of this same, my lord. Today I find that he's not appearing, my lord, before your lordship. Now, my lord, my witness is ready. If your lordship kindly.
Today is not present.
Today she is not present, my lord. I find she is not present, my lord. But on the last occasion, my lord, she appeared and submitted before lordship that.
Yeah, witness is present. It's a witness action.
Yes, my lord. Yes. My lord, on the last occasion, your lordship directed that it will appear, it will be heard as an undependent suit.
Issue framed. Let the witness examine.
Yes,
Matter
my
can
lord.
be
Yes.
discussed. The witness is present.
Yes.
Bring the witness. Do you speak English? Who is he?
My lord, he's one of the attesting witness, my lord. Not related with the TA.
What is the name?
Gautam Kumar Bosu. Gautam Bosu.
Yes.
বলুন, আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো,
আমি যা বলবো সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যা বলবো না,
কোনো কথা গোপন করব না।
কোনো কথা গোপন করব না।
আপনার নাম?
গৌতম বসু।
গৌতম বসু। বানানটা বলবেন একটু ইংরেজিতে।
GAU
GAU
TAM
TAM
BASU।
বাবার নাম?
son of late রবীন্দ্রনাথ বসু।
রবীন্দ্রনাথ বসু, লেট রবীন্দ্রনাথ বসু। আপনার বয়স?
61 years।
61 years। কি করেন আপনি?
মহড়া ল ক্লার্ক of হাওড়া কোর্ট।
অফ হাওড়া কোর্ট। আপনার বাড়ির ঠিকানা আস্তে আস্তে বলুন।
12/1
12/1
by 1
12/1 আবার by 1
সদগোপাড়া
সদগোপাড়া
SAD
সদগোপাড়া
GOP সদগোপাড়া পোস্ট অফিস বৈদ্যবাটি
বৈদ্যবাটি
PS শ্রীরামপুর
PS শ্রীরামপুর
ডিস্ট্রিক্ট হুগলি,
District Hooghly. Pin code
7122
7122
আবার 22
আবার 22 712222 ধীরে ধীরে বলবেন, হ্যাঁ? ইয়েস ম্যাডাম। উইল আপনাকে দেবো না এটাকে? আপনি ফটিক চন্দ্র সাউ এবং রেণুকা সাউ নামের কাউকে কি চেনেন?
হ্যাঁ চিনতাম,
ইয়েস চিনতাম বললেন।
হ্যাঁ চিনি।
I know them. Yes, I know them. তাদের সম্পর্ক কি?
স্বামী স্ত্রী।
They are husband and wife. Husband and wife. আপনি কিভাবে তাদের চেনেন?
আমার সেরেস্তার ক্লায়েন্ট ছিলেন।
They are the clients of my Sheresta. They were the clients of my Sheresta. THM.
document. This state my lord, what is the document about? I'm showing you one document. This tell my lord what this document about.
আপনাকে একটা ডকুমেন্ট দেখানো হচ্ছে, ডকুমেন্টটা দেখে মাই লর্ডকে বলুন যে এই ডকুমেন্টটা কি ব্যাপারে বা এটা কি।
এটা ফটিক চন্দ্র সাউ আর শ্রীমতী রেণুকা সাউ একটা উইল বা চরমপত্র করে দিয়ে গেছিলেন।
This is a will which has been executed by Sri Fotik Chandra Shau and his wife Srimati Renuka Shau. যখন এই উইলটা এক্সিকিউট করা হয়, তৈরি করা হয়, তখন কি আপনি সেখানে উপস্থিত ছিলেন?
আমি ছিলাম।
Yes, I was there. I was present there.
Who has signed in the will?
কে সই করেছে উইলে?
উইলে ফটিক চন্দ্র সাউ উনিও করেছেন, রেণুকা সাউ উনিও করেছেন।
The will was signed by Fotik Chandra Shau and his wife Renuka Shau. Both Fotik Chandra Shau and his wife Renuka Shau.
Has it been signed in your presence?
ওনারা কি আপনার উপস্থিতিতে সই করেছিলেন? Yes, they have signed in my presence. In my sir, in my presence.
Yes.
Where the will was executed? উইলটা কোথায় এক্সিকিউট করা হয়েছিল? কোন জায়গায় বসে?
হাওড়ায় আমাদের সেরেস্তা হাওড়া কোর্টে।
At our Sheresta in Howrah Court. কার সেরেস্তাতে?
কেদারনাথ মুখার্জি অ্যাডভোকেট।
At the Sheresta of Advocate Kedarnath Mukherjee. Advocate Kedarnath Mukherjee. এটা কি হাওড়া কোর্টে?
হ্যাঁ।
Yes. 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 আচ্ছা, কে আপনাকে বলেছিল যে এখানে একজন অ্যাটেস্টিং উইটনেস হিসেবে সই করতে? কে আপনাকে বলেছিল উইলে?
এই এক্সিকিউটররা ফটিক চন্দ্র সাউ আর রেণুকা সাউ ওনারা দুজনেই বলল প্রথমবাবু আপনি একটা এক্সিকিউটর হিসেবে উইটনেস হিসেবে সাইন করুন।
Both the testator and the testatrix, namely Fotik Chandra Shau and his wife Srimati Renuka Shau, Renuka Shau requested me to sign as an attesting witness.
What the person signed in this document, please tell the name one after another.
এই ডকুমেন্টে কে কে সই করেছেন সিরিয়ালি পরপর বলুন, কে কে সই করেছে, প্রথমে কে করেছে তারপর কে করেছে?
প্রথমে ফটিক চন্দ্র সাউ করলেন।
At first
ফটিক চন্দ্র সাউ
Fotik Chandra Shau put his signature on this will.
তারপর রেণুকা সাউ করলেন।
After that Srimati Renuka Shau put her signature.
তারপর
After that
একজন উইটনেস গোপাল মান্না,
a witness namely Gopal Manna put his signature on this will.
তারপরে আমি করলাম।
After that I put my আপনার নাম?
শ্রী গৌতম বসু।
I Sri Gautam Basu put my signature.
তারপরে তো উকিল বাবু ড্রাফট করেছেন শ্রী কেদারনাথ মুখার্জি।
And lastly the advocate Kedarnath Mukherjee put his signature on this will. Kedarnath Mukherjee put his signature on the will.
দেন না এরপরে উকিল বাবু টাইপিস্টকে বলে আপনি টাইপ করেছেন বলে সই করুন, তারপর উনি টাইপিস্ট উৎপল চ্যাটার্জি উনিও সই।
After that the typist Utpal Chatterjee on request of our advocate, put his signature on this will. আপনি কোন এখতিয়ারে এই ডকুমেন্ট আপনি এই ডকুমেন্টে
Take the microphone.
আপনি এই ডকুমেন্টে সই করেছেন কোন এখতিয়ারে কি হিসেবে সই করেছেন আপনি
উইটনেস হিসেবে সাইন করেছি
as a witness I put my signature on this document as a witness I put my signature on this document.
Can you identify the signature of Photik Chandra Shau and Renuka Shau in this document? হ্যাঁ
ফটিক চন্দ্র সাউ এবং রেণুকা সাউয়ের সই আপনি শনাক্ত করতে পারবেন? Yes I can.
আচ্ছা please encircle their signature with blue color.
ফটিক চন্দ্র সাউ এবং রেণুকা সাউয়ের সইগুলো আপনি ব্লু কালার দিয়ে এনসার্কেল করুন। The witness encircle the signature.
প্রত্যেক পাতাগুলো করে যাবো?
প্রত্যেক পাতাতেই করবেন তো?
Yes, all pages.
All pages. The witness encircled the signature of Photik Chandra Shau and his wife Srimati Renuka Shau, appearing on all pages with blue pencil. Blue pencil.
Well, this signature should be marked exhibit.
I will take. Let you complete, then I will take all together.
My lord.
Question করলো? Encircle পর্যন্ত হলো, encircle করুক। ওটা লিখে দিও, witness encircled.
Yes, next.
Oh, sorry.
নিয়ে গেছে?
Where is your signature in this document?
স্যার হয়নি স্যার।
ওটা হয়নি না, জজ সাহেব বললেন নেক্সট থাকবে স্যার।
আপনার সই কোথায় আছে এই
কেন
ডকুমেন্টে?
ঠিক আছে करने दो पहले। Let him do
আজকে করো, আজকে একজন করবে বাজে। আচ্ছা ঠিক আছে বলো, আমার সিগনেচার এখানে আছে।
কত পাতা একটু বলুন?
পেজ নাম্বার 9.
My signature appears at internal page number 9 of the said document.
Please encircle.
Internal page number 9 of the said document.
Please encircle your signature with red color.
আপনার সইটা লাল কালি দিয়ে গোল করুন। The witness encircled his signature appearing at internal page number 9 of the said document with red pencil. The witness encircled his signature appearing at internal page number 9 of the said document with red pencil.
Do you know Gopal Manna? You have stated.
আপনি কি গোপাল মান্নাকে চেনেন, যার নাম এক্ষুনি আপনি বললেন?
গোপাল মান্নাকেও চিনি। Who is he?
আমি গোপাল, yes I know গোপাল মান্না। উনি কে? গোপাল মান্না কে?
বিকে পাল টেম্পল রোডেই থাকতেন।
He is a resident of BK Pal Temple Road.
He has signed in this document.
উনি কি এই ডকুমেন্টে সই করেছেন? Yes.
Under what capacity? উনি উইটনেস হিসেবেই সাইন করেছেন।
As a witness, he also put his signature on the said document.
Please identify the signature of Gopal Manna and encircle with red color.
আপনি ওনার সই চেনেন? Yes, I know his signature. ওনার সইটাকে লাল কালি দিয়ে গোল করুন। The witness encircled the yes sir, yes sir. The witness encircled the signature of Mr. Gopal Manna appearing in the said document with red pencil.
Did all the persons signed in your presence? All the persons signed here in your presence?
যারা সবাই সই করেছেন সবাই আপনার উপস্থিতিতে সই করেছেন তো?
Who signed first? এটা বলে দিয়েছে কে কে পরপর সই করেছে? বলেছে তো, ঠিক আছে। Can you say who accompanied Photik Shau and Renuka Shau to the court premises?
কোর্ট চত্বরে ফটিক সাউ এবং রেণুকা সাউ মানে কার সাথে এসেছিলেন বলতে পারবেন?
ফটিক সাউ, রেণুকা সাউ, গোপাল মান্না, এনারা তিনজনে একসঙ্গে এসেছিলেন।
Photik Chandra Shau and Renuka Shau was accompanied by Gopal Manna to the court premises.
Before putting your signature, have you verified what this document about?
আপনি সই করার আগে কি ডকুমেন্টটা পড়ে দেখেছিলেন যে এই ডকুমেন্টটা কি ব্যাপারে?
হ্যাঁ দেখেছি।
Yes, I have read the document.
What is your conclusion regarding the document?
এই ডকুমেন্টটা পড়ে আপনার কি মনে হয়েছিল? আপনার নিজস্ব মতামত কি?
এনারা দুজন, ফটিক বাবু আর রেণুকা সাউ দুজনে তার পুত্রদেরকে উইল করে সম্পত্তি দিয়ে যাচ্ছেন।
My conclusion was Photik Chandra Shau and his wife Srimati Renuka Shau are giving their properties to their son by executing this will.
Acha, what was the condition of health of Photik Shah and Renuka Shah when they had executed the will? Condition of health.
আচ্ছা, ফটিক চন্দ্র সাউ এবং রেণুকা সাউয়ের শারীরিক অবস্থা কিরকম ছিল যখন ওনারা এই উইলটা এক্সিকিউট করেছিলেন?
দুজনেই ভালো ছিলেন, ওনারা হেঁটে এলেন, আমার সঙ্গে ভালোভাবে কথাবার্তা বলেছেন
They
সবকিছু।
were at good health. They came to the court by walking. They exchanged word with me. They were quite normal. They were quite normal, healthy.
Now, were they in a position to appreciate that they were going to execute a will? Were they in a position to appreciate that they were going to execute a will?
তারা কি জানতেন বা বুঝতে পারছেন যে তারা একটা উইল, মানে ওই মানসিক অবস্থায় ছিলেন কি তারা, যে তারা একটা উইল এক্সিকিউট করতে যাচ্ছেন? Yes.
Where the will was registered?
উইলটা কোথায় রেজিস্টার হয়েছিল?
ডিস্ট্রিক্ট সাব রেজিস্ট্রারে রেজিস্ট্রি হয়েছে।
At the office of the district sub
registrar.
registration of Howrah.
Were you present at the time of registration of the will?
রেজিস্ট্রেশন হয়েছিল তখন কি আপনি উপস্থিত ছিলেন? Yes,
Well,
I was present.
The will be marked as Exhibit A, comma, signature of the testator and testatrix are marked as Exhibit A by 1, A by 1 to A by 9. A by 1 देख लो हाँ, and signature of this witness is marked as Exhibit A by कितना है, 9 है 10 है?
My lord, 9 signatures, Photik Chandra Shah and Renuka Shah, and 1 signature at the last, at the bottom of the page.
A by 9, 1 A by 10, A by 1 to A by 10, huh? And signature of this witness A by 11, and signature of Gopal Manna is A by 12.
It has not encircled this signature.
Encircled.
এটাও করে নীল কালি দিয়ে, নীল দিয়ে এটাও এনসার্কেল করুন।
Both signatures are there. That's all. Close. Witness.
The executor will cite as witness.
What the executor will say?
Well, the death certificate and all those things are
okay. When?
Fix a date, in the next week.
So and so appearing for the petitioner. Get on. One witness is present. List of witnesses is examined. During his examination, the will is marked as Exhibit A. Signature of testator and testatrix were marked as Exhibit A by 1 to A by 10. Signature of this witness are marked as Exhibit A by 11. And signature of the another attesting witness is marked as Exhibit A by 12. Na? 12. The evidence of this witness is closed and discharged. Full stop. Counsel for the petition submitted, he will examine another witness. Accordingly, case adjourned. Let the matter appear on 29th January 2025 for examination of further witness.
Item 54, Lordship.
Yes. Yes.
Item 54, yesterday it was the first one.
Yes, yes.
Unfortunately, today next 2 days, Lordship, for personal reasons, I will not be in court, Lordship.
What is the matter?
That's that caveat discharge matter, Lordship.
Who is for the other side?
That yesterday somebody appeared.
Lordship,
54.
Lordship, Advocate Nandini Mitra was just now. Advocate Nandini Mitra, she was there, Lordship. But hearing that your Lordship will rise, Lordship, she has gone to the other court. Lordship, it may be kept any day, your Lordship, please.
Which court is sitting now?
Lordship?
Which court is sitting now? 130? Other than this court? Tomorrow you will not be available.
Monday,
एक काम करो, Monday ना इसको top में कर दो.
Monday.
Top में कर.
Lordship, Monday.
Monday. It will be come as a item number 1 in the testamentary matter.
Oh,
Item number 31 in commercial division.
No, testamentary, yes.
No, it's
Not
not
testamentary.
Well, we are filing our affidavit in opposition.
Which one?
Item number 31.
Commercial division, there is no 31 today. Only 9 matters are there.
Non-commercial. Non-commercial. I'm sorry, sir.
Non-commercial division.
Item number 31.
Ah.
We are filing our affidavit in opposition, my lord.
Which for the other
side is
side?
not there.
You do one thing. I am not recording. You serve the copy. Come when the matter will be taken. I will accept.
Or 2 p.m. I have got some difficult. My lord, instead of 2 p.m. make it
2 p.m. I don't know because fixed matters are there. It is in the list. You want to file the affidavit in opposition. Matter is not called. You have served. If it served, come when the matter is called. I will take the affidavit on record. That's all.
My lord, item number 52, just 1 minute, it will take 1 minute.
Yeah.
And the direction was given to sub upon my affidavit in support of cabinet and to pay the cost. I have complied with. Only the suit number has not been.
Kindly see
50
that the order,
order.
dated, my lord, item number 52, my lord.
Ah.
Order dated
Page 3, last
10
page.
December
The last page.
My
Last.
lord, by my letter, my lord, I have informed the
Okay. You do one thing. Manutosh, उनको बोलो suit number देने के. It will be done.
Item number 51.
52, na?
Yes.
So my officer will take the number from the department.
Place it on.
place it.
Come on the list. It will come in the list. Day after
If
tomorrow.
you lost to kindly fix the date, my lord.
It will be in the list.
Very well.
Sign. It will be in the list.
Yes. Very well.
Don't worry.
Item number 51.
Ah.
My other side is here, my lord.
Ah.
It is Association Lordship remembers past the direction for
Officer, officer.
and your lordship will try whether there are cases of interest. Yes. They have filed this affidavit. My lord. I'm seeking yesterday evening. 50 pages. My lord, I'm seeking to file a reply. Only one thing, my lord. Only one thing, my lord. File the affidavit in opposition. So, my lord, not be an affidavit. I thought
Let us see what.
Yes, file a 7 except, my lord, the maintainability of the affidavit.
That is already there. So and so appearing for the executor. So and so appearing for the caveator.
Yes, my lord.
Caveator?
No, I intending caveator. That issue.
Caveat, not a caveat.
Proposed
Yes,
caveat.
yes. That issue, will, your lordship will.
They have a
So and so for
I have a
the
prior
intending
will.
caveator.
Prior will.
Intending caveator. Full
Yes,
stop.
that issue will
The
decide.
intending caveator has filed affidavit in opposition.
Yes.
After serving the copy to the learned counsel for the executor, let the same be kept with the record. Counsel for the executor press time to file affidavit in reply by keeping the maintainability open. Stop. That affidavit in reply be filed within 2 weeks. In 2 weeks, police release the matter on 5th of February.
Wait.
Lordship item 70 only for issue of citation.
Huh?
For issue of citation.
Come tomorrow, meeting.
in this matter, my lord, I am for the defendant. There is one application by me.
My lord, I am for the plaintiff. There are 4 applications which your lordship is hearing. 4. GA 1, 2, 3, 4. And
What are the applications?
Yes, my lord. First one is my interlocutory application where injunction has been prayed. Your lordship granted an order which will expire on 9th. The second one, he filed a dismissal application, demurrer application, my lord, possibly under Order 7, Rule 11. The third one is my application for, my lord, summary judgment, summary eviction under Chapter 13A of the original side rules, not Order 13, because this is non-common, it's Chapter 13A, original side, summary eviction. And the fourth one, my lord, is by him extension of time to file written statement, which will obviously, my lord, if your lordship is not inclined to pass Chapter 13A, your lordship will grant. So my humble prayer is, my lord, that your lordship hears all together.
Yes.
He can
Readings completed all.
Yes, pleadings are
All pleadings completed.
complete within time.
So may I indicate what is the matter about? Now, by 2 agreements, 2 premises in the same building was let out by the plaintiff landlord to the defendant tenant. Now, one was of September 97, which comprised the ground floor, first floor and the mezzanine. And the other was of June 97, which comprised of second, third floor and the roof of the building. So separate premises, 2 agreements, different dates, but between the same parties. Now rent for the first one was rupees 2,150 plus 1,000 rupees service charge. And for the second one was 3,000 rupees.
Total.
Total. Now, from the tenancy agreements, which are more identical, almost entered into all in both in 1997, there is a salami paid for 3 lakhs of rupees or pagri. And there is a clause that landlord will not evict the tenant on these grounds. And there is a permission given to the tenant for addition of alteration and also permission given to induct subtenants. So if you look, and there was no tenure, this was month-to-month tenancy. Now, if you look into the agreements in totality, the agreement was of a perpetual nature with a high salami. Normally in monthly tenancy, there is no salami. Now, these agreements, they did not require registration because
month to month.
It was month to month new registration under Section 17(1) of the Registration Act. Now, by 2 notices dated August 24, under the West Bengal Premises Tenancy Act, the plaintiff landlord sought to enhance rent. Now, my lord, under the West Bengal Premises Tenancy Act, landlord unilaterally cannot increase rent. If he can ask the tenant agrees, well and good. Otherwise, he has to approach the rent controller. Landlord did not approach the rent controller. Now, initially, the tenant did not pay the amount. Then a word was sent to the tenant that you pay, there is about 7 lakhs due. You pay this amount, then we'll sit for a discussion for negotiation. So that was a precondition. So the tenant paid that amount and recorded by a letter that when we will sit for negotiation. You say that unless the amount is paid, we will not sit for negotiation. So that was not a payment accepting the rent, but as a deposit. One can say as a deposit, as a precondition to sit for a discussion. Now, as I said, neither any application was made to the rent controller. So
the rent did not increase, and rent was 2150, that's 3,000 in both cases, and governed by West Bengal Presidency Act. Now, even the notice enhancing rent was given under West Bengal Presidency Act. Now, if you take that amount, that 7 lakhs we have paid, and the current rent, about 2 lakhs and odd has been paid in excess to the landlord. So now there is no default as on date. Then, my lord, for non-payment of the enhanced rent, alleged enhanced rent, plaintiff issued a notice to quit under Transfer of Property Act. No notice under West Bengal Presidency Act has been issued. And moreover, the notice should be 30 days. In this case, 30 days notice was also not issued. Then this eviction suit was filed. Now, the rent was not increased in accordance with law. So the new, whatever the enhancement being claimed by the plaintiff is not binding on the defendant. And there are cases of our court also saying that even parties by agreement cannot enhance rent. It can only be fixed, fair rent can be fixed by the rent controller. Now, so the defendant continued to be a tenant under the West Bengal Presidency Act. If Lordship is with me on this issue, then, my lord, this suit before this court is not maintainable because they have to file before the rent controller. So there is a bar under the West Bengal Presidency. The suit is barred under the West Bengal Presidency Act. This is the summons absence of the case. Now let us take, my lord, to the tenancy agreements. If Lordship takes up,
Lordship is hearing GA2 now. That's the demurrer.
Yes.
I will make composite submission.
Philosophy takes up by application.
Yes.
Now, in a order summon rule 11, my lord, we all knew that only the plaint, and the documents relied upon in the plaint can only be taken into consideration. Can be looked into. So, Lordship can ignore my application, come to the plaint straight away, which starts at page 8 of my application.
Yes.
My lord, Lordship, can you take up first the prayers in the plaint at page 24. Decree for khas, peaceful and vacant position of the portion of the premises. Portions of the premises situated 21 Rupchan as indicated blue in the plan marked as A, mandatory injunction to deliver khas position, decree, mean profit, ultimately inquiry into the damages. So this is a eviction suit simplicity. Now, my lord, will come to paragraph 2 of the plaint, which is at page 12 of my application.
Yes.
At all material times since 1997, the defendant has been in occupation of the entirety of the building at the said premises, save and except a room measuring about 1,000 square feet approximately, situated on the ground floor of the said premises and located on the northern side of the building. A layout plan map of different floors under the monthly tenancy of the defendant, Lordship can mark the word monthly tenancy, would appear from a map plan annexed here to marked as annexure A, colored in blue, which excluded 1,000 square feet approximately on the ground floor mentioned above, colored in red. So here, my lord, pausing here, my lord, the plaint has suppressed that there are two tenancy agreements. Now, Lordship Kani takes up the first tenancy agreement at page 95. this is page 95. This is the 1st September 1997. Lordship got it?
Yes.
Now, Lordship, can it turns over the page?
Yes.
Look up now this agreement. The paragraph 1. The landlord have been inducted tenant as monthly tenant in respect of the entire ground floor,
Yes.
entire first floor and mezzanine floor. At tenant shall pay monthly rent of rupees 2,100 and service charge of 1,000 per month. So, total 3,150.
Correct.
Now, well, here there was a clause for increment, but that increment was never claimed by landlord. So this is ground for the first agreement covered. The premises covered by the first agreement is ground, first, and mezzanine. And rent is 2,150 and service charge is 1,000.
Correct.
Now, Lordship, take turns over the
So what about the 5% expiry of every 10 years increase?
That was never claimed by landlord. Never claimed. Now, Lordship can take the next
Yes.
Next agreement, page 100.
Yes.
This 2nd of June 1997.
Yes.
So again, Lordship takes a page 101. Inducted tenant, paragraph 1 here also, identical. Enter second floor, third floor, and roof.
Yes.
Now, monthly rent of 3,000, inclusive all service charges. Here is 3,000. Now, Lordship turns over the page. Paragraph 2 at page 102, paragraph 2 at 102. The tenant shall have the right to sublet the said demise premises or any portion or portions thereof to such person or persons of its own choice and on terms and conditions to be agreed upon by and with the subtenants and the tenant only once. The tenant shall have further right to induct subtenant for second and subsequent times with prior consent of the landlord. So when I induct for the first time, no consent is necessary. Now, paragraph 3. The landlord shall not call upon the tenant to vacate the demise premises or any portion thereof on the ground of his own use and occupation, or for building or rebuilding, or under any law, statute, ordinance presently in force or enacted or passed on any future date by the government, semi-government body or court of law. So there is a negative covenant that the landlord will ask me to vacate.
Correct.
Why this? Why this? Logically turns to page 103, clause 5A. That the tenant shall deposit for a sum of rupees 3 lakhs with the landlord in 97 landlord, and the said amount shall continue to be held in secret deposit non-refundable by the landlord, free of interest, and not to be repaid or adjusted by the landlord as against monthly installment order. So a pagri or salami of 3 lakhs was given and
not refundable. That
not
is not
refundable. Not refundable. So it is not even a deposit. It's a straight of salami or pagri. Paid, gone. So that is why not to vacate. So it was in the nature of a permanent tenancy, my lord. And so held in not to be refunded, not to be adjusted anyway. Now, Lordship takes up paragraph 13. The tenant, I'm sorry, page 104.
Yes.
Clause 13. The tenant shall have right to make additions and alterations to the demise premises without previous permission and interference of the landlord, but on obtaining permission for the Calcutta Municipal Corporation. So I have right to build, rebuild. I have right to induct tenants. I have, and the landlord will not evict me.
3 conditions.
3 conditions. These then at page 104, clause 9. The tenant shall have the right to install lift
Yes. Cost of the tenant.
Yes, at my cost, I can install a lift even. So, in totality, my lord, my submissions will be it is the nature of a permanent tenancy. Now, be that as it may, now Lordship takes up at page 37. This is the notice by landlord seeking to enhance rent. This is Lordship can turns over page 37 and 38. Both are dated 1st of August 2017 and both notices were issued in respect of two premises. So why I'm showing two premises? Because there are two causes of action. There's a misjoinder of causes of action. That will be one of my grounds. So 1st August, this is, they say the entire second floor for one premises, very clearly, they give a notice. You are a monthly tenant, paying monthly rent of 3,000 and your tenancy is covered by the West Bengal Premises Tenancy Act. Then they say that from 3,000 your rent will be 18,000, 6 times, by adding 5 times to existing rent and so on. The same identical notice, page 38.
Yes.
Page 30 is also identical notice.
12,900.
Yes. They say 12,900 for the other. So landlord also treated the two premises separately.
Yes.
Now, logically take up at page 12 of the plaint. At page 16, page 12, paragraph 12 of the plaint.
Yes.
The defendant, YD, its letter dated 24 July 1919, has confirmed its acceptance on the enhanced consolidated monthly rent, which took effect from August 2017. So it is a case of the plaintiff that by a letter, the defendant has confirmed its acceptance of the enhanced consolidated monthly rent.
Correct.
Right. The plaintiff states that the defendant has acknowledged its liability
Yes.
to make payment of consolidated rent at the rate of rupees 35,273 per month from April 2019 till June 2020 by depositing TDS amount of rupees 3,525 for each month, aggregating to rupees 52,905. The above fact would be evident from TDS statement under Form 26 AS, which has been downloaded by the plaintiff. In spite of depositing TDS amount for the period April 19 to June 20, the defendant has failed, neglected, and or refused to make payment of consolidated rent for the said period to the plaintiff. The TDS statements under Form 26 AS downloaded by plaintiff annexed here to Part 2. So there are two sort of forms of acceptance pleaded. One is the letter of 24 July 2019 and other is the plaintiff, a defendant has deposited TDS amounts.
Correct.
So they say by depositing TDS, you have acknowledged the liability.
Yes.
And by this letter, you have acknowledged the liability.
Yes.
Now this letter is at page 107, my lord. Lordship, can you look at page 107?
Yes.
I have to point out here, my lord. It may be pointed out by the plaintiff that since court can only look into the plaint, this was referred in the plaint but not annexed to the plaint, so court cannot look into this.
Which one?
This letter. This is referred in paragraph 12 of the plaint, 24th July 2019.
Correct.
But it is not annexed to the plaint.
Well, I'm not taking such point.
Very, very well.
It has been referred to the plaint. In a plaint, you never annex because in a commercial suit, you have to annex all documents. This is non-commercial. I'm not
Very,
taking
very,
this
very
point.
well. So one hurdle is over. So this is my client, Nivan Finvest, writing to Jatiya Estates, the plaintiff. This with reference to your August 27 rent increment for premises number so and so, when we requested for a conversation with you for the same. We were informed by your representative that we should make the due payment as per your bills first, and the meeting can be held post it. So we initiated the payment in October 2018 as per the bills provided, fully pays as on the date. We have been requesting your representative since then to schedule a meeting, but in vain. As requested by representative to pre-inform the purpose of the meeting, I would like to share the same. I look forward to discuss the increment in rent since August 2017. I'll also voice a few words shared with your fathers, Sri Birendraji and myself. So, my lord, according to plaintiff, this letter is acknowledge the liability to pay the enhanced rent. My utmost respectful submission is this letter merely says that your representative says I have to deposit first and the meeting will be held post it. So to hold a meeting, this payment was made. It is not an acknowledgement of liability. That's my submission. Now, then next part is TDS. They have annexed TDS statements where the defendant has paid TDS.
Yes.
There are cases that by depositing TDS, you have acknowledged this enhanced rent. To that, my lord, my legal answer is deposit of TDS is like a payment of advance tax. It does not acknowledge any debt or acceptance or any debt or anything else. It's merely I might be liable in future to avoid penalty. I pay advance tax. Advance tax is not acknowledgement of liability to pay tax of that amount. Similarly, TDS is not an acknowledgement of any debt or any liability or
Who has paid the TDS?
My clients have
You
paid
have
the
paid the
TDS.
TDS. Why the TDS was paid?
To avoid penalty, because in future there will be some increment, there will be some extra rent has to be paid. So when you pay that, since I am not deducted, suppose for even today, suppose rent in 2017,
Correct.
I pay today, I have to pay huge final penalty.
Correct.
But since I paid the TDS earlier, even if I pay that rent today, there will be no final penalty. To avoid final penalty, my client has deposited that mail.
The deposit. So one way you're telling that it is not
Acknowledge,
no
liability.
Not acknowledged.
Right.
But other way, if it say that you had the knowledge that rent will be increased.
Yes, because I'm asking to hold a meeting.
Correct.
What will be increased, that has not been finalized.
Correct.
Then maybe 5 rupees to 5,000 rupees or 50,000 rupees, whatever may be. But for that, we are wanting a meeting. That meeting never held till date. So rent not finalized, they are not approached the rent controller. So-called enhancement rent not binding on me.
So your specific case. So in anticipation to avoid the
penalty and
you have paid,
interest,
but subsequently it was not finalized.
Finalized.
So what has happened to this TDS?
TDS is lying in their account.
Okay.
Not in my account.
I mean yes, but their income tax account. I'm sorry. Form 26 is their credit. Now, my lord, so if I now lordship takes up this is only up to the facts, my lord. Are facts are issued? No. Now let us go to my submissions, my lord. In affidavit in opposition to
So where is the notice of termination?
Yes, ma'am. The notice of termination is at page 85, my lord. I should have brought you that page 85, my lord. For non-payment of enhanced rent, this is the notice under the transfer of property at 106.
This is July 24.
July 24.
Yes.
We have been instructed. We have been paying consolidated rent of 35,273. Our deposit they have taken as a payment from 1st August. From 1st April, you have stopped any payment of any rent.
Yes.
And here give notice by 21st July 2024. The last sentence at page 86, we treat the notice under section 106 of the Transfer of Property Act.
Correct.
So they have given notice under 106 of the Transfer of Property Act, giving 15 days time. Because 10th July, 31st July, 15 days time they have given, and no notice under Premises Tenancy Act. And my case is my tenancy is governed by Premises Tenancy Act. Now, my lord, certain I'll come to their objections immediately. Before that, my lord, certain provisions of Premises Tenancy Act. I'll copy it.
Premises Tenancy Act.
Okay. Oh. My lord, may I place section 17 first?
Yes.
Fixation of fair rent.
Yes.
The controller shall,
Yes.
on application made to him either by the landlord or by the tenant in the prescribed manner, fix the fair rent in respect of any premises in accordance with the provisions of this act. So rent can only be fixed by the rent controller. The fair rent for a year in respect of premises constructed later of 1984, and the modes of calculation given in the subsequent paragraphs, my lord. Now, my lord, section 13. Section 13, my lord, no tenant shall, notwithstanding any agreement to the contrary, be liable to pay to the landlord for the occupation of any premises, any amount in excess of fair rent of the premises, unless such amount is lawful increase of fair rent in accordance with the provisions of this act. So provision of this act is section 17. So unless it increase in accordance with section 17, no tenant is liable to pay to the landlord. So that increase, so by a notice, rent is increased unilaterally, that is not possible, and that is not binding on me. And in fact, there is a bar on the landlord to collect any amount in excess of fair rent.
Correct. But see, this is with regard to fixation.
Lordship.
If you're not ready, if the party is ready, what will happen? Not necessary.
No, my lord, I'll bring to kind lordship. I know that even parties by agreement cannot fix a rent, my lord.
With the consent.
Increase cannot fix. That has to be fixed by the rent controller only.
One thing. Okay, I will go through
Lordship.
that. And second thing, if you are harping upon section 17 and section 13, so what will happen to your 24th July 2019 notice? You are admitted that yes, for the purpose of the enhanced rent, you will pay.
No. Enhancement, I said for sitting in a meeting for negotiation, I'm depositing this amount. So I'm still willing for negotiation, but no negotiation held, no rent has been fixed.
Okay. Next.
I merely wanted to negotiate, to sit for a meeting, for a discussion, which they have not done. They immediately fix it. You are not paying enhanced rent, eviction. Okay. That is not possible, my lord, under the statute. So section 13, and lordship can see section 2B, the definition of fair rent.
Section 2B.
B, fair rent definition, my lord.
Yes.
Fair rent means the rent fixed under section 17.
Correct.
So unless fixed by the rent controller, the landlord cannot increase the rent.
Correct.
And then lordship look at section 6.
Yes.
Section 6 is
Obligation.
notwithstanding anything, protection of tenant against eviction, notwithstanding anything to the contrary contained in any law for the time being in force or in any contract, no order or decree for the recovery of possession of the premises shall be made by the civil judge having jurisdiction in favor of the landlord against the tenant except on a suit being instituted on such landlord on one or the following grounds. So except on these grounds, a suit by a landlord for eviction cannot be filed. And then lordship says subsection 4.
Yes.
Notwithstanding anything in any law for the timing in force,
Yes.
no suit, there is a bar, specific bar, no suit for the recovery of possession of any premises or on any of the grounds as aforesaid, except on the ground mentioned in clause E of subsection 1, shall be instituted by the landlord unless he has given to the tenant 1 month's notice expiring with a month of tenancy. So, unless a 6-4 notice is given, no suit for recovery of possession can be filed.
Correct.
In the present case, no such notice has been given. So, there is a non-obstante clause, and it starts with no suit.
Yes.
So, there is an absolute bar on filing a suit. Now, no notice under Premises Tenancy Act has been given. Now, my lord, I am not required to show lordship, bring to lordship notice the judgment says that documents referred in the plaint can also be looked to. I'm not since very fairly not necessary. I get rid of that. Now, lordship kindly, the first decision I will be citing is 2006 SCC Online Calcutta, which is also CHN. I'm giving the reference, my lord.
Page number?
Page 417, 2006 SCC Online Calcutta 417.
Yes.
CHN আছে বলে দিচ্ছি. This is 2000 equivalent to is there on the top. 2007 volume 1 Calcutta High Court notes page 1. 2007 volume 1 CHN page 1. Well, no, my lord, the facts are not very relevant. Lordship comes to paragraph 18 of this citation. This is also division bench judgment of our court, my lord.
Yes.
As held by a division bench of this court in the case of Remington Rand versus Rajgharia, reported in 87 CHN 923, the West Bengal Premises Tenancy Act has given exclusive jurisdiction to the rent controller in the manner of fixation of fair rent. Even a civil court is not competent to decide such question. The Supreme Court has gone to the extent that such a duty to assess fair rent or increase of fair rent vested with a controller or a court, as the case may be, under different rent control regulations, cannot be discharged by those authorities simply on the basis of consent of the parties, but must be adjudicated by the authority invested with such duty to assess by application of its mind on the basis of materials. Same paragraph, my lord, that in this case, the writ petitioner wants increase from 1972, which is not at all permissible under the law, when no application has yet been filed before the appropriate forum. You got it? In this case, what had happened? FCI was a tenant. Now the landlord filed a writ petition.
Yes.
Saying direct the officer in charge.
Yes.
I mean direct the person in charge to consider enhancement of rent. That head of the department, he considered and said very well 1 rupee per square feet should be increased. Against that, the landlord again came to court. Saying that this should be set aside and he should have directly reconsider. A single judge directed this should be set aside and let him reconsider.
Yes.
Against that, FCI came before the court saying that the court in a writ petition cannot direct to consider enhancement of rent. One, because it is only if the landlord wants to increase rent, it has only to approach the rent controller. No other authority or even a civil court can enhance rent. Then paragraph 19. From the aforesaid discussions, it is clear that legislature has not permitted either the landlord or the tenant to fix fair rent of a premises or mode of increase of the fair rent according to their own agreement earlier made before commencement of tenancy, unless agreed to at the same time accepted by both the parties. If there was such agreement prior to the commencement of tenancy, the tenant or the landlord is not bound by such agreement. And if any of this is not agreeable to enhance the existing rent, wants to fix the fair rent, only remedy available to the aggrieved parties to approach before the rent controller. Suppose here here there was a existing clause that it will increase by 10% every year. Even that clause is not binding, and any party, either landlord or the tenant, who wants that the rent should be increased or decreased, whatever, they only remedy available is to approach the rent controller. They even by consent they cannot fix the rent.
Got it. Yes.
So here, my lord, there was no consent from the defendant. That I have shown 24th July letter, which simply says you are depositing. Your person said deposit, then we'll sit for meeting, and that meeting never held. So this enhanced rent, whatever is being claimed by the plaintiff, is not binding on the defendant. And if this enhanced rent is not there, this I still continue to be a tenant under the West Bengal Premises Tenancy Act, and there is a bar of Premises Tenancy Act which continue with this suit before this lordship. This is one part. And in any event, if that enhanced rent is not claimed by that deposit, about more than 2 lakhs of rupees is excess payment, which is lying to my credit with them. So I am not at default in any case.
Where is that 7 lakh deposited?
That 7 lakh deposit, it is admitted fact. They also admitted, they have in their paragraph 12, in the plaint also they say that they have paid 7 lakhs. Paragraph 9. The plaintiff states, paragraph 9,
yes,
that the aforesaid sum of 7 lakhs, which was paid by the defendant between 1st October 2018 to 31st March 19 towards rent, service and municipal tax for the period 1st August 2017 to 31st March 2019 was without any TDS.
yes,
So that payment is accepted.
yes.
And if it's at 3,000 and 2,150, we take the rent, then there is excess payment of more than 2 lakhs lying with the landlord. So this is my first point, that simply by writing a letter, the rent cannot be increased. And I was not in default, first of all, and of course that is on merits, but there is a specific bar under the West Bengal Premises Tenancy Act. Now next is, my lord, what about the TDS? I paid month-to-month TDS, my lord. To that, my lord, I'll rely 2008 I mean, it is 2008 SSC Online Bombay 1599, which is equivalent to 2009 1 Bombay CR 25453.
Yes.
Well, here 2009 1 Bombay CR 453. 2008 SSC Online 8 Online Bombay 1599.
Thank you.
The copy দিয়ে দিন না যদি এক্সট্রা থাকে।
এটার কপিটা দিতে পারো?
হ্যাঁ আমি দিচ্ছি, আমি হয়ে গেলে দিয়ে দিচ্ছি।
না ঠিক আছে, তুমি বলো। সামল না তুমি
তুই চাইছিস না দিয়ে পারি?
আরে তুমি
No, I have my time. Here, my lord, Lordship, can you take up paragraph 8 straight away? This is about Lordship, can take up page 3, internal page 3, from the bottom, my lord.
Yes.
The issuance of TDS, the last sentence of the page.
Right.
The issuance of TDS, Lordship got it?
Yes.
Terms of the page. Certificates does not amount to an acknowledgement of the defendant within the meaning of section 25 of the Indian Evidence Act, and the full bench judgment of this court in the case of Josna Supra puts the matter beyond doubt. The TDS certificate is primarily to acknowledge the deduction of tax at source. That certificate does not refer to any amount of loan or even the rate of interest which is payable by the principal amount. It does not refer to any contract between the parties, even a transaction. Then so, my lord, a TDS
Cannot be. Yes.
it is not an acknowledgement of any date or any acknowledgement, my lord. This is second limb, my lord. And in the affidavit opposition, my lord, 2 points have been taken, my lord. Lordship, can you allow me? Lordship, take the affidavit opposition. This is affirmed by Sri Siddhant Jatia on 11th December.
My lord, I don't think the affidavits
Not filed.
are not probably filed. Yes, this is the now for number 2. Can I file the others also?
Subsequent.
Keep it. Okay.
No, no, these then.
No,
That I am taking
okay,
this
okay.
thereafter. When I
So
will
one
take
after
it,
another. Very well. Well, as 1 point and taken paragraph 3, my lord, of the 2 technical points have been taken at page 2, paragraph 3.
Yes.
Before dealing with the allegations contained in the said application, I respectfully state and submit that the said application, that is my application for rejection of the plaint, is not in proper form and is by way of a petition, which has been filed instead of an affidavit in support of the master's summons. What happened, my lord? Advocate has taken out a master's summons, but it was in the form of petition, not an affidavit.
I'm not pressing that. But this is correct procedure.
Yes, yes. So, my lord, procedure is handmaid of justice. I have cited, my lord. So, my lord, very fairly.
As per the original
Who
side
is,
rules.
yes, that's who is not habituated to the original side rule, they will go by the general rule.
No, previously we also do. Half of the people do not know that a dismissal for Order 7, Rule 11 has to be by way of an affidavit. It is never by way of a petition. It is provided in the rules. When we made lots of mistakes initially, he will correct. Most people do not know. Whatever is left in the original side,
especially
so
my lord,
people
people who are deals more with appellate side, my lord, they make this.
side.
That's what I'm telling.
So I am not.
No, but
I'm not.
I have faced the difficulty when I have given the determination.
Well, we are here to
I
assist.
have no idea.
No, we have to assist your lordship.
No,
It's
that's
not
why.
fair. It's not fair on your lordship.
No, that's why.
Yes.
Subsequently, then all the bar assisted me.
Yes.
Then I have followed. Because I found what is the Savastu Samman.
There is no original side in board there.
No, but your lordship is more conversant about service law, which we are not. Which we are not.
Yes.
That
yes,
you
yes.
have to. I mean, everything. One cannot be a specialist in everything.
My lord,
We had appeared
uh,
against each other.
You told me you have to finish the matter on that day.
Yes.
now, in then lordship take page 5. Page 5 about middle of the page.
Yes.
Or rather page 4 bottom, last two sentence, it is. Page 4 bottom, it is. It is denied. Lordship got it?
Yes.
It is denied that the plaintiff also suppressed in the plaint that there are two separate and distinct tenancy pursuant to two agreements dated June 2, 1997 and September 1, 1997. Then Lordship skip some 3-4 lines with regard to the Lordship got it?
Yes.
With regard to the two agreements contained in Annexure B to the said application, I say that the copies of the aforesaid two agreements are contained in the interlocutory application, being GA number 1 of 2024.
Yes.
So, my lord, these two documents are admitted documents. I mean, at least their existence, may not be the contents, but the existence are admitted. Now, then the main submission. The said two agreements are unregistered agreements and insufficiently stamped and therefore not admissible in evidence. These are the principal point of law taken by the plaintiff. Now, this has been clearly stated in the application. It is now tried law that unregistered agreement creates only monthly tenancy and terms cannot be considered. The two monthly tenancies are subsequently clubbed into single monthly tenancy by the action on the defendant appear for the statements contained in the plaint. So, it is the, I will say, principal contention of the plaintiff is that these agreements are unregistered agreements and insufficiently stamped and therefore not admissible evidence. This is the, so if the agreement, with utmost respect, my lord, even if the agreement goes, the bar of Westmoreland Tenancy Act remains. The bar of Westmoreland Tenancy Act remains because the rent is 3,000 rupees only.
But if they will take the recourse of 106, what will happen? If the agreement goes.
Yes, but I remain a monthly. They admit they are monthly tenant.
Monthly tenant. But
Rent 3,000 rupees.
Under 106, if the terminate the agreement under 106, what will happen?
No, then the termination will be bad, and because I fall under Westmoreland Tenancy Act. Westmoreland Tenancy Act. I mean, কত টাকা ভাড়া হলে? Lordship, can you take up the definition of tenant? This is the longest definition.
G.
No, apart from that, section 3, exemption.
Exemption.
3E. Nothing contained in the act shall apply to 3E. Any premises let out for residential purpose, not being a premises within the purpose clause C, which carries more than 6,500 rupees in monthly rent. The rent is more than 6,500 rupees, and in case of non-residential purpose, which carries more than 10,000 rupees a monthly rent. So, if the rent is more than 10,000 for non-residential, it's a non-residential. So, rent is more than 10,000, then Premises Tenancy Act will not apply. The exclusion clause. All others are roped in, my lord. So, my case, 3,000 rupees rent is squarely falls under the Westmoreland Premises Tenancy Act.
Yes.
Now, regarding registration, if you No. If lordship takes up Registration Act, Registration Act আছে রে এটা তো আছে ওখানে আপনার কাছে হবে Registration Act
রেজিস্ট্রেশন একদম
আরেকটা বই আছে
ফটোকপি আছে
না না সোসাইটিস নয় শুধু Registration Act Lordship kindly takes up section 17 documents section 17
yes
section 17 documents of which registration is compulsory the following documents shall be registered
yes
if the property to which they relate is situated in a district in which and if they have been executed on after the so and so then A lordship come to state away D speaks of leases
yes
leases of immovable property from year to year in my case is a monthly tenancy or for a term exceeding 1 year in my case there is no term or reserving a yearly rent mine is a monthly rent so 17(1)D does not apply to a monthly tenant
yes
where there is no tenure
yes correct then
so this document tenancy agreements were not compulsory registrable so the objection regarding unregistered agreement this cannot be taken at all the next question my lord insufficiently stamped my lord there are at least to my knowledge 5 decisions of our court
evidence
yes evidence now it has all been diluted in a curative petition by constitution bench then setting aside almost all other earlier judgments my lord this is 2024 volume 6 Supreme Court cases page 1 it's almost like a book because our Calcutta case was that if a document is not properly stamped it cannot be looked into even
correct
now that myth has been cleared by the Supreme Court a constitution bench in a recent decision 2024 shall bolo 2024 6 SCC page 1
oh arbitration
right
arbitration
so lordship takes up first is a very longish judgment there are A B C D headings they have made a lordship takes up page 31 of this judgment 31 gives an index. At page 31, there is an index, my lord, which is which are if your lordship takes up D, the Stamp Act, 1899.
Yes.
One is overview, you can skip. II, the consequences of the failure to stamp an instrument.
Yes.
The procedure on the Stamp Act. Then B, very important. The difference between inadmissibility and voidness. This is important, my lord, because our Calcutta say this is, if not stamped, is void. Not registered is void. But they say there is a difference between
admissibility and void.
Inadmissibility and voidness. C is section 35
that is
of the Stamp Act renders the document inadmissible and not void.
Opposite.
So, lordship kindly takes up paragraph 51 first at page 51. paragraph 51.
Yes.
Before that, the heading says at above 49, the difference between inadmissibility and voidness. So they say document can be void but still inadmissible evidence. And a document cannot be inadmissible evidence, but it may not be void. There can be two are not perimeter, two are not same thing. 51, an agreement can be void without its nature as a void agreement, having an impact on whether it may be introduced in evidence. And the agreement is void.
Can be valid.
Right.
Can be valid, but inadmissible in evidence.
Evidence. Right.
Correct.
So then paragraph 54, coming to section 35, which says that it is inadmissible.
Unambiguous.
No instrument chargeable duty shall be admitted in evidence. The term admitted in evidence refers to admissibility of instrument. Subsection 2 of section 42 states an instrument in respect of stamp duty is paid and which endorsed as such will be admissible in evidence. The effect of non-payment of duty or paying an inadequate amount renders an instrument inadmissible and not void. So their case that this is our insufficient stamp is not the that this agreement does not evaporate into thin air.
So that's why see, if you relied upon the document, if you
They are not void, they can be looked into.
Correct. If you wanted to rely now, then it will come as evidence. In evidence, then it is to be impounded.
No, my lord, because no stamp duty is necessary.
Now, if you want to bring on evidence by admissibility of the document,
if at all it is to be stamped, then it can be impounded.
Yes.
But my case is not registrable. It's not registrable, then no stamp duty is necessary.
Correct.
Right. So it does not become void. The Stamp Act does not render such an instrument void. The stamp, non-payment of stamp, is accurately characterized as a curable defect, as your lordship just now saying.
That's what I'm telling.
And then the purpose of Stamp Act, they say it's only to collect revenue. At page 66, paragraph 66, I'm sorry, page 55. They're quoting from Hindustan Steel, a Stamp Act is a fiscal measure enacted to secure revenue for the state or certain class of instruments. Is not enacted to arm a litigant with a weapon of technicality to meet the case of his opponent.
Yes.
Well, today, my lord, Supreme Court has spoken on all subject. Yes, no, if one looks into, they change the law every day. In fact, this changes, at least to my knowledge, 5 decisions of our court, starting from Sadhguru Nirman and so and so. So it is so the park is taking his claim on the instrument to not be defeated on the ground of the initial defect in the instrument. The scheme is very clear. It's only to collect stamp duty, nothing more, nothing less. Now, this takes care of their technical objection, my lord. I mean, their legal objection.
Reply to the objection.
One is technical, not by way of petition.
Yes, that was technical. And my lord, if your lordship kindly looks one more decision, 1997, 3, Supreme Court cases 679. 97. Lordship got it. Page 680, para 4.
Yes.
The only question that arises for consideration is whether the unregistered lease deed is admissible evidence. Section 17(1)(d) then set out, I skip over, Lordship comes to paragraph 7. The question, therefore, that arises is whether a lease of immovable property from month to month or for 11 months is a compulsory registerable document, though it was reduced to writing as an instrument defined under section 214 of the Stamp Act. So whether registerable, then a conjoined reading of the first part of section 107 read with section 17(1)(d) of the Registration Act as extracted herein before does indicate that the lease of immovable property from year to year or for any term exceeding 1 year or reserving an yearly rent should be made only by a registered instrument, and all other instruments, though reduced to writing and possession is delivered thereunder, are not compulsory registrable instruments. Then paragraph 8, my lord. The proviso is not applicable to the facts of the case, it's section 49. It is not necessary to look into of a document comprising, namely, unregistered document used for enforcement of specific purposes under the Special Relief Act or used as evidence or part purpose of the contract section 50 or using evidence for cool. The combined effect of all the provisions is that an unregistered lease deed executed from month to month or for a period not exceeding 11 months, though reduced to writing and possession delivered thereunder to the tenant, is not a compulsorily registerable instrument, and therefore the prohibition contained section 49 Registration Act is inapplicable. Therefore, the document is admissible in evidence to consider the effect of the immovable property contained therein or to receive as an evidence of any transaction vis-a-vis such property. So, my lord, in my case, I don't fall under 17(1)(d), so it was not compulsory registerable instrument. Therefore, this can be taken into evidence.
Yes.
and of transaction vis-a-vis the property. So, my lord, summing up, my lord.
Yes.
So, summing up, my lord, today, that their case is they have by letter increased rent, and I have acknowledged that liability. 1, 2, I have paid tax deducted at source.
Correct.
2, therefore it was also an deposit of TDS was an acknowledgement of debt. Therefore, having accepted rent, I was liable to pay that rent. Since I have not paid that rent, therefore eviction suit. My answer is, first of all, that there was no admission. I have not accepted. I have simply said I am depositing as a conditional seat in a discussion. There was
Not acknowledged.
There was no finality.
Correct.
There was no contract. There was no finality. The rent was not agreed upon. And secondly, there is a legal bar on their part. They cannot increase rent by simply by writing a letter. They ought to approach the rent controller. They have not done so. There is no order by rent controller. So rent has not increased. If the rent has not increased, my lord, then I am squarely covered by the Visual Premises Tenancy Act, because I do not come under the exclusion under section 3 of the Visual Premises Tenancy Act.
Yes.
And in view of the bar under section 6(4) of the Premises Tenancy Act, this suit is barred by law, covered under subclause D of the Order 7, Rule 11.
Yes.
And
Yes. Anything further?
my lord, my junior insists, my lord, that 2019 letter, though referred to, but has not been mentioned in the plaint, my lord, I think they are not liable to.
Okay.
That will be, and that obviously they will refer when at the trial and all. My lord. So this is what my case
Thank you.
is. Well, other matters I am not paying. Only thing is, Lordship had given some administrative instructions regarding filing of written statements. If that is followed, my lord, my application for extension of time to file written statement, that period has not complete and period is complete, but I'm entitled to extension, my lord. And because this order 7 rule 11 was Lordship takes up that extension application kindly.
My lord, we are hearing the now.
You have filed the application.
Obviously,
We will decide, no problem.
yes.
Your affidavit, written statement is affirmed.
My lord,
Statement
if
is
you allow
ready.
filing of written, my chapter 13 will go.
No, it will become premature.
ah.
They'll file again.
No, what? So, my lord, my okay, Lord, let me give you some answers.
No, next day.
Oh, next day. Okay. That is tomorrow.
Tomorrow is fixed. Huh?
My lord, interim order is still tomorrow.
So tomorrow will come?
Yes.
Suffering for the plaintiff,
Well, instead of tomorrow, can it be day after, subject to my lord's?
It is already fixed tomorrow. Already fixed tomorrow.
Tomorrow, little difficulty, subject to my lord's convenience.
Let Mr.
Day after tomorrow.
Let Mr. Bose continue. You take note of it. I will give the chance to give reply to next date. No problem.
But I will be praying for the interim order.
Extension.
My lord,
That
not
will-
to dispose of the tenancy, the sell alienate. Your lordship
The defendant has argued
restricted
the
it till 9th.
has concluded his argument in connection with GA2 of 2024. Due to paucity of time, counsel for the plaintiff could not give reply. The matter is already fixed. Let the matter is tomorrow.
Oh, yes.
Or fix it to
এটা ওদের বই।
come tomorrow.
My lord, I have prepared as 3-4 page note for your everything is included. But the moment I'll give it to you.
Come. Yes, next.
Tomorrow at 2 p.m. man?
2 p.m. 2 p.m. na?
কালকে আছে তো কালকে আছে
Deeply obliged.
Thank you.
May I pray for a Passover for 5 minutes, my lord?
Why?
Witness action was going on. Witness is almost here. I just had a phone call, my lord, for 5 minutes, my lord. Witness is on the way, 5 minutes.
Okay, let that come.
Kindly passes it over for 5. My lord, he's in the lift, my lord. That's what I hear.
Every day same submission is wait. Lordship takes up one more matter, my lord, we'll wait for the witness. We have no difficulty.
Extremely grateful to my lord.
Huh?
21 is the body.
আমরা wait করি।
So this is my application for review.
Item number 21.
21, your lordship.
Yes.
So review on 4 grounds.
Review of
Your
order
lordship.
dated 27/11.
Lordship.
What is the point?
Your
for review?
lordship, does your lordship has the GA brief as well? Lordship, if your lordship kindly posts with the GA application, your lordship, it will be convenient. Because I'll tell your lordship what has happened is, your lordship, in this matter, there were 2 notes of argument filed. One before the hearing start, before a coordinate bench, and one after the hearing was actually concluded.
The coordinate bench was this bench only.
No. I had entered late, and my learned friend is suggesting that this was only before your lordship. Now, your lordship, what the error apparent on the face of the record is, your lordship has passed the order on the basis of the previous notes instead of the notes subsequently filed. Your lordship, so your lordship's GA application will contain 2 notes. And there was a subsequent judgment of your lordship in Mita Surana, which was cited, which is not been considered in your lordship's judgment. So if your lordship posts with the GA, your lordship will be able to.
GA1.
GA1, your lordship.
Your lordship, in the meantime, may I seek for direct?
Suffering for the plaintiff, suffering for the defendant. You are for the defendant.
Yes, your lordship.
And so are for the plaintiff. The counsel for the plaintiff has filed the present application being GA. Filed the present review application being review 49 of 2024. Praying for review of the judgment dated 27/11/2024, passed in GA1 of 2021. Full stop. Counsel for the plaintiff submitted for hearing of the review application. The record of GA1 of 2021 is required. Accordingly, the department is directed to place the record of GA1 of 2021 in CS number 163 of 2020 in review number 49 of 2024 on the next date fix. Let the matter appear on the non-commercial.
Yes, Your Lordship.
6th
Your
February.
Lordship,
On
if
6th
I
February.
if I may pray for direction for affidavit.
Lordship, there is nothing on the merits. The review is only.
Affidavit.
Because if he is going into the written notes of argument, these written notes of arguments or that written notes of
That's come, we'll see to that.
because
Or in the
Lordship,
so,
kindly-
okay. The counsel for the defendant press for time to file affidavit in opposition of the review application. Let affidavit in opposition be filed within 2 weeks. Reply, if any, they are to be filed within a week thereafter. Leave the matter on 6th. Na?
Lordship, I was praying for an earlier date, subject to what falls from your Lordship. Your Lordship, perhaps no affidavit is required because an earlier date could be fixed, your Lordship.
Huh?
An earlier date could be fixed.
Come on 6th. That's why I fixed because other matters are fixed.
Very well, Lordship. Great.
Yes. Call this night.
$345 is a fixed man.
এই রাজা তো এই পাঁচটা কাগজ কাগজ এসছে তো তাড়াতাড়ি করিস
नहीं होता है हमसे I'll try to well, generally I talk English but certain things I
What is your name, sir?
Mahesh Kumar Kejriwal
Kejriwal.
Cross resume, na?
Cross exam.
Yes, sir.
Yes.
Shown question 126 and answer to the same. Are you now in a position to produce the affidavit?
Let me see the question.
Yes.
Question number 126.
126.
Yes, sir.
In fact, you may read from question 122, 123, 123, 123 to 126. ছেড়ে দেবো একবার মানে
हम अपने वकील साहब को दे दिया था ये एफिडेविट
I have given this affidavit to my advocate.
This is the opportunity I was waiting for. Now I will examine Mr. Kaushik Banerjee. Where is he?
Start with his son.
He's run away.
Start with his son.
Oh no, শান্ত থাকলে দিয়ে দে নাহলে ছেড়ে দে
আছে দিচ্ছি this is same affidavit you are using
দাও
also.
সাক্ষী বলেছে তোমাকে দিয়ে দিয়েছে কাগজ দাও
This is the same affidavit you were using it in
বলে দে না
proceedings.
বলে দে কোনটা shown question 113 Can you please produce the document that you promised to in your answer to this question?
ये भी हम अपने वकील साहब को दे दिए
I have given this document to my advocate also. I have also given this document to my advocate.
Shown question 463.
463.
463.
Are you in a position to produce the call records? না বলেনি
क्या
এটা
call
বলেনি
record दे सकते हैं अभी प्रोड्यूस कर सकते हैं
नहीं
ও দেবে না এটা
No, I cannot. No, sir.
No. Shown question 420 to 424. Can you please produce bank statements?
क्या आप ये बैंक स्टेटमेंट प्रोड्यूस कर सकते हैं?
No, the leakage I cannot produce.
না তারপরেও বলেছি।
No, no. You can ask the will. Oh, it takes some time.
It did not strike his mind that he had to ask the bank. পড়ো। Idea পেয়েছে আমার থেকে।
Sir, I cannot produce bank statement of 2009 का।
Up to 2000
ठीक है, no problem.
बैंक स्टेटमेंट 2009
তুমি ওই দুটো কাগজ দিয়ে দাও। হ্যাঁ? দেবে না, রিফিউজাল। PD8 দেখা, ওই দুটো ডকুমেন্ট করে দিই। Shown
PD8.
the document being PD8 at page 52 of volume 1 of the judge's brief of documents.
PD8.
হ্যাঁ 8 নম্বর তো হ্যাঁ I am sure you have seen this written statement filed by Ramesh Kumar Kejriwal to the plaint which was filed by you in this honorable court and numbered as CS number 377 of 2013. Just turn over, you will find the written statement. I'm sure you have seen it before.
This is a reply of Ramesh Kejriwal.
Yes.
The reply of Ramesh.
Or may this be exhibited. Written statement, I can, he's identified it also. Makes no difference really. Records of this court, I can give production and exhibit it also. It's just saving
His
time.
witness will be coming. But defendant's witness will be coming.
What does it matter? It's my evidence in any case because I am asking him.
His witness will be coming any event.
Your witness will come. He has identified.
It is identified.
Then marked, I think X4.
Yeah, whatever.
X4
Mark
for
for
identification.
But so far the
document appearing at page number 52. 52 to
52 to
52
637.
What is PD?
PD8.
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 PD8. Marked as
X4 for
identification. X4 है क्या? X4 for identification.
Remember the
X4.
Konta?
But the document is called for in answer to question 126. Mr. Chaudhary asked, this is the
That already recorded.
No, he said has given to my lawyer. So now this is the document.
No, he has not asked for the production. He has not asked for the production. He has given to the lawyer. He will take steps what he wants.
Okay. No, the question records, can you produce
question,
it?
he had put the question.
Can you produce
the
it?
witness stated that it has been given to the advocate.
And
So,
then it's stopped.
so that is his chance to what he will take the step for the matter.
I have with me. Okay.
No, really speaking, it is for them to now by a letter disclose the document, then I will exhibit.
That's why. So that's why after that, what he will do, the court,
We will.
either he will ask for the document from you or you.
I will produce. I'll
make
once again their affidavit.
I'll make it quicker and I'll just ask a question and do it. এটা কি DD3? না এটা হলো হ্যাঁ shown page 302 of the judge's brief of documents, volume 2. You will find, now do you find that this is the judge's brief of documents in CS number 377 of 2013, which is a suit filed by you?
सूट आपने फाइल किया था
Yes.
Yes. Shown page 1316 to 1334 and 1348 to 1501. Of the judge's brief of documents, which are a part of your disclosures in the suit that I have just now referred to. Please identify the documents which I have just now shown you and indicate whether these are medical bills disclosed by you in the other suit. (1316) to 1334, 1348 to 1501. They are all medical bills which he has produced in another suit for reimbursement against my clients.
(1501) 1501 পর্যন্ত क्या ये मेडिकल बिल है जो आपने प्रीवियस सूट में जमा किया था 1501 सर
डॉक्यूमेंट তোর কাছে আছে পেছনে লাগা যাবে
लास्ट
Medical bill.
क्या ये मेडिकल बिल है
Yes, the medical bill.
मेडिकल बिल्स
May these be marked as exhibits.
What are the exhibit number?
Exhibit number?
Last was PP.
PP was the last, yes. Exhibit PP was
QQ. You want a PP? It's a QQ.
না এটা QQ
Which are the pages?
হ্যাঁ বলে দিচ্ছি তোকে পেজেস হলো
Pages.
1316 to 1334 and 1348 to 1501.
Collectively, yeah.
Exhibit Q হলো তাহলে
QQ
Q. So 1.01 or 1.1?
01.
1.01.
সবটাই একসাথে কিউ কিউ করে
On 16th March 2010, your father was diagnosed to require knee replacement. Can you confirm this?
16 मार्च 2010 को आपके पिताजी को डायग्नोस किया गया था उनकी नी रिप्लेस घुटना बदलने
2010 में हुआ
ये
था
कंफर्म कर सकते हैं
2010 में कंफर्म करते हैं 16 मार्च या क्या वो देखना होगा
it was confirmed in the year 2010 I have to check the exact date was it whether it was 16th March or not
Whether it's 16 March, I don't remember.
Or not.
Yes. Shown page 1330 within bracket part of exhibit QQ. Can you now confirm the date from the receipt issued by Dr. Arun Mulaji, MULLAJI?
क्या ये रिसीट देखकर अब आप कंफर्म कर सकते हैं
So this is consultation bill, but not the surgery bill. तो
This is
maybe
the
आगे
consult-
पीछे हुआ होगा.
This is the consultation bill and not the surgery bill. Maybe
माने सर्जरी आगे पीछे हुआ होगा वो डेट देख
maybe
के
the surgery was happened prior to this or after this. Prior to the date or after the date.
Shown page 1331, which is also a part of exhibit QQ.
So
This is another, is this another consultation bill dated 1st March 2010?
क्या ये एक
1st May 2010?
क्या ये एक और कंसल्टेशन बिल है? पहला मई 2010 का.
हाँ, this is showing एक बार पहला वाला बिल देखे.
Easy.
1st May 2010. This is again a consultation bill.
Yes, this is again a consultation bill dated 1st May 2010.
Shown shown page 1332, part of exhibit QQ. What is this document?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
सर्जरी होने के बाद या उसके बाद पहले पूरा शरीर का चेकअप होता है डिफरेंट डॉक्टर से. ये प्रोबेबली एक और डॉक्टर है जो उनका माने सर्जरी के पहले चेकिंग किया.
बिफोर सर्जरी के पहले.
पहले या
document shows that before surgery some investigation was done.
Correct. So, so 8th May 2010 is immediately before the surgery.
सर्जरी
That
का
correct?
बाद देखना होगा सर. हमको डेट देख के बता सकता है सर्जरी कब हुआ.
I have to check the date to confirm when the surgery was happened.
But the document dated 8th May 2010 is of Breach Candy Hospital, Bombay. And therefore, I suggest to you that he must have been admitted there for surgery on 8th May 2010. Must have been admitted there for surgery on 8th May 2010.
8 मई 2010 का जो डॉक्यूमेंट है ये ब्रिज कैंडी हॉस्पिटल मुंबई का है. तो वो आपको सजेशन दे रहे हैं कि आपके पिताजी शायद हॉस्पिटल में भर्ती हुए होंगे.
शायद हो सकते हैं. शायद हो सकते हैं
Maybe.
इस समय.
Maybe he was admitted.
Okay. You are not sure that whether he was admitted or not.
He was admitted. 2010 में उनका नी रिप्लेसमेंट हुआ.
He was admitted.
बट डेट हमको
In the
नहीं.
year 2010, the knee replacement was taken place. बोलिए.
I am
Date
showing.
हमको
I
पता है.
cannot confirm the date.
I
I
can confirm that exactly.
I am showing you pages 1332 to 1334 of Judge's Brief of Documents being part of Exhibit QQ, which are all documents of Breach Candy Hospital. And show that between 8th May 2010 and 22nd May 2010, your father was admitted in Breach Candy Hospital for his knee surgery that was suggested on 16th March 2010.
1332 से 1334 में जो डॉक्यूमेंट है उन सब में ये दिखा जा रहा है कि 8 मई 2010 से 22 मई 2010 तक आपके पिताजी ब्रिज कैंडी हॉस्पिटल में एडमिटेड थे नी रिप्लेसमेंट सर्जरी के लिए, जो 16 मार्च 2010 को उनको सजेस्ट किया गया था. क्या ये सही है?
21/5/2010 का ये सर्जरी का बिल है. तो इस पीरियड में बाजी एडमिट हुए.
The document appearing at page number 1334 is a
सर्जरी बिल.
surgery bill of Breach Candy Hospital dated for 21st May 2010. This suggests that my father was admitted in the Bridge Candy Hospital at that period of time
for knee replacement.
for knee replacement surgery.
On now, please see page 1331, part of exhibit QQ, which will also show that on 1st May 2010, your father was in Bombay for treatment at Breach Candy Hospital. 1331 Barker.
Yes, sir.
Yes.
Yes.
Where was your father on 2nd May 2010?
2nd May 2010 को आपके पिताजी कहाँ पर थे?
हम नहीं बता सकते.
I cannot say that.
Were you not with him on 2nd May 2010?
क्या आप उनके साथ नहीं थे 2nd May 2010 को? आप उनके साथ थे या नहीं थे?
हमको नहीं याद नहीं है.
I do not remember that.
Would your answer be the same for 3rd to 7th May 2010?
3 से 7 मई 2010 तक क्या आप आपके पिताजी के साथ थे या नहीं थे?
नहीं, हमको याद नहीं है ये चीज.
I do not remember that.
I suggest to you that your evidence is false and contradictory.
वो आपको सजेशन दे रहे हैं कि आप जो एविडेंस दे रहे हैं ना ये गलत है और ये खुद में ही कॉन्ट्राडिक्टरी है.
I disagree.
I disagree.
Please see question 512 and your answer to the same.
क्योंकि वाला डॉक्यूमेंट दो.
I want to.
Huh? 13162.
Can you produce the documents today?
सर सब जमा दे दिए आप लोग को.
I have submitted all these documents.
Just see that shown
My lord, let it be recorded that the document was produced in court.
I'm just showing it to him. Only thing is that very well shown director's report. Normally, if it's by a covering letter,
That's
it
why
can be
that's
easily
why
identified.
That's why if it is so, then you have to write a letter in terms of this. You have to produce the document.
Yes.
Then they will produce that.
Then they'll
Then
produce.
they will produce.
Or the
Otherwise,
next day we'll do it.
that you take note of. Then you wrote to them.
Yes,
then
yes. The
they will-
3 documents which are with him. So this is over. Aha. Right. Yes. So this is over. This is over. This is next day. Do you remember an office space situated at 12 capital A NS Road, which until 2014 was mortgaged with Punjab National Bank or some other bank, but which is not reflected in your father's affidavit of assets? In the affidavit of assets pertaining to the present proceedings, not father's affidavit. Affidavit of assets pertaining to present proceedings.
क्या आपको याद है 12 कैपिटल ए NS 12 कैपिटल ए NS रोड जो 2014 साल तक मॉर्गेज था, ऑफिस था एक जो 2014 साल तक मॉर्गेज था, जो एफिडेविट ऑफ एविडेंस जो इस मामले में एफिडेविट ऑफ एसेट जो इस मामले में आपने दिया है उसमें दिखाया नहीं गया है, को याद है?
नहीं,
I do not remember. I do not remember. I do not remember.
Can you please find out and inform the honorable court on the next day?
क्या आप इसके बारे में पता करके नेक्स्ट डे बता सकते हैं?
हम क्वेश्चन ही नहीं समझा इनका।
क्वेश्चन नहीं समझा?
मैंने कौन सा चीज ये बोल रहे हैं नहीं समझे हम।
12A NS रोड में एक ऑफिस था जो 2014 साल तक मॉर्गेज था। आपने जो एफिडेविट ऑफ एसेट्स जमा किया है इस मामले में, उसमें इसका जिक्र नहीं है। क्या आप बता सकते हैं याद करके इस ऑफिस के बारे में?
वहाँ हम लोग का 3 ऑफिस था।
We had 3
वो कौन सा ऑफिस के लिए ये बोल रहे हैं वो नहीं समझ में आ रहा है।
हाँ हाँ कोई दिन आंसर है।
He had 3 offices at that address. I cannot understand about that office. Asking the question. The advocate is asking the question about this office. The learned advocate is asking the question.
Do you remember were any of the 3 offices in your father's name?
क्या इन तीनों ऑफिस में से किसी भी ऑफिस आपके पिताजी के नाम पे था?
हाँ, एक ऑफिस बाबूजी के नाम में था।
Yes.
What was the number of that office?
One office was in the name of my father. Number क्या था?
नंबर याद नहीं।
I do not know.
And what happened to that office?
उस ऑफिस का क्या हुआ? क्या हुआ उस ऑफिस का?
Ramesh forcibly took over that office, throwing father out from there.
Ramesh forcibly took over the office, throwing father out of that office.
It is documented.
It is documented.
And why is that office not mentioned in your father's in the affidavit of assets in this proceeding?
Affidavit of assets में उसका जिक्र क्यों नहीं है उस ऑफिस का?
हमको वो आइडिया नहीं, देखना
I
पड़ेगा।
do not have any idea. I have to check.
Do you have any documents pertaining to that office?
उस ऑफिस के सिलसिले में आपके पास कोई डॉक्यूमेंट वगैरह है?
Xerox documents है हमारे पास।
I have photocopies of documents.
What documents do you have?
क्या डॉक्यूमेंट है आपके पास?
प्रॉपर्टी टैक्स का कागज मिलेगा हमारे पास।
I have the property tax documents with me.
मेंटेनेंस चार्जेस जो वो बिल्डिंग वाले को देते थे वो उसका कागज मिलेगा।
The maintenance charges document which we have to pay the building authority. Documents regarding this. और कुछ?
और
And
एक लेटर मिलेगा, वो कंपनी का क्या नाम है,
the letter.
एक रमेश का एडवोकेट ककरानिया कंपनी लेटर दिया था उस ऑफिस के लिए, वो लेटर मिलेगा।
And a letter which was given by Ramesh's advocate, that was Mr. Kakrania and company regarding that office, regarding the said office.
Did you who is in possession of the office now?
ये ऑफिस किसके पोजीशन में?
रमेश के।
रमेश, in the possession of Ramesh.
What about the other two offices who are in possession of the other two offices?
बाकी दो ऑफिस किसके पोजीशन में है?
एक ऑफिस मेरे पोजीशन में, रमेश के पास एक और ऑफिस में। तो रमेश के पास 2 ऑफिस पोजीशन में, मेरे पास 1 ऑफिस पोजीशन में।
Ramesh has 2 office in his position and I have 1 office in my
The
position.
office is the office which is the office of which you are in possession in your name?
Yes, sir. It is in my name.
Yes, it is in my name.
And in whose name are the 2 offices which are in Ramesh Kejriwal's possession?
रमेश के पोजीशन में जो 2 ऑफिस है वो किसके नाम पर है?
एक बाबूजी के नाम, एक मुरारी मोहन केजरीवाल के नाम से है।
Out of the 2 office, one is in the name of Murari Mohan Kejriwal and another one is
रमेश कुमार केजरीवाल HUF के नाम से।
and another one is in the name of Ramesh Kumar Kejriwal HUF.
ठीक है, ছেড়ে দাও, পরের দিন চেপে ধরবো। On 22nd May 2010, there was a letter which was issued ostensibly by your father to Ramesh Kejriwal, which is at page 002-971 of paper books filed in APO 210 of 2013. I am copy আছে? না, চিঠিটার আলাদা কপি আছে? বাহ, চমৎকার। I'll withdraw the question because we don't have a copy of the letter. I'll ask it the next day. I'll bring this is company. I'll request my learned friends to make it quicker. These are company matters. Section 10F appeal pending in this honorable court.
Okay.
This is disclosed in that paper book. Part of company law board records. I can give production and prove the document, or if I give the copies to my learned friend with the page number, let them see it, tally it with their own records, and I'll ask him show the documents on the next day.
Okay.
Oh, we have already given production, so we can do it.
Hey, Manutosh, you witness ko through court. Through court. Shown page number 1352 and 1353.
135.
Tell the date of admission and tell the date of discharge of the father.
I wanted to,
आपके पिताजी
I wrote it down.
डेट में एडमिट हुए थे और किस डेट में डिस्चार्ज हुए थे बताइए। The date of admission is 11th May 2010 and the date of discharge is 22nd May 2010.
Next page. What is the date mentioned? Date of admission and date of discharge.
The date of the invoice is 22nd May 2010. Date of admission is 11th May 2010. And the date of discharge is 22nd May 2010.
8th May he was in Bombay.
That is consultation. Which the document you have taken into consideration, that is a consultation.
Yes.
That's why I asked the document.
In breach candy.
Breach candy. 4 consultation doctors. 4th consultation, 11th admitted, 22nd discharge.
6th May evening is the alleged execution in Calcutta. 1st May he was in Bombay. Why did he come back? Yes, that is the point.
Swenson suffering for the plaintiff. Swenson suffering for the
Lord, may I have leave?
plaintiff witness is present. Cross-exam. Witness number 1.
My lord, second witness.
Plaintiff
First
witness
was
number
the
2.
attesting witness.
Plaintiff witness number 2 is present and cross-examination resumed, but due to paucity of time, cross-examination could not be completed. Cross-examination is defer. Yes, date है क्या again नहीं ना? Let the matter appear on 6th March at 2 p.m.
Chip, sir. 6th March.
6th March at 2 p.m.
2 p.m.
Grateful to my lord.
Grateful.
Next.
I appear for the plaintiff in both the suits, my lord.
May it please your lordship, I am for the defendants.
Applications have been taken out by the defendant, my lord. They can
If
start.
there's my application for
What is the
rejection
application
of for rejection of the plaint.
Which one are you
For
moving?
the rejection of
Which one? You have filed two.
Reading is completed.
filed only one application for rejection of plaint.
First item is, my lord,
Lordship, may I indicate the
it's
facts?
2011 suit where, my lord, they filed a recalling application. That's the first item appearing in the list. Perhaps that should be
CS 203 of 11.
Yes,
That is the
that is
first item number.
203 of 2011. That is the first suit.
That is in respect of a different suit, which is now pending before Honorable Justice Sugata Majumdar.
Huh?
Before Honorable Justice
Sugata
Sugata Majumdar. From that order, here Justice Majumdar has passed an order, and we had to prefer an appeal from Honorable Justice Majumdar's order. Now that appeal is pending, and this application is for recalling of your lordship's order when your lordship was sitting at determination and had taken up that suit. For that order, this recalling application has been filed. However, the appeal, we have not been able to get it heard out, that appeal, because it is our fault. We should have.
That is earlier for application suit.
Yes, earlier. But
And
in
this
respect of
GA1 is in connection with
rejection of plaint, I will move that.
My lord, before that, perhaps last occasion, my lord, I was being led by Mr. Chaudhary, my lord, in respect of the application of the 2011 suit. Perhaps that is to the infractors. That was our submission because they had filed an application before Honorable Justice Majumdar seeking extension of time to file the written statement. That application was rejected by a detailed order. This is what they have carried up in appeal. Subsequently, they filed an application after that application was filed. They filed an application seeking recalling of my lord's order, directing this matter to appear in the undefended list. So now once an order has come by a coordinate bench, my lord will kindly have a look. My lord, this application, perhaps it will have to let the appeal be decided. I am not standing in the way, but this application has to go, perhaps.
Lordship, I will be very candid why that application was filed in the first place. In the event, I am assuming that if I fail in the appeal, and if the Honorable Division Bench is on the view that the Honorable Division Bench would not grant me any observation regarding my right to cross-examine. In that
cross-examine, who has closed?
Yes.
Nobody has closed.
Nobody is, Lordship, in that anticipation, this order, this application has been filed only. Lordship, let it stay. Till then, I'll.
Which one?
The recalling application.
So the first item in the list, that's in the 2000.
First item, see, first item, I had passed an order sitting in that jurisdiction.
Yes.
The suit was placed in the undefended.
Yes.
Correct.
Yes.
Thereafter, you filed an application for filing written statement.
For filing.
For filing written statement along with counterclaim.
Yes. Yes.
That was rejected.
That was rejected.
Next is, now you filed the appeal against this order. Filed by the Justice Majumdar.
Yes.
That is order dated 22nd August.
Lordship.
Correct.
Lordship.
Now you have filed this application in CS 203 for recalling of my order,
yes,
wherein this court has passed has placed the matter in the undefended suit.
Undefended.
So my order has been merged with the order of the Justice Majumdar.
Merged with the order.
So
In essence, Lordship, if that is so, I shall withdraw it.
Man,
I
let
shall
that be
withdraw
recorded.
it. I
Yes.
don't.
Yes.
Let it. Let it.
Yes.
And as for my application for rejection of plaint,
Yes. What is the ground in the
Worship, the
rejection?
ground is it's one
What is the suit for?
small ground. I will indicate everything. I'll indicate everything. Worship, the inception of the matter starts from a will which was of Dulal Chandra Bhor. The plaintiff and the defendant, Dhananjay Bhor and Amit Bhor, are brothers. The will states that I will be colloquial in my submission. I will not go to the integrities. The will states that Dhananjay Bhor gets a part of the properties and Amit Bhor also gets a part of the properties. The will was probated. There were two executors, Dhananjay Bhor and Amit Bhor. However, only Dhananjay Bhor files the probate application. Probate was granted. It was contested by me. Probate was granted. Thereafter, after the probate was granted, there are certain procedures that needs to be followed. This particular suit is for recovery of possession against Amit Bhor, who is residing in one of the properties which has been given to Dhananjay Bhor. My submission today will be that there is no cause of action. This suit is premature and there is no cause of action that this suit has been filed, because there are certain characters that play a huge role in after that probate has been granted. Character A, the executor. B, the beneficiary, in this case. C, another beneficiary. I am making it as ABC because in my respect, Dhananjay Bhor is the executor as well as the one of the legatees. So is Amit Bhor. So once a probate has been granted, there has to be an assent. Because once the will has been executed, thereafter, when the person executor dies, the beneficiaries become the owners. Now, after they become the owner, after the probate, their title becomes concrete, but only after the assent that it gets complete. Kashyap, I will evidently not go out of the plaint. That is the reason I've only taken the plaint at hand. If your Lordship kindly takes up the plaint, I will very shortly and briefly place the plaint today.
Yes.
Lordship, it has been stated that Dulal Chandra Bhor was the owner of a two-storied building erected on a land measuring about 5 kata 14 chotak, so and so. Thereafter, the plaintiff is the eldest son of the introduction part. Thereafter, introduction of the defendant in paragraph 3. Paragraph 4, it is important that Dulal Chandra Bhor died on 27 June 2000, leaving behind his last will and testament dated 1st December 1999. Inter alia, bequeathing the suit property to the plaintiff. Both the plaintiff and the defendant number 1 were appointed joint executors by the said will. Now, defendant number 1, it has been alleged that refused and neglected to discharge his duties. Thereafter, the probate was granted, stated in paragraph number 6. and subsequent proceedings stated in paragraph number 7.
Yes.
Now, Lordship, paragraph number 8.
Yes.
This is essentially the cause of action.
Yes.
The plaintiff, in his capacity as an executor,
Yes.
has expressly and/or impliedly assented to his own legacy to complete the title of the plaintiff to the suit property. It has been alleged that there is assent to the suit property. Now, my submission is that there has not been any assent. There has not been any assent because the way it has been stated that it has expressly and/or impliedly assented, I say that assent could not have been made in such way that has been stated here. Next line, by reason thereof, the plaintiff has become the owner of the suit property with effect from 27 June 2000, with the right of the plaintiff being established in relation to the suit property after the grant of the probate of the said will. So this also states that only after the probate that right has accrued to them to file, and it has also been admitted that they have that assent is necessity. Assent is a necessity in that.
Assent by whom?
Assent by, in this case, the plaintiff Dhananjay Bhor is the executor, and the suit property here is also the property of the plaintiff. So the the plaintiff sitting in the chair of the executor has to give assent to the plaintiff again sitting in the chair of the legatee. That assent cannot be in a normal way. That assent cannot be by a mere pleading. There has to be an act. That is not there. Lordship, thereafter, the defendants have been in occupation of the suit property since 2001. The defendant number 1 at all material times prior to the death of Dural Chandra Bhor was residing at the family residence of the Bhor family at 180 Bidhan Sharoni, Kolkata, along with the other defendants. Paragraph 10. Inasmuch as the right of the plaintiff in the suit property has been established with the grant of the probate of the said will, the plaintiff has duly exercised such right in the suit property and has not assented to the occupation of the defendants in the suit property. Very well. Thereafter, the mother of the plaintiff, Urmila Bhor, who continued to be in occupation of the suit property, died on 13th February 2011. The plaintiff has revoked and/or in any event is deemed to have revoked the permissive occupation of the defendants in the suit property in the facts as aforesaid. Here, for the first time, the plaintiff has stated that the plaintiff has revoked that permissive occupation. If your Lordship kindly comes to section 332 of the Indian Succession Act. 330.
Yes.
Yes. Assent necessary to complete legatee's title. The assent of the executor or administrator is necessary to complete legacy's title to his legacy. So today, this if the suit property is the legacy, even if the plaintiff is the executor and the legatee all in himself, even then he has to complete the title. Before that, this suit could not have been filed. Now, in respect of a fact situation where the executor and the legatee is different, that is very simple in every aspect. That the legatee deed can be a letter can be given to the legatee. It can be verbally made that assent has been done. Assent, however, even if it is a simple thing, it is very necessary. That is established that assent has to be there. In rest, what happens? I ask this question to myself: what happens now that the executor is the legatee? That answer is there in section 335. Section 335, I will read out. When the executor or administrator is a legatee, his assent to his own legacy is necessary to complete his title to it in the same way as it is required when the bequest is to another person.
Yes.
And his assent may, in like manner, be expressed or implied.
Yes.
It has been stated that assent has been given expressly and / or impliedly. However, subsection 2 has not been followed. Assent shall be implied if in his manner of administering the property he does any act which is referable to his character of legatee and is not referable to his character of executor or administrator. Lordship, there has to be an act, any kind of implication that says that me, the executor, sitting in my chair is giving a right to myself sitting in the chair of the legacy. For example, that there is an amount of money.
Leaving aside that,
Lordship,
if suppose in this case itself, this is joint, it was the property of the father.
Yes.
Mother was living.
Yes.
Father has executed the will.
Yes.
Two brothers given 2 shares.
Yes.
But after the probate, it was found that the share which has been given to one of the son, who is one of the executor, the other executor is in possession.
Yes.
Who will give the assent?
The assent has to be given to the by the plaintiff, Dhananjay Bhatt, to himself.
Huh?
Dhananjay Bhatt to himself.
Huh.
That assent has to be given.
To whom?
To himself.
So,
yes.
So
that
if he's telling that the assent has been given,
yes,
so
that
how
is
do you
my subsection.
Just to cut the long story short, if this is his ground, kindly seize, my lord, one, that document, since we have not, my lord, filed affidavit, in the plaint we have relied on the
Is
deed
there?
of
I
assent.
will deed of
Deed of
assent is
assent,
there. I will come to that.
335 is my answer. With the deed of
Yes,
assent,
I
it's a
will come
complete
to
answer.
that. I will come to.
And lordship's query, which the example which lordship just now, my lord, asked him.
That's I'm asking. It is
Yes.
the case. So from where you are asking, he is telling that I given the assent.
Yes,
So
he is telling that.
That
Subsection 2, lordship, kindly. Assent shall be implied if in his manner of administering the property he does act which is referable to his character of legatee. He has to do an act which makes him the legatee.
Correct.
In a place.
Correct.
In this aspect, I will give an example. For example, a money is lying in the bank account of an executor. That money he is entitled to. Now he uses that interest or that money for his own benefit. He can show it that assent has been granted. Assent has been done. Immovable property, the rental incomes for the immovable property, he uses that for his own use. Assent has been granted. In this respect, lordship, the assent had to be given before the suit is filed. I asked this question to myself, where is that assent?
That's why can you come to the
Yes,
page,
yes.
page 9? Page
Paragraph
9.
number 9. Defendants have been in
Come to the page 9.
Page 9.
Page 9 of the plaint. Document relied upon by the plaintiff.
Deed of assent.
Deed of assent
dated
dated 28 June 2023. When the plaint is filed.
Lordship, the plaint has been filed in July.
July.
Now, Lordship, kindly, in paragraph 8, it has been written the plaintiff in his capacity as the executor has expressly and/slash or impliedly assented to his own legacy. That it has to be stated how the cause of action has to be complete. It cannot be that they have relied to a document, deed of assent dated June 23 to the 2023. That cannot be,
So
the court.
if it is so, you are telling that it is how this court can decide under Order 7 Rule 11. This is a matter of the trial. So
Rashid,
you can take
that
the
is
defense.
there.
You can put the question in the trial with the.
But that cause of action has to be complete.
That's what I'm telling. See, your simple case is that what the assent they have relied upon, that assent has not been completed.
Yes.
If the assent has not been completed, cause of action does not arouse. If the cause of action has not aroused, the suit does not lie. These are the three things.
That is there.
Correct. These are the connected one.
Connected.
So now they have taken the plea. They have taken the assent by the deed of assent on 28th of June 2023. Subsequent in the month of July, they have filed the suit. Now you are telling that no, that is not the assent. That is not the assent. If it is taken to be assent, it is not a complete assent.
Complete assent.
If it is not a complete assent, it is not a cause of action.
Cause of action.
Correct. So it is how this court can decide in the interlocutory application. Then you have to prove
Lordship,
of evidence. And with regard to the cause of action, you know the cause of action is the bundle of facts. It has
bundle of facts. That bundle of facts has to be complete because today
that's why that is to be during evidence, not in the by way of the interlocutory application.
The pleading has to be, in my respect, the pleading has to be there.
What
because
pleading?
Today the pleading is there that assent has been granted.
Correct.
Now in the documents which has been relied upon, it has been stated that in deed of assent is there. Now, today, if it is not stated as to how the assent is there, then the pleadings are not complete. Because from paragraph 8 to...
See, if you read with the paragraph 9, that is the assent which they are telling that. Correct.
Yes.
Now kindly come to the paragraph 10. Last line. The defendants are presently in occupation of suit property wrongfully and trespass. So that's the assent. You are not vacated. You are still in occupation. That's why what is the prayer? Eviction.
Eviction.
So it is to be read together.
Yes, but why am I urging upon the? I asked this question to myself. Why am I urging upon the fact that there has to be an act? That is very important. There has to be an act. Even if a deed of assent has been executed.
How you can disbelieve or this court can disbelieve with regard to the act? This is
I am not disbelieving
then
in that respect. What I am stating that if there is an act in this instant, the execution of the deed of assent, I am assuming that execution was done without the defendants. I am assuming that execution was done without the defendants. That has to be pleaded here. That the act was the execution. Until and unless that is pleaded here, the cause of action is not complete. Number one. Number two, another act could have also been pleaded that the plaintiff has intimated the defendant regarding the fact that you leave the property. This is my property. That could have been another act. But without making an act and without stating as to how the cause of action arises, this plaint and this cause of action is not complete. Because they have stated that assent has been granted and only without any pleadings, it has been written that deed of assent is there. Now, can the Honorable Court read between the lines to say that this is that act of assent?
Okay. So you mean to say the document which they have relied upon, that they have not pleaded how this assent has been obtained? This is
yes.
That is the
yes. This is a point for me in the suit, but there are multiple beneficiaries. So one deed of assent cannot be executed singularly. So if that is not pleaded as to how that has been executed singularly, that is a question, and that is the reason that simpliciter answer to that deed of assent dated to 28 June 2023 cannot be formulated.
Why you are not coming forward and settle that? Now the will chapter is over.
Will chapter is over.
And up to Supreme Court.
Yes.
So what will come and sit and settle that dispute? Why this all the things? Yes, why you come with
That
the
is not
you come with
really
a
up to
counterclaim.
that is really not up to me to but I will indicate that.
What will happen? This is tight now. It has come as a
I will be very honest why the settlement is not there. Because assuming out of my submissions I'm speaking here.
I am telling.
Yes, out
Then
of
you
my
tell. Because I have dealt with in the appeal. I have dealt with in the appeal of this matter. Correct. The only settlement will not come because you are not agreed with the proposed settlement, proposed will, the part which has been given to the plaintiff. He got more benefit than you. That's why you're not settled.
But I am not even getting my benefit.
Why?
Because we have tried.
That's why if you're not
That
getting
is the reason we
so
are
if
trying
you're
to
not
defend.
getting the benefit, so only by objecting when you come with a counterclaim and file it.
Yes,
But sit together.
that we have to hear awaiting instructions. We have
Sit
to do that.
together.
But till then, I must defend
Both brothers. Now one chapter is over, the second chapter, then how again it will go. Sit together, leave it and all because sisters are not coming now.
No.
Then mother died. Sisters are not coming, both brothers. Probate granted. You are also got the benefit. You're telling that you are not giving the sit together or otherwise come with the both the suit can be disposed of. Take instruction. Yes, Mr. Dattu.
My lord, we have the executor after the my lord will was provided up to Supreme Court. Executor tendered my lord the money also which they were entitled to under the will. I have taken instructions, my lord. They have not accepted it.
Yes, because the
why I don't know.
Why?
Because the special officers were there. The question of
I will indicate
No, these
why.
special officers were there over that business.
That's why I'm
They have also not filed the inventory till now for that revocation of the
My lord,
probate.
is there an allegation against the executor today in any proceedings?
Today
My lord,
it is
these are my lord statements from the lordship is considering the order 7 rule 11 application. 5 minutes I will answer my lord his application.
Okay, continue.
হয়ে গেছে না আরো আছে?
না এগুলো আছে। Actually, one judgment regarding the cause of action. May I cite? Paragraph 23 and 24 of this judgment, 2005-10 SCC 5-1, Swami Atmananda and versus Sri Ramakrishna Topovanam. Paragraph 23 and 24. Osborne's concise law dictionary defines cause of action as the fact or combination of facts which give rise to a right or action. In Black's Law Dictionary, it has been stated that the expression cause of action is the fact or facts which give a person a right to judicial relief. In my aspect, that right is not accruing until and unless they state as to how that assent has been given. That act has to be specifically enumerated. If the legatee was a different person and the executor was a different person, in that respect, only that pleading would be sufficient. But here, as per section 335 subsection 2, that act has to be mentioned. In Stroud's Judicial Dictionary, a cause of action is stated to be the entire set of facts that give rise to an enforceable claim. The phrase comprises every fact which, if traversed, the plaintiff must prove in order to obtain judgment.
Yes.
Next paragraph, a cause of action thus means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. Every fact, if assent has been granted, as to how assent has been granted, all these bundle of facts has to be pleaded and thereafter proved. In other words, it is the bundle of facts which taken with the law applicable to them gives the plaintiff a right to relief against the defendant. It must include some act done by the defendant since in the absence of such an act, no cause of action can possibly accrue and vice versa.
Correct.
It is not limited to the actual infringement of the right sued on, but includes all the material facts on which it is founded. Even if it is an act that cannot be read between the lines, that I have stated in paragraph 8 that assent has been done, as to how that we have to guess through deed of assent because it has been mentioned. That is an afterthought. That is clearly an afterthought. Another only one judgment I will refer. But just to, for my benefit to state the law, it's a Chancery Division judgment. Right. 1924 Chancery Division. Page number 467. Rough page. Lordship, is that a rough page that I have? Is that a rough page?
No.
That is a fresh one. 467. Internal page 8.
Yes.
I will place that. The first question is, was there such a breach as the plaintiff alleges? The defendants deny it because they say there never was any assent by them to the bequest. The question of assent is one, no doubt, mainly of fact. It is not suggested that in order to prove assent, it is necessary to show affirmatively that the executors, either verbally or in written, formally expressed assent. It is considered that the assent may be implied from conduct on their part. And the plaintiffs rely upon conduct which they say is unequivocal and unambiguous as establishing the assent. The conduct is of this character. The testator left a large estate and appointed as his executors his son and daughter. The son was, as was to be supposed, took the active share in the administration and has told us that his one desire was to get the estate cleared and settled up as quickly as he could. Having regard to the magnitude of the estate, no time was lost in obtaining probate. The death was in November and probate was granted in January. No necessary time was expended in payment of the debts, which were very small, or in paying or providing for the pecuniary and other legacies, some of them of large amount. Everything was done in as much expedition as circumstances and magnitude of the estate, which consisted both of realty and personality, permitted, and the residuary account was passed in June 1913. Nor was this all. Before the residuary account was finally passed and the duty paid, it becomes necessary to provide for the duty on the specific bequest to which this action relates, and in August 1912, less than a year after the testator's death, accounts were delivered and the duty paid in respect of the widow's succession and the settlement created by the bequest. All these one facts, this is clear that there has to be a conduct. If there has to be a conduct, then that conduct has to be pleaded. That cannot be left to the imagination for the defendants in regard to the same. This is my submission.
Yes, that's all.
That's all. I will.
Well, it kindly takes the plained ones, 2 provisions from the Succession Act and 1 provision from the CPC.
My lord, in the plaint, my lord, I have in first paragraph described, my lord, the property. Then, my lord, about the will, probate granted, challenged up to the, my lord, division bench, and then Supreme Court, how, my lord, title ultimately comes to the, my lord, plaintiff. Now, two paragraphs I want to show from the, my lord, plaint at page 20, running page 20, internal page 3 of the plaint.
Running page?
20, my lord.
Plaint.
Of the that plaint is annexed, my lord, in the application. So running page 20 would be internal.
Application, they are not in here.
Plaint annexed, my lord.
Not,
My lord is looking at application GA number 2.
GA 2.
He was, my lord, rejection of plaint is, my lord, GA 2. Right? The plaint is part of this application, my lord. Now, if lordship comes to, my lord, page 20, running page 20. Para 5, defendant number 1 refused, failed, neglected to discharge the obligations as joint executor of the will. Reason thereof, plaintiff was constrained to file an application for grant of probate. Proceeding was contested by the defendant number 1 and other legal heirs of Dulal Chandrabhor, set down as a contentious cause, numbered as so and so. Then, my lord, the two judgments of the, my lord, our High Court. Paragraph 8. Plaintiff, in his capacity as the executor, has expressly and or impliedly assented to his own legacy to complete the title of the plaintiff to the suit property. By reason thereof, plaintiff has become the owner of the suit property with effect from 27 June 2000, with the right of the plaintiff being established in relation to the suit property after grant of the probate of the said will. My lord, just pausing here for a moment, kindly takes, my lord, order 6 rule 2. This is not a commercial suit. So, my lord, kindly takes order 6 rule 2 of the CPC. Or I'll just place it for your lordship. Because I am not required to, my lord, plead evidence in the plaint. My learned friend is making a, my lord, in his submissions, my lord, he is possibly making or trying to, my lord, make a difference between a triable issue and a demurrable issue. My lord, I say, my lord, this is not a demurrable issue. This is at best a triable issue.
That's it.
Pleading to state material facts and not evidence. Every pleading shall contain and contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. So, my lord, why, my lord, this pleading at paragraph 8 of the plaint? Now, kindly, my lord, takes, my lord, the Succession Act and kindly comes to, my lord, two provisions. One which he relies upon is is section 332, which according to me is not applicable in my case, because here, my lord, the executor and beneficiary was the same in respect of this suit property. So 332 is the general provision which my learned friend first relies. Assent of the executor or administrator is necessary to complete a legatee's title to his legacy. No quarrel with that proposition. Kindly comes to 335. When the executor or administrator is a legatee, his assent to his own legacy is necessary to complete his title to it in the same way as it is required when the bequest is to another person, and his assent may, in like manner, be expressed or implied. In my case, it is expressed because I have referred to the deed of assent also as part of the disclosures which I file or which I wish to rely upon along with my plaint.
So that's why they are telling that the deed which you rely upon, that you have not elaborated in any of the paragraphs.
I am not required to.
No,
Order
this
6,
is-
that is his contention. And lordship also, my lord, apropos this contention of his lordship posed a query, because I am not required to, my lord, lead evidence in the plaint. I am only required to state this fact, the fact which is material, to demonstrate or establish that as a beneficiary, my lord, or as an executor, my lord, who is also the beneficiary, there has been an assent. So, my lord, that pleading is there, the provisions are there, my lord. He also relies upon subsection 2, and he says, my lord, I'll just read subsection 2. Assent shall be implied if in his manner of administering the property he does any act which is referable to his character of legatee and is not referable to his character of executor or administrator. My institution of the suit is, my lord, exercising power under 335(2). I am not instituting the suit in the capacity of executor or administrator. I say there has been assent to legacy. title has devolved upon me pursuant to the probate granted. Therefore, I am now entitled to seek eviction from the Duff Lane property, which is the suit property. So, my lord, these issues at best can be raised by my learned friend in course of, my lord, witness action if we reach that stage, but not, my lord, presently, my lord, at the demurrable stage. So, my lord, Order 7, Rule 11 application, the ground in his application is really paragraph 6, which lordship took note of. Though, my lord, according to me, these application or averments are really not required to be gone into. Lordship has to see the plaint and find out, my lord, whether a cause of action is disclosed or not.
Yes.
And one last paragraph from the plaint just to establish that cause of action, my lord, kindly takes note of, my lord, para 10 at page 21. So, para 8 and para 10, with this, my lord, this plaint cannot be rejected in limine, my lord, at the Order 7, Rule 11 stage. First sentence, my lord, so far as plaintiff is concerned. And cause of action to institute the suit and seek eviction is also pleaded here. My lord, I am praying for, my lord, dismissal of this application. The judgments which my learned friend rely upon, I don't know why he went 100 years back, my lord, to a Chancery Division judgment, but they're really not necessary, my lord. And it's not a, my lord, judgment in a proceeding under, my lord, Order 7, Rule 11 or a demurrer application. And so far as cause of action, my lord, which the Supreme Court has, my lord, discussed in 2005-10 SCC, my lord, cause of action from the plaint, if I can demonstrate that the cause of action is there, my lord, no question of, my lord, rejecting the plaint. Those are my humble submissions.
Yes, Lordship, in respect of my reply, I will seek one time to reply.
For what?
On the next date, because of his, he has stated that the suit is an act. Lordship, kindly note that today he has stated that the suit is an act. In that respect, I need one day. I will indicate as to how the suit cannot be an act. Lordship, this is 4:30. Anyway.
3 minutes.
Yes.
4:30 now. I will.
427, my lord, not 30 minutes.
So suffering for the plaintiff, so suffering for the defendant. The defendant has filed the present application being GA2 of 2024 in CS 135/2023, praying for rejection of plaint. Counsel for the respective part, counsel for the plaintiff as well as the defendant has concluded his argument, but the counsel for the defendant prays for time to give reply to the submission made by the counsel for the plaintiff. Accordingly, case adjourned. Let the matter appear on 17th January 2025 as parted.
My lord, insofar as the other application which he said he is going to withdraw,
yes,
that can be recorded, my lord.
That is GA1.
GA1
is that is in regard to the other suit.
That's GA5 in CS 203. The recall application.
GA5. GA5. You are withdrawing this?
Lordship, I am.
You are not pressing this?
I am not pressing because I do not want to.
Counsel for the CS 135 of 2023 GA no CS 203 of 2000 कौन सा
CS 203 of 2011 GA5 of
order दिया है that is CS 135 में दिया है.
Yes.
अभी no CS 203 of 2011 and GA5 of 2024. So it's counsel for the plaintiff and a counsel for the defendant has filed the present application being GA5 of 2024 in CS 203 of 2011 for recalling of the order dated 11th August 2023 passed in CS number 203 of 2011. So the counsel for the defendant submit that he will not press the application filed by the defendant being GA5 2024. Accordingly, GA5 2024 is dismissed as not.
Lordship, may this be also recorded as it has merged with the order of
Counsel for the counsel for the plaintiff submit that. Counsel for the defendant submit that. Abhi over the card deno line. Counsel for the defendant submit that after passing of the order dated 11th August 2023, the plaintiff had filed another application being GA2 of 2023. GA? GA4 of 2024.
Yes.
4 of 2024.
Looking at Justice Majumdar's order. Yes.
Praying for extension of time to file written statement, but by an order dated 22nd of August 2024, the coordinate bench of this court has dismissed the said application. Counsel for the defendant submitted being agreed with the said order dated 22nd August 2024, the defendant has prepared an appeal and same is pending for adjudication. This court find that before the order dated 22nd of August 2024, this court by an order dated 11th August 2023 has placed CS number 203 of 2011 in the list of undefended suit. Subsequently, the plaintiff has defendant has filed an application for extension of time to file written statement, and the same was also dismissed as mentioned above. Thus, this court is of the view the order dated 11th August 2023 is merged with the order dated 22nd of August 2024. Thus, full stop. Considering the above, the counsel for the defendant not pressed the present application being GA5 of 2024. Accordingly, GA5 of 2024 is dismissed as not pressed.
Lordship, 17th is a Friday. It is a commercial.
Oh, it has to be either a Wednesday or a Thursday.
17 बोला है ना 17 मत करो 22nd करो
22nd. Great.
I'm great.
ऊपर का 2 लाइन लिखा था ना क्या लिखा था वो ठीक है वो ठीक है हो रहेगा हाँ इसको काट डिसमिस का है ना तो करके फिर वो कंटिन्यू कर यस
Well, with the Lordship's kind permission, my lord. So this order dated 21st August, there is a mistake in the name of the deceased, my lord. I have annexed the copy of the cause title. It's not.
So why you are not mentioned in the morning? When the order was passed?
My lord, 21st August 24.
Yes.
My lord, it's Vijay Kumar. It should be Vijay Kumar. V, not V. Yes, my lord.
It is B or V?
It's V.
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 Huh? This is not passed by this court. This is not passed by this court, 21st of August 2024, by the other court.
Yes, my lord.
उनका तो भी क्या जुडिक्शन नहीं है
Testamentary matter.
डिटर्मिनेशन नहीं ठीक वो कर मेंशन में लेके आ
May I have your lordship's?
mentioning it will decide as to be tomorrow or day after tomorrow. You check the list.
May I have your lordship's kind leave?
Yes. What is another thing?
My lord, this another PLA, my lord. This order was passed on 16th August, my lord. The department is saying the file is still in the court. The file has not reached the department.
Which order?
My lord, again, not this court, but.
No, this is not passed by this court. You mentioned before the other court.
Okay. My lord, I mentioned the other one also before the other court. That's better.
May I have your lordship's kind leave to mention one matter? The interim order is expiring on the 10th of January 2025.
Tomorrow, you mentioned tomorrow. 10th is tomorrow.
10th is day
Day
after.
after tomorrow. You mentioned day after tomorrow.